cum laude at University of Natal and an LLM from Cambridge. Is that right?
Indeed, it is so.
Yes, and yet you were admitted as an attorney in 1988. Is that right?
Correct.
And you practiced for about 7 years or so. Then you were appointed as a judge at a very young age, namely at 35.
That's correct. I think I practiced for 10 years.
Oh, it was 10 years.
Yes.
Yes. And then you were appointed as a judge of the Land Claims Court at age 35.
That's correct.
That was quite young.
It was very young. I think it was only, Justice Strawberry, it might have been a year or so younger than me when he was appointed, but I was one of the youngest to be appointed at the time.
Yeah. Yes. And then your appointment was for a period of 5 years, which would go up to 2000, is that right?
Indeed.
And you served all that period of 5 years. And during that period, you wrote a number of judgments that got reported, is that correct?
Indeed. They're listed at the end of my curriculum vitae.
Yes. And you were one of the first Land Claims Court judges.
Indeed.
And therefore, that must mean that when you started with your colleagues, you were really starting on something new. The jurisprudence was not there. You had to start a new field of law.
Indeed, we started with a completely clean slate, and a set of statutes. Initially, the Restitution Act. Later, other statutes were added to our jurisdiction, and we had to develop the law from there. But obviously, guided by the Constitution, which was already in place. Initially, the interim Constitution, and then subsequently the final Constitution.
Just take 1 minute to share with the commissioners how that experience was of starting a new court and a new jurisprudence on land law in a democratic South Africa.
With pleasure, Acting Chief Justice. It was obviously a unique experience. There was a substantive dimension to it, and there was obviously a procedural dimension to it. The substantive component involved interpreting the legislation. As the Constitutional Court ruled, a judgment of Deputy Chief Justice Moseneke in the Goedgelegen judgment, the land reform legislation is umbilically linked to the Constitution. So in a sense, it was really constitutional adjudication that we were busy with from the outset, and we did have the guidance that was provided by the Constitution for purposes of that from a substantive point of view. There was limited foreign authority that could be referenced, but I had a background in both human rights and specifically in dealing with forced removals, and I think that gave me the framework within which to act substantively. It was a great honor and privilege to write judgments. From a procedural point of view, we had to start from scratch. We had to find a building, we had to draft rules, we had to establish a library, we had to establish an IT infrastructure.
Yes.
We received enormous help from the Constitutional Court, but I got stuck in with all of that stuff. We worked well as a team, and we eventually had a thriving court, which is still there today.
Thank you. And during that term of 5 years, you wrote quite a number of reported judgments. Is that correct?
That's correct.
Do you have an idea about how many? I know we've got them in the pack here, about how many reported judgments you ultimately wrote, more or less?
I didn't count them. My guess is about 25, but I might be wrong there.
And when you were appointed as a judge of the Land Claims Court, had you always planned to go back to practice after the period of 5 years?
It wasn't always my plan. I had to make a decision when I got to the end of my 5-year term as to what I would do. And it was only, I suppose, in the last year that I began to crystallize my thoughts. There was also the difficulty that we didn't know what was going to happen. We had to wait to see what the government had in plan for us.
Yes. And then after that period, you went back to practice, and then you didn't go back to practice as an attorney. You went to the bar. Is that right?
That's correct, Acting Chief Justice.
Yes. And you are still at the bar. You took silk about 10 years ago?
I think it was 2011. So yes, 10 years ago.
Yes. And you say that the cases that you dealt with were very much constitutional law based.
Well, perhaps I should mention, before I get to that, the period from 2000 until 2007, although I was at the bar, I think the major focus of my time was an appointment that I had to chair the Housing and Property Claims Commission, which was a body established by the United Nations in Kosovo to deal with the aftermath of the war, and in particular, property claims arising from the war. They took up a substantial part of my time for the first 7 years at the bar. But I did some bar work during that time as well, and yes, I went and looked back at my reported judgments while I was at the bar, and in fact, every single one of them, perhaps bar one, involved constitutional issues. The one that didn't is the case of Absa Bank and Lombard, which was a case about banking law. But in that case too, in the Supreme Court of Appeal, I argue that the common law should be developed in relation to when funds are stolen through an electronic transaction from a bank. So in a way that also involved the Constitution.
Yes, and many of the cases in which you have argued in the Constitutional Court, is that correct?
Yes, I have argued a number in the Constitutional Court.
And is constitutional law quite a large portion of your practice?
It's the bulk of my practice.
Yes. And you haven't acted in the Constitutional Court, is that correct?
I haven't acted in the Constitutional Court. There was a recommendation from the BLA in response to my first nomination in 2019, I think it was. They recommended that I be given an opportunity to act in the Constitutional Court, but it was never acted on.
Yes. In the cases that you have dealt with when you were a judge in the Land Claims Court, or when you have acted in the High Court, because you have acted in the High Court as well, have you dealt with cases where you have got to declare legislation unconstitutional and grant appropriate orders? I haven't
ever had a case where I have declared legislation to be unconstitutional, if I remember correctly. The closest I've come is to develop the common law in terms of Section 173 of the Constitution, and that was in the case of Picard versus Stan.
But you know what the approach is when you are required to declare a legislation unconstitutional. Is that correct?
Indeed, and obviously I've had a number of my cases as an advocate have involved declarations of invalidity.
Yes, and you have dealt with cases whether when you argued them or when you were sitting as an acting judge, where you had to deal with reading in and reading down.
Indeed.
Are you able to just share quickly with the commissioners what this distinction is between reading down and reading in?
Well, reading in would be the situation where, in order to correct legislation, to render it constitutional, you would have to read in certain words, and it would typically follow on a declaration of unconstitutionality in the legislation as it stood. And then reading down would be an interpretation, for example, based on the Hyundai judgment, where one aims to, through a process of interpretation, read the legislation as being constitutional in accordance with Hyundai.
Yes, no, thank you. Minister, do you have any questions?
Yes, DCJ, thank you. Advocate, firstly, is also to state that Advocate also help us with our Justice Reference Group on land matters. But anyway, I think that goes also with many advocates. They represent the state through the state that My first question relates to a matter you are involved in, the Mwelase matter, Advocate, of the creation or the innovation of the special master. Our lived experience is that it has straddled between the separation of powers, and that the special master reports to the court and has taken some of the powers of the accounting officer and that of the executive authority. So it has created a kind of a difficult also in terms of accountability as to how do they account to Parliament, the executive authority and the accounting authority with regards to the work of the special master, whether it will be the special master or it will be the accounting officer or the executive and all that. What will you be your view going forward to government? How must we handle this special situation? Because it's new to us, and I also think it's new to everyone involved in it, so that we still find a way of it working.
Thank you for that question. The Molasi case was the very first case where a special master was appointed, and I think it was inevitable that there were going to be some pathfinding problems. I haven't been substantially involved subsequent to the order of the Constitutional Court, so I don't have a deep knowledge of what the factual position has been subsequently. But I think it's important to bear in mind that it was a particularly dire case of non-compliance with legislation. Essentially, the department had shelved, the Department of Rural Development and Land Reform had shelved legislation, which is constitutionally extraordinary and a severe constitutional wrong. So it was extreme circumstances that required a measure like the Special Master. What's important, and I haven't restudied the order before this interview, but what was important is that the interview was based on, I would submit, a combination of collaboration, guidance, and supervision, with the Special Master required to play a coordinating role between the department on the one hand and the court on the other. At the end of the day, the Special Master is required to be the eye of the court, but because of the severe problems that have arisen, in a much closer way and in a much closer collaboration with the department. My sense is that as long as there is good faith on the part of both government and the Special Master, and if I know the individuals involved on both sides to the extent that I do, I think there is that good faith. And I think that provided there is a collaborative spirit with which they approach the matter, I think the Special Master can play a fantastic role. You know, one of the frustrations that one had on the Land Claims Court is that when problems arose in the land claims sphere, amongst other institutions like the Lands Claims Commission, the problem with the court is that you sit remotely. You don't have the opportunity to go and sit down with somebody and say, how can we solve this problem together? That's the beauty of the Special Master. The Special Master is really the agent of the court, and it's providing the department with an opportunity, instead of the court preaching to it from on high, to sit down with the representative of the court and say, how can we solve these problems together? How can we help each other? That's the spirit in which it would be done. It should be done. And my sense is that will be the guide. If there's a spirit from both sides that says, how can we help each other to deal with these 10,000 claims that have been left to stagnate for, it's now 20 years, I think it is, and more for people who lodged their claims before 2001. Let's work together and collaborate. I worry that there may be a sense of turf and a feeling that turf is being invaded. I think that's wrong. I think the way to make it work is to see it as an opportunity, to see it as having the court's agent sitting potentially in your office and solving a problem together.
Yeah, my second question relates to what the Land Claims Court has entrenched in terms of the interpretation of Section 25 on restitution matters or land reform matters to mean that any compensation should be market related, which is not what Section 25(3) of the Constitution expects in terms of what should be just and equitable. Why at the initial stages of the Land Claims Court you entrenched these principles of calculating the market price on the basis of the 1975 expropriation bill instead of what the Constitution expected the court to do?
If I can...
before you answer, Mr. Johnson, may I just mention I will try to make sure that you get a fair opportunity to respond, but may I ask you to try and not make the answers too long? So if you can exercise restraint, but at the same time, I don't want you not to feel that you have had a chance to respond properly. So go ahead.
By all means. If I can start with the correction. The Land Claims Court judgments don't apply at market value, and as the basis for compensation in isolation. They apply it as the Constitution requires them to do, and they follow the Detroit judgment of the Constitutional Court. So if you look at the judgment of myself and Judge Meer in Kumalo versus Potgieter, we firstly determined the market value of the land, and then we looked at the other factors in Section 25.3, and we reduced the market value of the land. Again, Acting Judge Ngukai Tobi followed exactly the same approach and determined market value, then proceeded to adjust market value. He also made the point, and the judgment in Kumalo versus Potgieter was no different, that the starting point is what is just and equitable. But what Detroit from the Constitutional Court says is you start with market value because that's ascertainable and you adjust from there. What I have some difficulty with is the Supreme Court of Appeals decision which overturned Ngukai Tobi's decision in the Msiza case. I think that is the one that fits, that judgment is the one that fits a bit closer to what you're talking about. If you look at Kumalo versus Potgieter, the landowner did not get market value. I can't remember the exact figure, but they got several $100,000 less than market value. One is forced to apply the Expropriation Act to some extent because it's sitting there in the statute book. We can't ignore that. But we applied Section 25.3 over the head of the Expropriation Act. We wouldn't have made that downward adjustment in Kumalo versus Potgieter if it wasn't for the fact that we were applying Section 25.3 with respect correctly. The reference is in my curriculum vitae for the Kumalo versus Potgieter judgment.
Thank you. Thank you, Mr. Dodson. Anyone who wishes to ask questions? Commissioner Mapisa Ngula.
Thank you very much, DCJ, and thank you very much, Advocate Dodson, for availing yourself. The question I have, it sounds very trivial. It's a very trivial matter, but very profound as well, and commendable to me that when I looked at your CV, that your previous conviction is that you refused, and it's a military criminal record, that you refused to patrol with the army in the townships. However, much as I would want to commend you for that, because I think you took a very good decision, I would want to understand, is it something that you want to keep? You don't want, why have you not applied for a nullification of this record so that it doesn't keep on popping up in your CV? That's the number one question.
I'm battling a little bit, Commissioner, to hear you.
Well, I was actually going to ask everybody because when Commissioner Nujesi was speaking earlier on, I couldn't hear him so well. And so I don't know whether you need to come closer to the mic or something else.
Thank you.
So maybe speak closer to the mic.
The issue is, I see that I read from your CV that one of the things you did is something which is very commendable, which is that you refused. You have a military record for refusing to patrol in the townships. However, my question is to you, is this something you want to keep? Why have you not applied for a nullification of this criminal record? That's the first question. And the second question I have is...
Maybe let him answer that first one.
Okay.
Mr. Dawson.
I don't see it as it's something I don't want to hide away. It's something I'm proud of, frankly, that I acted in accordance with my conscience, and it hasn't interfered with my professional life in any way. So from that point of view, I haven't felt a need to seek a nullification. I don't even know if there's a procedure to seek a nullification, but I'm proud of what I did.
Thank you very much, Advocate. The second one is having, but of course I think you responded to that from the issues which were raised by the DCJ earlier on, that your focus has been on land restitution. And therefore, how would you describe your abilities to decide on matters which will arise, which relate to litigation issues at the Constitutional Court?
as I understand your question, it's I come from a specialized background. How do I deal with other matters? To respond to that, let me start by saying I'm similarly proud of the fact that virtually my entire professional career has been aimed at dealing with the problem that black people were forced off their land in South Africa. And I make no apologies for the fact that that's been the focus of my professional life. But I have been widely involved beyond that. In the Land Claims Court, we inevitably, and the Acting Chief Justice I think will bear me out with this given his experience in the Labour Court and the Labour Appeal Court, specialists, of course, sit within the matrix of the broader legal system. Every single case just about brings out other issues from other components of the legal system. I in fact made a list which I can make available if need be. I don't want to waste time by going through it, but of both non-constitutional, non-land reform issues that came up in my reported judgments, and there are several. I took a sample, and then I also took a sample from my time as an acting judge, because I've acted in the Labour Court, I've acted in the High Court, I've gone back and acted again in the Land Claims Court. But you will see from my curriculum vitae that through my acting in the High Court, I've dealt with a range of issues that have absolutely nothing to do with land reform, and that venture into a whole lot of other areas, both of constitutional law and of non-constitutional law. And I have several reported judgments referred to at the end of my curriculum vitae in the High Court that have nothing to do with land reform. I'm not sure if that answers. I also have a list separately that I can provide of all of the non-land reform constitutional issues that I've had to deal with, both in the Land Claims Court as well as in the High Court in acting. And then as an advocate, I have a wide, focus on constitutional law, but I've been involved in a wide range of issues, environmental, I've done a lot of customary law work, and so on.
Thank you. Yes, Commissioner.
Thank you.
Oh, Nyami, yes.
Yeah. Thank you,
Thank you.
Acting DCJ. Morning. What motivated you to accept the nomination as a candidate to the position of a judge in the Constitutional Court?
I have gone through a very unusual route in my career. Normally people go attorney, advocate, judge, and that's it. I've gone an unusual route. I know of no other lawyer who's gone that route, and it's taken me in diverse places. I went from attorney, human rights attorney, to being a land claims court judge, to working in the UN, to being a practicing advocate. And my sense is, firstly, Section 174(5) of the Constitution makes it clear that only 4 of the judges need to be judges at the time that they're appointed. So there's a door that has opened to me in the Constitution, people in my position, if there were anyone, and I felt that the experience that I'd had could be of assistance in enriching the adjudication of the Constitutional Court. Both my non-land work, as well as particularly my land work. I think it's going to be a big issue in the years to come.
Thanks. My second question, as a senior counsel, attorney, acting judge, a judge, we have seen it all. What's your view about the current state of the transformation of the judiciary?
My sense as a lawyer, I'm proud of what's been achieved in the transformation of the judiciary in particular. I'm exposed to it because I'm married to a judge in the High Court, and I appear in the High Courts. And my sense is that if I think back on the days of the 1980s, when I was knocking at the doors of the High Court to try and get somebody out of detention, when I was knocking at the doors of the Supreme Court of Appeal after I'd failed in the High Court, and I was faced in the Supreme Court of Appeal with a phalanx of white male judges shaking their heads when we tried to submit that detainees should have been released, or the damages should be paid because of what the police did brutally to somebody. And I see a phalanx of white male men. It was a very depressing experience. If I contrast that experience with what happens now, if I stand up in the middle of the beautiful court and the Constitutional Court, and I see all of the justices sitting in front of me, it's profound. The change, let's be frank, is profound. So my view is a positive one. I think that there has been incredible work done in the transformation of the judiciary. There are some excellent leaders in the courts who lead the courts from the top down. I obviously, because I'm in Gauteng, I have the direct experience of Judge President Mlambo leading the High Court there, who does a fantastic job. So I think that it's been a fantastic achievement.
Thanks,
Thank you.
DCJ.
Thank you. It's going to be Commissioner Club. I think he had his hand. Did you have your hand? Oh, no, I saw you, but I thought he was before. Then it will be.
No,
you are fine. You are covered. Okay. It will be Commissioner Dodovu, then Justice Spetze, and then Commissioner Malema. Oh.
Thank you very much.
Yes. Okay. All right. Thank you.
DCJ, just my two questions. You acknowledge, firstly, that you are strong on the areas of constitutional law, administrative law, and labor law, and that you have not done criminal law, especially when practicing as a counsel. How will you compensate that as if you are considered to be a judge of the Concord?
I think a lot of people come to the bench in the position that I'm in, where they haven't immediately had a practice in criminal law. But the truth of the matter is that in the early 80s, I did almost exclusively criminal law. That was during the time of the uprisings in the townships, protest uprisings in the townships, and I spent my days doing criminal work representing people, mostly young people charged with public violence, also some more serious crimes. Our firm was the firm that was appointed in the Yengeni trial. So my early years have steeped me in criminal law. I've run my own criminal cases as an attorney, and it's a bit like riding a bicycle. I don't think that you forget that stuff, even though I've had a long period away from it.
Okay, my second question
I will answer it.
relates to Section 27 of the Constitution. I can see that you are very strong in that area around healthcare issues. What do you think the current pandemic, COVID-19, what challenges do you think it will impose to our health system, especially in terms of adjudicating issues of vaccination? A lot of people say no, but we all know that is very risky. What is your view on that?
So there's more than one component to your question. I'll try and answer it quickly. It's been a completely novel experience for the courts. I think the courts have responded well. I think in many respects government has responded well, even though they've been subject to so much criticism. It's such a new thing and so difficult. I think that what is needed for the future is a dedicated statute for pandemics. I don't think the pandemic fitted comfortably under any legislation, whether it would have been a state of emergency or even the Disaster Management Act. We need dedicated legislation to provide for it in future. We need legislation that would enable centralized control during a pandemic of both public and private healthcare from a national level to respond. I think the legislation should provide for a dedicated fund that gets built up and that is kept in reserve and grows, so that the economic impact can be dealt with in future if ever we have a similar experience over and over again. To come to the specific issue of vaccine mandates that you referred to, I need to be careful about answering that. I think that issue is going to become before the courts, but I can speak very briefly about the issues that it raises. It raises issues in relation to Section 12.2, the right to bodily integrity. It raises issues in relation to Section 9.3, as well as PEPUDA and the Employment Equity Act in relation to potential discrimination on the grounds of thought, belief, and opinion. It raises the issue of possible limitations of Section 15, the freedom of thought, religion, belief, conscience, and opinion. And if vaccine mandates are going to be debated, one then has to see, are the limitations of those rights justifiable with reference to Section 36 of the Constitution? There are laws of general application. There's the Mine Health and Safety Act. There's the Occupational Health and Safety Act. Those present real challenges for employers because employers have to provide a safe working environment to employees under those statutes. How do they do it if some people are saying, I'm not going to get vaccinated? The science says vaccinations work, they help. So how does an employer respond? I don't want to express a final view on the issue, but I would be ready for the debate were it to come to court. I know what the issues are, and I know what would influence the final outcome.
Thank you very much. Thank you, DCJ.
Thank you. Justice Betze.
Thank you, Acting Chief Justice.
Before you continue, I'm sorry, let me just announce so that we are all aware. I think we are 10 minutes away from reaching 40 minutes. So I mentioned that so that we are just all aware, but continue.
Thank you, Acting Chief Justice. Good morning, Mr. Dodson. I've got two questions for you. One of, or some of the critical attributes of a good judge, especially one who's aspiring to serve on the Constitutional Court, are experience, scholarship, dignity, rationality, forensic skills, humility, a capacity for articulation, diligence, integrity, intolerance for injustice, emotional maturity, courage, objectivity, energy, both physical and emotional, efficiency, wisdom, and the moral ability to distinguish the right from wrong. Do you think that you possess those attributes to a sufficient degree that would make you a good judge?
The short answer is yes, I do, but the moment one says it, one feels as though one is bragging. But I think in sufficient quantities. I'm a human being, and human beings are fallible, but I think that I have those qualities in sufficient quantity to be able to do the job.
Thank you. My second and last question is, of the 7 candidates that will be interviewed by this commission, you are the only one who's not a sitting judge. Wise mindful that that does not in itself disqualify you. What would you say would be compelling factors which, in your view, should tip the scales in your favor?
I think the beauty of Section 174.5 is that it allows this body to look at candidates who've gone a road less traveled, a different route through the profession. And I think that the route that I've followed is one which can really enrich the adjudication of the Constitutional Court. Yes, it involves work at the bar, but I believe that work at the bar is an incredibly important and helpful component of the skill set and experience set that one brings to the court. When I left the land, if I'd stayed at the Land Claims Court and simply gone through the tiers of the courts, bearing in mind how young I was when I started, I would not be as comfortable as of the fact that I'm a good lawyer as I am having gone the route that I've traveled. But I've traveled that route without dropping adjudication. For 7 years after I left the Land Claims Court, I headed up an adjudicative body, an international adjudicative body, with people of the level of Supreme Court judge in former Yugoslavia, a top international arbitrator. I was responsible both for adjudication in that body, as well as, because I was the chairperson, effectively running the commission. from the adjudicative side, managing it, getting a group of lawyers from all over the world to work together as a team and achieve a goal. I've also continued to be involved in the work that is appropriate for adjudication, in the work that I've done over the years on the Independent Regulatory Board for Auditors Disciplinary Committee. I've attached one of the decisions to my documentation. It can be read. It dealt with a constitutional issue. I've also referred in my curriculum vitae to a 472-page decision that I handed down exactly a year ago on the 5th of October last year. In that body, it dealt with a really complex area of the law and of auditing. It involved a bank audit, a charge against bank auditors, canvassed a range of legal issues, a range of accounting issues, a range of commercial issues, a range of regulatory issues. And as I say, that was the 5th of October. It was a year ago. So yes, whilst I've gone to the bar, I've remained involved in adjudication because of the fact, it was because of the fact that I was a judge that I was made chair of this disciplinary committee, but also because I was a judge, I do an enormous amount of opinion work. And the rational process one goes through in writing an opinion as an advocate
Chief Justice.
Thank you, Commissioner Malema.
Thank you, DCJ. Advocate, how long should the Constitutional Court take to adjudicate on an agent matter?
The Constitutional Court faces a difficulty in that they make their decisions en banc. All 11 judges have to come to a particular decision, and the decision has to be changed. Then it becomes difficult. So it's very difficult to answer. But there are circumstances that the courts also need for lawyers. Sometimes if you can't get judgment out quickly enough, it can become irrelevant or it can become unhelpful. So it depends on the circumstances, it depends on the stance of the judges, but obviously they must look at the facts and they must attempt to respond and provide a judgment that assists the parties and provides a resolution to their dispute as quickly as possible.
You are applying to be a judge of the Constitutional Court, and I ask you a simple question, and then you say something too long. I don't even understand what you are saying. Because this question is the one that is going to guide your conscience when matters appear before you and your colleagues, that we agree that this is an agent matter. And that should, in guiding your conscience, then be able to say, within a particular period of time, we should be able to have resolved this matter if things are normal, to say. So, I just want to have an idea, because I'm not a lawyer. And I'm sitting there at home and I see something called an agent matter, and it takes forever to be resolved. All I'm asking is, what will be an ideal situation where a competent constitutional court takes to resolve an agent matter?
All I can do is judge by my own experience at sitting in the Urgent Court in Johannesburg. When I sit in the Urgent Court in Johannesburg, I try and give a judgment there and then. For following my own guideline, if I was in the Constitutional Court. But there are difficulties. That's the best answer that I can give.
Is there anything that needs to be changed to the Constitutional Court?
The one thing that worries me a bit at the moment is turnaround time with processing of cases. I can think of at least one case that I've got that's been waiting for a long, long time to get an answer. We filed heads in the case. We were asked to file heads a long time ago. We filed heads. We just don't know what's happened in the case. But that's not a universal experience. Mostly my experience has been good. But I think that case is indicative of a problem. But I think it's difficult for the court. They sit on bunk. I think they have a massive load of applications for leave to appeal. I think that's a problem that needs to be addressed, but I don't think it's the fault of anybody. I think systems need to be developed to process those. We had to do the same when I was chairing the commission in Kosovo. We had 30,000 claims. We had to decide them in a short space of time. We had to work out methodologies to process them as quickly as we could.
With your indulgence, DCJ, you can't say it's not a fault of anyone, because someone must take responsibility. We can't have a situation in this country under this constitution where things are not happening and we say we can't put a fault or a blame on anyone. In a situation where the Constitutional Court, in a case that you are telling us about now as an example, where there is no clarity of what is really happening, who takes responsibility for that at the Constitutional Court level?
Mr. Nalima, I don't want to get involved in a blame game. And I'm a person who's I've never acted on that court. I don't know what the circumstances are that obtained that.
The Constitution for, let's say, in the last 3 to 5 years. Thank you.
I spent 5 years as a judge on the Land Claims Court, involved in a wide range of adjudication, and that puts it in a very different light. I was a permanent judge for those 5 years. I wasn't an acting judge. And that's the primary basis for my judicial experience, along with the 7 years that I spent in Kosovo, heading up a commission adjudicating. That too was a permanent appointment. And one can't look simply at the fact that I've done 20 weeks of acting and ignore the fact that I've spent 7 years in the position in Kosovo. I spent 5 years on the Land Claims Court. It comes to 12 years altogether. The research I did do was to look at the amount of time that the current judges on the Constitutional Court spent as judges, permanent judges, before getting appointed to the Constitutional Court. And I think the average I got to was about 12.5 or 13, somewhere around there. I've got a similar period involved directly in in adjudication on a consistent basis, taking into account the Land Claims Court and the 7 years I spent on that commission. So they're very much comparable. Yes, I've only acted for 20 weeks. It's not too bad. It's given me a wide range of experience, and in a short period of time that I've acted on the High Court, I've several reported judgments. And the short answer is no, I haven't done the research that you referred to in your second question.
Thank you.
Thank you.
Sorry, Acting Chief Justice, if I can just perhaps mention one more thing.
Sorry?
If I can just mention one more thing, if you don't mind,
Yes,
in
yes.
response to the last question.
Yeah.
Just to point out that nowhere in the Constitution is the requirement that one has acted as a judge before one is appointed to the Constitutional Court.
Thank you. There was also, I think there was another commissioner who wanted to ask questions from those who are virtual. Oh, Commissioner Breitenbach.
Thank you, Acting Chief Justice, and good morning to everybody. Good morning, Mr. Dodson. You have had a role as the chair of the IRBA's disciplinary committee for some time, and that gave you obviously the opportunity to deal with complex commercial matters. Do you believe that this experience would be beneficial to the Constitutional Court bench going forward, especially in view of the sort of near future?
Yes, I certainly believe it would be of assistance, and that's part of the reason why I say I come a different route, and I think that experience will potentially be invaluable on the Constitutional Court. There are going to be issues that come before the courts as there are big company failures and so on in the future. Those issues are going to reach the Constitutional Court because of Section 167(3)B's broadened jurisdiction.
Thank you, Acting Chief Justice. I'm done.
Thank you. Commissioner Nokesi, before you ask, I just want to say, in the light of time, if there are any colleagues who want to voluntarily say they are covered, that would be great. Or those who want to say, I'll ask one question instead of two,
Yeah.
that would be great. Okay.
No,
You'll ask one. You'll ask one. Thank you.
In fact, I will,
Commissioner Nokesi.
in fact, I'm also doing exactly that
Okay,
because
thank you.
Commissioner Singh has
Thank you.
helped me. But there's one thing that troubles me. You say, admittedly, you never acted in the Constitutional Court. But when Commissioner Malema asked you about urgent applications and judgments, you give a detailed explanation, the difficulties that the judges of the Constitutional Court face before they take a chance. Where do you get that? That's my only trouble with your answers.
One picks up information about how adjudication takes place, but one can simply infer it from the judgments. Look at one of the judgments where there are 3 different sets of opinion, and you can see where the difficulties lie. It's a matter of logical inference.
Thank you, Commissioner Nokesi. Then Commissioner Mtolo Lepu.
Thank you, Acting Chief Justice. Good morning, Advocate Dobson.
Good morning, Commissioner.
I heard you earlier saying, and I think it was in response to Commissioner Dodovo's question regarding the transformation of...
Maybe you might raise your voice, speak up a bit here, or bring your mic closer.
I'm saying, I heard you earlier saying that the change in the Constitutional Court is profound, and this transformation in the Constitutional Court. I'm quite worried in the sense that you seem to see transformation as those judges who are sitting there, not people who are representing the claimants or the applicants in the Constitutional Court. Do you still believe that there is change? Because for me, the judiciary includes people who are representing people in the Constitutional Court.
I understood the earlier question to relate purely to the judges, to the judiciary, not to the profession. The profession's a different kettle of fish. The profession's got a long way to go to be properly transformed. That I acknowledge immediately and without hesitation, and I agree with you. There's an enormous amount that has to be done.
Just a follow-up, what do you think the profession should be doing to enable people to be represented by other races in the Constitutional Court?
The difficulties are many. There is a problem in relation to briefing patterns. There's a problem in relation to disadvantage from the earliest times in relation to the different circumstances in which poor people have to study compared to privileged or wealthy people or people's children who have to study. There are problems in terms of accessing the profession through they are predominantly people. In fact, usually, if I think of the groups that come before us, there are usually groups of about 8 pupils. Invariably, I think only one is usually a white person. The rest are historically disadvantaged individuals. I think those programs are those advocacy training programs are of great assistance. I see, as the years go by, I see fantastic talent on display in those training programs. So I think people will come through, but people have to work hard. The bar has to work hard. The attorney's profession has to work hard to create opportunities for people. We run a junior fund in the Victorian Kleinge Group. The bar also runs a junior fund where we put money into a pot every month so that if one of our young members is struggling, we can bring them into a matter even though the attorney hasn't briefed them. And then there's a huge obligation on us as senior practitioners to bring in people who come from disadvantaged backgrounds. And I think that it's taking time, but I think it is starting to show some benefits. It's not nearly fast enough. I think you in your position are well positioned to push us in your position on the Legal Practice Council, to push us harder, make sure that we do more, make sure that when people are standing up in the Constitutional Court, we see a better picture from that way, from the judges looking down.
You are covered. Thank you. And then Commissioner Chepe.
Thank you, CJ. As I said, I will ask one question because the other question was asked by Commissioner Malema. Thank you. Good morning, Advocate Dodson. Could I just ask you if you could just give examples of some of the judgments, particularly in recent times, where you would have dealt with matters in relation to Section 39(3) of the Constitution, which requires that when courts are interpreting any legislation, and they must. And when developing common law and customary law, they must promote the spirit, purport, and object of the Bill of Rights. Do you have any cases that you have, and if so, if you could just deal with one or two of those? Thanks.
Okay, 39(2), I think you meant. Yes. The cases that immediately come to mind are. The airport company case, which I've attached to my documentation. And there I applied it in the context of when do you read a tacit term into a contract. And what I said is that the parties, in thinking about whether a lease would be extended during a tender process at the end of the lease, would contemplate that a lawful process would follow in order to choose a replacement tenderer for in that case it was for rented space in the airport. The other example that comes to mind is in relation to the Kransport judgment. In relation to the Kransport judgment, I had to deal with a difficult situation where the community had to prove that they had a right in land, but it was under apartheid where the legislation did everything to deny people having rights in land. And so what I did is I adopted that particular provision to arrive at a situation where I interpreted quasi-possession in their form of occupation of the land on a mission station as being a sufficient basis to qualify under Section 1 of the Restitution Act in interpreting that particular provision as a right in land that entitled them ultimately to have the land restored to them in full ownership.
Thank you, CJ. Thank you, Advocate Dotson.
Thank you. And then it will be Commissioner Madonsela.
Thank you, Acting Chief Justice, and good morning, Advocate Dotson.
Good morning, Commissioner/Advocate Madonsela SC.
Thank you. I've generally been covered by Deputy President Tsepe and Mr. Dodovu, Commissioner Dodovu. But I will ask just one question, just on that topic, on the topics that they raised. Are you really averse to making yourself available for the High Court position as a judge?
The difficulty for me with a High Court position is that essentially it takes me back to the position I was in 1995. The Land Claims Court is a court of equal status to the High Court, and it essentially means I've got to start again where I left off some 26 years ago. And, you know, I've got a limited span of my working life left. I need to choose carefully what I do with the years that are still allotted to me, and the short answer is I don't see that as part of my plan for the period that's allotted, the remaining period of my working life that's allotted to me.
Using the language of jurisdiction, which we use as advocates, I've always thought that you go to the ways to go to the Constitutional Court is via confirmatory jurisdiction of the court or appellate jurisdiction of the court. It seems to me that you want to go by direct access. I thought that we required exceptional circumstances for direct access in the Constitutional Court.
Well, Mr. Madonsela, in response to that, you and I are lawyers and senior counsel. Let's have a look at Section 174.5. Section 174.5 specifically envisages people who have had no judicial experience at all going directly to the Constitutional Court. And that is a live provision of the Constitution. It hasn't fossilized. There's a well-established principle that is repeated over and over again in the judgments. The Constitution is a living document, and meaning must be given to every single one of its provisions. 174.5 is one of those provisions, and this Commission cannot pretend that that section doesn't exist. Parliament conducted a thorough review of Chapter 8 of the Constitution when they expanded the jurisdiction of the Constitutional Court. If you look at those provisions, let's have a quick look at them. They amended virtually every single surrounding provision around 174. So 167, 168, 169, 170, 171. I think all of those were amended. So
I'm very much aware of
No, but I'm trying to make a point. The point I'm trying to make is this. If Parliament wanted to get rid of Section 174.5 and to say you can't come to the Constitutional Court without having followed a route through the judiciary, they had the full opportunity to change it. When they did that review, Parliament chose not to change it, and with respect, the Commission has to acknowledge that. They have to give meaning to 174.5. And it allows somebody with my track record to come to the Constitutional Court. And this Commission can't turn around and adopt a different interpretation that's not permissible in the Constitution. It can't overrule the Constitution. Every provision must be given a meaning and must be respected. It's on the statute book. It opens the door for me. The Commission can't close the door to me. The Commission can't grudgingly hold the door a tiny bit open to me. The Commission must hold the door fully open to me because the Constitution tells it to do so with respect.
Yeah, well, I don't want a debate about it. Can I just put to you just one question? You mentioned in response to Commissioner Tsepe the judgment in AXA versus the exclusive books. Your interpretation and the importation of the tacit term went on appeal in the SCA. My recollection is that the SCA did not affirm your importation of the tacit term, but decided the case in your favor on different topic and expressly disavowed the endorsement of the tacit term that you sought to impose in the AXA judgment. Is that correct?
No, I don't think the last bit is correct. They did decide it on a different basis, and as I read it, they didn't need to go into the other issue. I don't think they disavowed it.
Thank you.
Thank you. The next one will be Commissioner Mpofu, and after that it will be Commissioner Lucas, and I propose that we stop there. But before I allow Commissioner Mpofu, may I clarify this, Mr. Dodson? The answer that you have just given to Commissioner Madonsela, is my understanding correct that what you are saying is that the experience that you have acquired during the period when you were not a judge needs to be taken into account. If somebody else has been a judge during that time and has been gaining judicial experience, all of these must be taken into account and weighed, and then a decision can be taken as to how much weight should be attached to the judicial experience over that period, and how much weight should be attached to the non-judicial experience, but nevertheless relevant experience. Is that what you are saying?
I wish I could have said it as well and as briefly as you, Acting Chief Justice.
Okay, right. Commissioner Mpofu.
Thank you. Good morning, Alan.
Good morning, how are you?
I'm well, thanks. Yeah. Right. Well, I was going to ask you one question, but I'm tempted to ask you 1.5 because I also, with Commissioner Tsepe, double up as the communications person for the Commission. And there is this notion out there that the criteria are not clear. And I would say maybe they're not clear enough, but I think sometimes it gets exaggerated. So I want to take the opportunity, because you have cited Section 174.5, that the people out there might not know what it says. It says, at all times, at least 4 members of the Constitutional Court must be persons who were judges at the time they were appointed to the Constitutional Court. That's the one, yes. Now, I just want to assure you that we are fully aware of that section. If we were not, you would not have been shortlisted. So we're very aware of that. But the issue is, for me, the question I wanted to ask you really relates more to Section 174.2, which says that the need for the judiciary to reflect broadly the racial and gender composition of South Africa must be considered when judicial officers are appointed. And just to assure you again, I'm the first one to say that that section is limited. I've even proposed a constitutional amendment to expand it. But the issue really is this. You have 3 ostensible disadvantages as you sit there, and I say ostensible advisedly. The first one is you have addressed, so we won't go into it. That is the fact that you have not acted in the Constitutional Court. You've addressed that. The second one was asked by Deputy President Petse regarding the fact that you are not a sitting judge, or I think it was Commissioner Nyambi. You've addressed that, and that goes to the 174.5. But the third ostensible disadvantage, and I say ostensible because these are not disqualifiers, but they are, is the fact that you are a white male, and nobody seems to be talking about that. That's the elephant in the room. So, in the same light as Deputy President Petse, when we do our deliberations, what must we, how are you going to convince us to overcome that issue? I just want to give you that opportunity briefly.
I appreciate that, and I'm glad that you raised it. There's not much I can do about the fact that I'm white, and there's not much that I can do about the fact that I'm male. and I don't want to sound soppy, but to use words which are not mine, I am an African. I've lived in 3 different countries in Africa, but South Africa is my home. Every cell and fiber of my body is made from the African soil. I haven't relied on my whiteness to take advantage. From the moment I stepped into a law firm as an article clerk, I was out defending people who were being hammered by the police. I got into a bit of trouble in my first couple of months at the law firm because I wasn't earning any money. I was just going off and representing people. I wasn't charging anybody a fee. And one of the partners called me in and said, look, we like the work that you're doing, but at the end of the day, we've got to pay your salary and you need to earn some money. I'm taking you to the dependents conference to go and talk about how you can actually at least charge a small fee for the work that you're doing. I was in a commercial firm. I could easily have followed a path in a commercial firm that was rewarding financially and pretended that the problems in South Africa didn't exist. But I didn't use my whiteness to do that. Before then at university, I fought it. So to the extent that I have a white skin, I haven't taken advantage of it. And I've done the best to use the privileges that still come with it. I don't deny that there haven't been privileges that have attached to my white skin. But I've tried to use the resources and the privileges that I've had educationally and so on for the betterment of the country and to represent the disadvantaged in South Africa.
Thank you, Mr. Chair.
Thank you, Commissioner Bofu. Commissioner Lucas.
Thank you very much, Deputy Chief Justice. Good morning, Advocate Dodson. I was hoping that someone will ask the question that they know I will ask, exactly because of the kind of...
You might wish to raise your voice a bit or bring the
Do
mic
I speak
closer.
like a tokolosh? No, I was really sincerely hoping that someone will ask you this question because of what I actually purport to represent. I will usually ask this question, and the issue is that in our consultation with women, we find that there is no just dispensation, particularly with regards to land ownership. As someone with your background and someone that is actually aspiring to become a constitutional court justice, what will you say need to be done to make sure that we see the just dispensation that we are speaking about? And that will be my only question. Thank you.
Thank you. Thank you, Commissioner.
So, as I understand your question, it relates to the oppression that women face in relation to particularly the land.
Particularly land ownership.
Land ownership. And what will I do about that?
What will you see as a just dispensation, generally?
Well, maybe let me assist. If I understood the question correctly, she is asking what you think should be done to make sure there is justice for women in regard to land ownership. Did I get it right?
And particularly in front of the courts.
Or particularly in front of the courts?
So I have sympathy for your position because obviously in my work as doing land-related work, I've seen the difficult position that are faced by women, even though they are, in fact, in the rural areas, women are the majority by a significant number. I think a lot of the difficulty comes perhaps from the patriarchal component of customary law and the way that land is administered in rural areas. I think it is a tragedy that after the Communal Land Rights Act was declared to be unconstitutional in the Constitutional Court, it's a case that I was involved in, that we haven't yet, after all of these years, I think it's about 15 years now, got a replacement act. And it's through a replacement act for the Communal Land Rights Act that I see as the best opportunity for trying to improve the position of women in relation to land ownership. Part of the problem is also that there is no legislation, still to this day, that properly addresses the question of land redistribution. There's legislation to deal with security of tenure, there's legislation to deal with restitution, but not to deal with redistribution. And if one looks at the role that women play in rural areas, particularly in relation to farming, it's massive. Women shouldn't just be equal in land areas, they should probably predominate in land areas, in rural areas, in relation to land ownership. And so I see a crying need for a dedicated law dealing with land redistribution. And when they set criteria, because what that law is going to have to do, it's going to have to assess what the position is with land in South Africa. It's going to have to assess what the demand is for land in South Africa. It's going to have a ranking process for the allocation of redistributed land to people. And it's there that I think the position of women should be addressed. I think there should be a point system when it comes to the allocation of land for redistribution. And I think that point system has to be weighted in favor of women. They're the ones who've actually done probably most of the farming in the rural areas. They're the ones who probably come with the best chance of using the land well if it's redistributed to them. And I think that it's in that allocation process and that point system that you can address the problem that women have faced. To some extent, the problem has also been dealt with by the judgment that I was involved in, involving the person who seeks to be recognized as the Queen of Venda. We got the court to declare that, to recognize that the rule of male primogeniture in relation to succession to customary law positions is unconstitutional. And I think that is going to take time, but I think that's also going to have a massive impact and will come down to issues of land ownership because it's the traditional leaders who administer and adjudicate disputes in relation to land. I hope that answers your question.
Thank you, Advocate.
And I'm sorry it was long,
Thank you, Commissioner. I think that we are done with Mr. Dodson. Thank you very much, Mr. Dodson. We appreciate that you made yourself available. Thank you very much. You are released.
Thank you, Acting Chief Justice.
Thank you.
Thank you, Commissioners.
Thank you.
Thank you.
Commissioners, I'm going to disappear for just 2 minutes, but I'll be back. Good morning, Judge Catherine Setlwane.
Chief Justice Sondo.
We are just waiting for all commissioners to be back. Is everybody back? Oh, okay. Okay. Okay, once again, good morning, Judge Catherine Setlwane. Welcome.
Very much.
Welcome, and thank you for availing yourself for this session of the interview. As you know, this session happens because there is an order of court that said the commission must do these interviews afresh. So thank you for availing yourself. I see that you hold 3 degrees, BA, and then LLB and LLM, is that correct?
Yes, that's correct.
And one you got in 1988, another one in 1991, and then 1993. And you got admitted as an advocate after you had served some time as a law clerk at the Constitutional Court, is that right?
Yes, that's correct.
Yes. How many years did you practice as an advocate?
I initially practiced for about 8 or 9 years, and then I had gone across to Worksman's to work as an in-house counsel, so I practiced there as an in-house counsel, and then I returned to the bar after that. So there must have been about 12 years in total, 12, 13 years.
Yes. And during that period, it appears from your CV that you did a lot of cases as an advocate that got reported in the law reports.
Indeed, Chief Justice.
Yes. Please describe to us the nature of your practice at that time.
Yes, it was, when I started off, it was a public interest practice. I initially started off, while I was doing pupillage, I was also employed by the Legal Resources Center. In those years, the bar gave me a special dispensation to both serve, to both work at the LRC and serve pupillage at the bar at the same time, because the LRC was through my year of pupillage. So it really, made things very comfortable and easy for me when the LRC, at that point, the Constitutional Litigation Unit, decided to take me on as an employee and to allow me to also do pupillage at the same time. And I think a few other judges may have also had that opportunity in the past. I know Judge Nafsa was one. I know but Advocate Patrick Umshalano was another one after me who also served his pupillage and worked at the LRC at the same time. So it was, I had also previously worked at the LRC immediately after university for about 2 years. In those days, it was a fellowship program and not articles. So,
how much of your practice consisted of constitutional law matters, more or less?
I'd say a fair amount. When I say I was a public interest lawyer, I also did a lot of constitutional law, with the public interest angle. So I did a lot of constitutional law, both as an advocate and at the LRC before I was an advocate. Constitutional law lies at the heart of everything. So it infuses all aspects of the law. And I mean, I think my passion for constitutional law was actually, my passion was actually developed from the years that I spent at the LRC. Well, that was pre our constitutional era, but we were very bogged down in administrative law and administrative review and labor law at the time. But a large aspect of my practice was constitutional law at the bar. Yes.
Yes, and you were appointed as a judge in 2010.
In 2010, October 2010, and I acted from, I think, January 2010 for a full year before that.
Yes, and that means that you have about 10.5 years of judicial experience, is that right?
Yes, I think I'll start my 11th year.
Sorry?
I will start my 11th year now in October.
Soon.
In October, end of October, my 11th year.
Yes, okay.
But if you take my acting experience into account, I think it's 12 years.
Yes, but also during the time that you have been a judge in the High Court, you have acted in a number of courts. You have acted in the Labour Appeal Court,
Yes.
is that right?
Yes.
You have acted in the Competition Appeal Court, is that right?
Yes.
You have acted in the Supreme Court of Appeal, is that right?
Yes.
And you have acted in the Constitutional Court.
Yes.
Has that given you quite a wide range of experience?
Yes, it has, and I think it's made me a far better judge. And I see that now when I go back, when I'm sitting in the High Court. The manner in which I approach matters is with a very different eye. You get a wealth of experience sitting in large benches, particularly the Constitutional Court, the Supreme Court of Appeal, the Labour Appeal Court. The experience, it just helped develop me into a far better judge, I think, and the ability to hone into the important issues and to focus on the important issues, and to write judgments differently than you would write judgments if you only had High Court experience. So I think across the board, it has really assisted me as a judge, and I actually feel with each year and each time I act in any of these courts, I come out feeling more competent and more confident and more at ease with the job that I have to do in the High Court. So I'm really very, very grateful to have been given all of those opportunities to have that experience across the board in all of these appellate courts.
Yes. Do you have an idea about how many reported judgments you have penned?
I think in total, probably around 60, I would think.
Around 50?
650 or 60.
50 or 60?
60, I'm not quite sure.
Okay, no, we don't need to have the exact number.
60. I think it's about over 60.
No, we don't need to have the exact number. We've got them here. And some of those are judgments you wrote in the High Court, others Labour Appeal Court, others Competition Appeal Court, others SCA, others Constitutional Court.
Yes.
Yes. Now, in terms of the work in the Constitutional Court, either in the Constitutional Court or in the High Court, have you had a chance to deal with matters where you have to declare legislation
search and seizures without a warrant, and this took place in the context of almost 3,000 occupants of buildings in downtown Johannesburg, and we rendered that section unconstitutional, but we also provided Parliament with an opportunity to put in place to remedy that in a year. That matter was heard by the Constitutional Court, I think, at the end of last year, November, December last year, I believe. As far as I'm aware, I haven't seen the judgment of the the Constitutional Court. I think it's still pending. I rendered legislation under the iPad Act unconstitutional. The Contingency Fees Act, we found that the act was not unconstitutional, and that also was upheld by the Constitutional Court. But there were matters where the Constitutional Court basically confirmed the order that we made relating to the unconstitutionality of legislation.
Yes. What kind of factors would you take into account if you were appointed to the Constitutional Court and you had to deal with an application for direct access?
Well, the question is whether it's in the interest of justice that the matter comes to the court, by way of direct access. I mean, is it a matter where you need to have the view of the High Court? So ultimately, it will revolve around the interests of justice and whether or not...
What kind of factors would you look for in deciding the interests of justice?
Yes, I mean, well, the one would be basically whether this is an issue that, for instance, evidence has to be led, and the matter comes to the Constitutional Court, direct access. I mean, the Constitutional Court can simply not deal with that matter. It's, the High Court would have to firstly sit on the matter, listen to the evidence, and then give a judgment on it. I mean, at the end of the day, the interest of justice is such a wide concept that, are the issues sufficiently important, sufficiently pressing, for the matter to come directly to the Constitutional Court?
And a direct appeal, what kind of factors would you look for to decide whether to entertain a direct appeal?
Well, I mean, the question is, firstly, the question is whether it's, the court has jurisdiction. Is it a constitutional issue? Is it an issue that raises an arguable point of law? So jurisdiction becomes very important. I mean, even with an appeal, it's always better for the Constitutional Court to have a decision of the court that first heard the matter. An appeal, in an appeal, you first go to the court that gave the judgment, and you seek leave from that court. I mean, a direct appeal is completely different from confirmation of unconstitutionality. It's there's a hierarchy in our court system. If it's a constitutional matter, it can come directly. If it's not a constitutional matter, if it deals broadly with the common law, it should go via the SCA first, the intermediate court.
Okay, please just repeat that last point.
I said if it's a constitutional matter, it can come directly to the Constitutional Court. But if it's a matter where it turns on the law and not necessarily the Constitution, it should actually go through the SCA. It should follow the normal course in the High Court, the Supreme Court of Appeal, and then come to the Constitutional Court as the court of last instance. But
if it's a constitutional matter, it doesn't have to go to the SCA?
If they're also common law issues, I think it can go to the SCA. It should go to the SCA. The SCA has dealt with constitutional issues. If it deals with confirmation of unconstitutionality, then it would have to come directly to the Constitutional Court. But if it's a matter where the SCA has jurisdiction, then it must go through the SCA before it comes to the Constitutional Court. You shouldn't be bypassing our court system. I think there's the hierarchy of our courts, and it's important for a matter to proceed through all of the courts before it gets to the Constitutional Court, unless it's a matter relating to confirmation of unconstitutionality.
Thank you, commissioners. Yes, Commissioner.
Good morning, Acting Chief Justice Moimang. Moimang is my surname, Acting Chief Justice.
Yes.
I know it can be very difficult to pronounce.
Thank you.
Thank you. Good morning, Justice Tilwane.
Good morning, Mr. Voimwana.
I just have two areas that I want to converse with you. The first one relates to the recent Concord judgment on the IEC matter.
Just 1 second, Commissioner. Am I the only one who struggles to hear commissioners sometimes when they are speaking? Maybe, but I see your mic is quite close to you, so.
I've just brought it closer
No.
to me.
Okay.
DCJ,
Yes.
there is no monitor next to you there. There are 2 monitors here by you that side. So I think when we adjourn,
Yeah.
you need to get a monitor that side.
Yes. Okay, thank you. Thank you. Okay.
Thank you.
Thank you, Commissioner Malema.
Thank you, Acting Chief Justice. I just want to check with you. Do you think that the South African Constitution is a living document that must be informed by the conditions that exist, like the pandemic, or is it an absolute that must be enforced at all times, irrespective of the conditions that exist? I'm raising this question in light of how the court interpreted Section 159 of the Constitution on the term of a municipal council to say it is irrespective as to whether there is pandemic or not. The term of a municipal council ends after 5 years, and within 90 days you must go to the election. Don't you think that the court should have been open-minded on the interpretation of this section?
I think the Constitution is a living document. It's a flexible document. It allows one to, when dealing with the rights in the Bill of Rights, when dealing with any other constitutional provisions, and testing the constitutionality of legislation, of executive conduct, etc. I think it requires a contextual approach. And so it's a flexible document. The court decided to go the route that the 5-year period had come to an end and the elections have to be held on a particular day. That was the decision of that court based on its reasoning. But I see the Constitution as an organic living document. And for me, context is very important. I mean, there's no one answer to the question you're asking me, but it's important in any constitutional inquiry to basically look at context and the times. And, 20 years from now, the Constitution may require interpretation that's right for that time as opposed for now. 10 years ago, the Constitution would have required a contextual interpretation or a purpose interpretation for that time. So, as I see it, it's a living, organic document that will be informed by the context, basically.
Thank you, Justice Tilwane. The second one, on your recent judgment on the setting aside of the mining charter, don't you think that somehow it delays transformation, particularly given the monopoly within the mineral energy complex, but more than that, take into account the fact that in Botswana, the government of Botswana owns 51% of shares in the Shwana company. And here in our country, we are still at
I'm sorry,
86%.
Commissioner. I'm sorry,
Thank
Commissioner. I might have missed something. I'm hoping you are not asking her about a matter which might go to the Concord at some stage, and if she is appointed to the Concord, you may be asking her to express an opinion on it.
I think let's allow her to express a view on that, Chief Justice. If that is the case, then I'm comfortable with I'll be comfortable with the answer.
Well,
Thank you.
well, if you are asking, I may have missed something on a question, but if you are asking to express a view on a judgment that has been given, for example, by the High Court, that might go on appeal to the Concord, you might be putting her in a difficult position.
I agree with that advice, Acting Chief
Yes.
Justice. Let me reserve that question.
Okay, thank you. Yeah, no, so.
Thank you.
Yeah. I'm sorry. Is it Minister first? Or him first? Okay. Commissioner Mpofu.
Thank you, DCJ. Good morning, Judge. Thank you. Yes, no, I just wanted to say first that I know it must be difficult for candidates like you who were successful last time to have to do this again. But the DCJ has explained that a court order is a court order.
Stand, yes,
Yes.
you must comply.
No, I think we owe you an apology. Through you, the other successful candidates as well. But I only want to ask you one question, which is this issue about acting in the Constitutional Court, the importance of that. I think we canvassed it with the previous candidate, and we all know that it's not compulsory. It's not a criterion that is in the Constitution per se. But what significance, in your own personal experience, would you place on that factor? Or maybe asked differently, how did that enrich or convince you yourself about your own suitability to go to that court, given the work that you've done, the givens that you've given? Would you have felt the same if you had not acted in that court? If you get the gist of my question.
Yes, if I can just start from, at the beginning. I think if I had not acted in that court, I would not have put my name up for a position in that court. I certainly would not. I think it would have been presumptuous of me to have done so without having the benefit of, spending time at that court. Like I said to Acting Chief Justice Zondo, the time that I spent there was invaluable. I have to say, of all of the courts that I've acted in, and I really enjoy acting in the appellate courts. But I was very sad when that 6-month period came to an end. And I remember sitting at the conference table and Acting Justice Zondo was there, and we were saying goodbye to each of us. And he said to me, both in respect to me and Judge Collopin, my colleague, he said, we were very happy to have the two of you in this court. You were a natural fit in this court. And that really made me feel good. I really, really enjoyed the manner in which we dealt with matters, in the manner in which we exchanged ideas, the manner in which we disagreed or didn't disagree with. It's all done on paper. Unlike in some of the other courts, nobody comes to your office and tries to impress on you on what position to take, There's nothing of that sort. You are left to your own devices. When you get there, 1 or 2 judges will take the time to come to you. They'll take you through the process, because the process that you follow in relation to matters and the whole decision-making process is very, very different from the Supreme Court of Appeal or the Competition Appeal Court or the Labor Appeal Court. So it's completely different. Judges take the time to come to your chambers to explain the whole process to you. And they do say to you that they're available to assist you with any query that you have. And for me, I really, really appreciated that, where in some of the other courts, you don't really get that. You just jump in at the deep end, and things are expected of you. And if you don't do things in the way that is expected of you, then that is treated as a cross against your name. Nobody comes to you and says, well, you should not have done that way, you should have done it this way. In the Constitutional Court, it's very different. I picked up no ill feelings, I picked up no animosity. You were working in a very calm environment. Everybody was collegial. when you disagreed with somebody, you disagreed on paper. You got the time to basically set out, in a memorandum to your colleagues why you disagree. And then you were given an opportunity to basically, make amendments to a draft, make suggested amendments. So for me, that was so important. It was also very, very different from the High Court, where, we discuss issues before we go into an appeal. We discuss issues when you come out of the appeal. In the Constitutional Court, when I was a clerk, I know they used to have post-conference hearings after every hearing. At the time that I was at the Constitutional
Judge
Court.
Catherine Setlwane, I know I want to give you a fair opportunity to answer, but the answers should not be too long because we don't have all the time. Yes, but Commissioner Mbofu says he's satisfied.
Okay, thank you very much, Mr. Mbofu.
Thank you.
Thank you very much, Judge. Thank you, Mr. Chair.
Thank you. Then, Minister.
Thank you, Acting CJ, and good morning, Justice Tulana. I
Good
just
morning,
have
Minister.
two questions. One, it relates to the answers you gave to the Acting CJ on the issue of direct access and direct appeal. That you seem to say that the test is the same. Maybe I'm wrong, but I was surprised by that you did not mention exceptional circumstances when it comes to direct access.
I suppose I meant, in the interest of justice, I meant to also refer to exceptions. There has to be exceptional circumstances before. Sorry, I beg your pardon. Indeed.
Okay. Yeah, I was surprised that you did not mention them,
Yes.
because I thought they are in terms of the test, is the most important.
Yes, it is the most
factors.
important, yes. Sorry, I used
Okay.
interest of justice, and what I meant to actually say was exceptional circumstances. You're quite right.
Oh, okay. My second question relates to the matter that you handled for the lesbian and the gay and equality project, on the issues of same-sex marriages. I want to. What could be your view for government in particular? Given the current environment of brutal killings of the LGBTQI community, what do you think could be done that we do not have to wait for the courts to direct us to promote love, diversity, and tolerance in society for this community?
Yes. I mean, I do think it's a community that has been treated badly, that are still subject to discrimination. We have a whole framework, a legal framework in place, and a policy framework in place to basically deal with violence against women, violence against members of the LGBT community. Some say that framework is not sufficient. I think we can still work within that framework, but I think there has to be, on a broader level, there has to be education around the rights of these communities, and that's the only way there's going to be full acceptance. If society is made to understand that, like all other members of other heterosexual members of society, people with differences from the LGBT community have the same rights and should be given the same protections. I think government can do much more in terms of its policy framework. I think government can do much more working, through members of parliament in their constituencies to basically educate society, educate communities on LGBT rights, and that will lead to a proper acceptance of any persons that come from marginalized or minority groups. I think our court staff, I think the police, all have to be sensitized around issues of violence, and this relates both to violence against women and particularly violence against LGBTQ women. I mean, I think when it comes to violence against women and violence against members of the LGBT community, I think our numbers exceed the global numbers, I think, by 5 times. You know, I mean, I think that's how drastic the problem we face with violence against women and violence against members of the LGBT community. So I think government, together with civil society, and the courts, I think, have to work together in order to entrench. The Constitution entrenches the rights of LGBTQ people. But I think if you have this coordinated approach with all of these 3 groupings, you know, you can, in time, ensure that violence is eliminated completely against women and members of the LGBT community. And women especially, lesbian women especially, have become victims of violence, which is really very, very sad in this day and age of our constitutional dispensation.
Thank you.
Thank you, Minister. Deputy President Betzer.
Thank you, Acting Chief Justice. Good morning, Justice Katri Setulwana.
Good morning, Mr. Justice Betzer.
My first question to you will be in the form of a general proposition. And it is this: you know, collegiality amongst judges conduces to a healthy work environment, and lack of it is a catalyst for a toxic work environment. I just want to know from you first if you do subscribe to that general proposition, and 2, whether you scrupulously subscribe to the principle of collegiality amongst judges.
Justice Betzer.
Thank you. And my second and last question to you, looking at one of the Constitutional Court judgments in SOS Support Public Broadcasting Coalition and 2 others versus South African Broadcasting Corporation Limited and others. It's a judgment that you penned, and mindful of the fact that the primary responsibility for ensuring that a judgment is produced expeditiously rests with the scribe. Can you share with this commission why this particular judgment took slightly more than 10 months to deliver?
Yes, sir. This judgment was, we had heard argument in this judgment at the end of, right at the end, it was one of the penultimate hearings of the court in November 20, the year that I acted there, I think it was November 2017. During December, there was new correspondence from the parties, and they wanted to lead evidence on a whole number of aspects. And I then had to produce memoranda in that regard to my colleagues, which this sort of came in sort of around Christmas, mid-December, I remember. And I had already started writing the judgment in December of 2017 during that recess. Yes, so there was the issue of wanting to lead evidence after hearing of the appeal. I then had to produce memoranda, and I think in January we considered that. My colleagues considered that and came back with responses. We decided we weren't not giving them a new hearing, that we were going to basically deal with it in the judgment, so I had to take that into account. I then went back into the High Court, and in the last week of recess of the High Court, while I was so busy with this judgment, I was in urgent court. So I had a particularly heavy urgent court because it was the last week of recess, and I needed time, I had a number of reserved judgments from urgent court that had to get out urgently. So that took me, I think, into February, when we started term, and I think I was in term for 1 week when, in terms of the roster, I was back in urgent court. So I had all of those commitments in urgent court again, which in Johannesburg, urgent court gets incredibly busy. I was then busy during the April recess. I then spent time on the judgment, and at the same time I had Competition Appeal Court hearings. I remember at the beginning of that recess, but the second part of the recess and a week or two afterwards I spent completing the judgment. There were a number of issues in the judgment. It was a highly complex matter, and there were 2 lots of evidence. The one lot of evidence we had to consider was whether we grant them leave to adduce new evidence at the point that we were hearing the application for leave to appeal, and the second was whether we allowed them leave to adduce new evidence after the application had been heard. I was still busy. I think at that point, just immediately after the April recess, and after I'd finished my competition matter, I had then submitted the draft to the Constitutional Court. I had not heard from the Constitutional Court until about June or July of that year. So I didn't get feedback for them for at least 4 months on the judgment. When I spoke to Judge Jafter, he said to me, unfortunately, there have not been any comments yet. None of the colleagues have commented as yet. So I waited for them to come back to me. In end of June 2017, I had a tumor on my ankle, and I had to go in for an urgent operation to have that removed. It was then the recess, and I was recovering from the operation during the recess, when I think towards the end of that recess period, and while I was recovering, I then got a call then I received a draft, then I received comments from the judges, and I then worked on made the necessary revisions, and I sent it back to the Constitutional Court. They then conferenced on it, and then it came back to me, and I think within a day or two, we then produced the judgment. I then let them have my final judgment.
Through you, a follow-up, Acting Chief Justice. So the short answer to my last question is that the long period of gestation that finally bred this judgment was not attributable to any dilatory conduct on your part.
Absolutely not. Absolutely not.
Thank you, Justice Carter Situlana.
Thank you.
Thank you, Acting Chief Justice.
Thank you.
Thank you. Then Commissioner Mapisa Ngakula.
Thank you very much.
I think she must mention that their judgment was against her.
Yes, it was. And I can assure you, I can assure you, DCJ, that it was one of the hardest ones on my part.
Yes.
But we did well. Thank you. Thank you very much, Judge Sitiluana. And your CV talks to somebody who always advances the transformational agenda wherever you've been, be it quality of women, mentoring, and of young attorneys. And I would want to know, though, what do you think should be the attitude of judges who are in the Constitutional Court in educating society about some of their groundbreaking judgments? Yeah? I'm talking about society. I'm not now focusing on the legal fraternity. I'm talking about us who are sitting here. How do you think, because half the time you find that indeed there's a groundbreaking judgment which was made X number of years ago and you're not familiar with it. how, as you move into, if you're appointed into the CC, how do you think this constitutional court should do that, but also promote the Bill of Rights of the people of South Africa? The Bill of Rights of the people of South Africa, because it's always about constitutionality, but you hear very little about the promotion of the Bill of Rights of the South African people. Thank you very much. Thanks.
Yes, I mean, I think educating the public on the Constitution is an important project. The rights in the Constitution have to be realized and have to be lived out by members of society. And unless members of society are aware of the workings of the Constitution, of the rights, of their rights that they can invoke, the Constitution then becomes a useless a useless document. So I think it's important. I mean, I think when I was a clerk at the Constitutional Court in the first year, at the inception of the court, the one thing that we proposed was that the clerks actually put together a summary of the case, a pre-hearing summary, a post-hearing summary of the case, and that was actually directed at the press, so the press are not confused. But I did see over the years that members of the public also benefited from those summaries. But I think much more has to be done. I think perhaps the Constitutional Court can, from time to time, have road trips where, there's nothing wrong with judges basically going out into society, spending a day in Soweto, spending a day in Alex, in the same way as NGOs do, just basically talking about their judgments to the people, educating them. But I think it demystifies the court, it demystifies the Constitution. It brings, one's rights, makes it more realizable. So I think you could have that. You could have, once in 6 months or once in a year, judges basically making themselves available in a town hall to talk not about matters that they're currently dealing with, or aspects that they may deal with in the future, but past judgments, the important judgments of the past, and how that impacts on society. I think, there's a wealth of information amongst the clerks at the court. You could have a roadshow of clerks, during the recess, where clerks can join members of NGOs and carry out this educative process. So there's so many different ways of actually bringing the Constitution closer and closer to the people, for them to make those rights realizable for them, I think. Thank you very much.
Thank you, Commissioner Pisangakula. And then I have Commissioner Makwanishe.
Thank you very much, Acting Chief Justice. Good morning, Judge Situlwane.
Good morning, sir.
No, I have one question for you. In 2004, you wrote an article entitled 8 Years at the Bar. And in 2006, you left the bar to join Waxman as in-house counsel. Were you disgruntled?
Was I?
Disgruntled.
Disgruntled?
Yes.
I was very, very involved in transformation at the bar, and the issue of briefing patterns was uppermost in all the minds of young counsel. Judge Mpofu was my colleague. He would know the debates we had at bar council level in relation to briefing patterns. When I started at the bar, my practice was essentially public interest law, constitutional law, public interest law. As time went by, I started breaking out into other areas of the law, competition, telecommunications, etc. But women were still not getting the amount of work that women were entitled to at that time. And black members, black women, black men, women generally were not getting the kind of work. So when I wrote that article, I I wasn't disgruntled, but I was disillusioned. And I said that I have never experienced that element of discrimination that I experienced with briefing patterns, that I experienced in those 8 years at the bar. In those 8 years of the bar, we ran gender, sensitivity workshops. We invited attorneys to functions where we basically presented them with CVs of young people. We introduced them to young people. And the disillusioning part was they would brief those young counsel on one or two occasions, just, cosmetically, and thereafter they'd just return to their old positions again. I mean, by that stage, we also introduced the second junior rule, where if you didn't have a black counsel or a woman counsel on board, you had to bring one on. But of course, that benefited the very, very junior counsels in their first, second, and third years. I mean, by the time you were 8 years and above, you were actually left to your own devices. So I had a fairly busy practice, but I felt that I was not getting the commercial experience that I should be getting. So when Worksmans made me this offer to come and join them as in-house counsel, I decided to take that opportunity. But I always had at the back of my mind that I will come back to the bar. And while I was at Worksmans, I introduced a project whereby it was Worksmans and a few other law firms, and I had to get special authority through the Johannesburg Bar from the General Counsel of the Bar to create opportunities for young women juniors to spend 6 months to a year at a law firm. So that basically allowed them to be exposed to the networks of lawyers that will assist them in their practices later on, So I wasn't disgruntled. I'm not disgruntled with the bar. The bar, the new bar, the Pan-African bar, members, they are all very close to me. They are my colleagues. They're my friends. They appear before me all the time. I support them in terms of their education programs, advocacy training, all of those things. But there was a problem with briefing patterns. And I see now, and it's encouraging, that more and more young women, particularly black women, are appearing in their courts. This mining charter matter. There were at least two women silks that appeared in the matter, and for the communities and the unions, you had about 4 women appearing, very junior counsel in under 4 years who did a superb job. So it's encouraging to see that those briefing patterns are changing now. I'm not sure that they are where they are, but they are
I
changing.
encourage you again, just Catherine, still wanted to try and not
Thank you, I'm done.
give too long answers. Yeah.
Thank you, I'm done.
Okay. Are you done, Commissioner?
Yes, I'm done. Thank you very much, Chief
Thank you
Justice.
very much. I'm always happy when a commissioner asks one question. I'm making a note. Commissioner Matolo Mdlepu.
Thank you, Chief Justice, and good morning, Judge Setilwane.
Good morning.
When it comes to mentoring, I can vouch for you. You are always available for young women to be trained. But I just wanted to follow up on Commissioner Ngakula's issue on how do we, instead of bringing the constitutional and Bill of Rights to the people, how do you see the constitutional court actually maybe mentoring or offering learnerships to young practitioners? Because I see a lot of young practitioners really want to do constitutional law. They end up attending courses, but nothing. But I think the mentoring, like when you are a judge's clerk, wouldn't be a good idea, maybe a problem like that.
Yes. The whole constitutional court program around the clerks is structured such that
You get young lawyers that come in for a year, and I think they can only stay for a year, not more than that. So that ensures that a number of young lawyers go through that program, which I think is very important for their development as young lawyers. But I think what you're asking me is, what do we do about young students at university, and how do we expose them to what's happening in the Constitutional Court? You know, while I was at the Constitutional Court, one of Judge Zondo's clerks formed an organization called Sinako We Come, and basically what she did, and I think that's a fantastic idea, while she was the clerk at the court, she's now at the bar, she's now doing her pupillage at the bar. She basically used to invite students, high school students, university students from across the country, right? And she would then bring them to the Constitutional Court for a weekend. And she would then invite judges, and she invited me, I know she invited Judge Jafta and a few other judges to basically address these students, on why, on the work that the court does, basically demystify the Constitutional Court. And what that does, it actually instills in the minds of these young people that, you've got Justice Jafta, you've got Judge Mahora, you've got Justice Taran, you've got Justice Zondo. These are all people that were young students like you were. And, and look where they have come. So that, in their minds, inculcates the idea that I can also achieve what these justices have achieved, Whether whether ultimately I get to the Constitutional Court, or I become an advocate, or I become an attorney. But, I think what this young girl has done is incredible. And I think she's won some awards for it as well. And I think that kind of program can be replicated to really bring young minds, people that are interested in becoming lawyers, into the court environment, and expose them to the court and to the justices and to the other young clerks.
Thank you. Thank you.
Thank you, Commissioner. Before I go to Commissioner Tepe, can I go to the commissioners who are virtual and see if anyone wishes to ask a question? Commissioners?
Acting Chief Justice Singh, my hand is up.
Yes, thank you.
May I proceed?
Yeah, proceed, please.
Thank you, Acting Chief Justice. I'm on the screen in front of you, Judge Setwana. Good day to you. In your questionnaire that you completed on the 27th of November 2020, you listed that there were no reserved judgments, but you had 3 part-heard matters, some ranging back to March 2019, so it's more than 2 years now. There were 3 matters that you listed. What I'd like to know if these matters have been heard and concluded.
Yes.
And allied to the question of timeframes, a question was asked early on about, and from your experience in the Concord, what is the average time do you think the Constitutional Court should take to hand down judgment on a matter? And here I refer to one matter, where a court in the Western Cape, I think with Judge Magona, ruled that life partners are spouses for interstate succession. This was in October last year, and it's almost a year gone, and I don't think a judgment has come forth from the Constitutional Court. So what are your views on that? Timeframes and your part-heard matters.
Yes.
Thank you, Acting Chief.
Yes, on my part-heard matters, they've all been completed. I had to lead, I think there was just one. There's one where I've heard the evidence in all of them. There's one where I'm waiting for them to let me have the transcript and let me have the heads of argument so I can then prepare the judgment. So that should come now in this new term. So all of those part-heard matters have been completed. There were also delay because of, in March 2020, because of COVID, so matters from 2019 would have been dealt with in that 2020 year. But because we were still setting up our systems, and in relation to trials, it was particularly difficult, especially if it was a long-term trial. But all of those trials just needed about 2 days of evidence, and that's all been completed. One of them became settled.
No, thank you for that, Judge.
Yes.
And just the second part?
Yes, I think in relation to getting out judgments quickly,
you know, I mean, there's the, in terms of the code of conduct, there's the, you know, there's the, we are all required to produce judgments within 3 months. You know, in Johannesburg and Pretoria, it's sometimes a little bit difficult to produce judgments within 3 months because of the workload that we have. So lengthy judgments, complex judgments are kind of dealt with over the recess period. So sometimes it just goes over 3 months. But I think in the Constitutional Court, you know, I mean, when I was there, I didn't realize from when I was a clerk there to the time that I acted in that court how large the workload of that court is. And particularly because it's dealing with these applications for leave to appeal all of the time. So apart from the hearings, they're dealing with, you know, hundreds of matters that come in virtually every month that have to be sifted and given to judges, and judges must decide whether these, you know, these matters should have a hearing, whether there's grounds to grant leave. So there's the workload, I think, since, you know, 2016, 2017 has increased. Well, I mean, since the jurisdiction of the court has increased, I think, since that amendment in relation to to extending the jurisdiction of the court to matters that extend beyond constitutional matters. So the workload is incredibly heavy in that court, but you know, I think they could work quickly. Maybe judgments could come out sooner. It's very hard to tell because, you know, in as much as we'd like judgments from the Constitutional Court to come out sooner, there's a lot of deliberating that has to happen. Sometimes there are more than one concurring judgment. Sometimes there are more than one dissenting judgment, you know. So judges are drafting judgments that they get allocated for that term. They're drafting judgments that they were allocated before that. They are writing dissenting judgments. They're writing concurring judgments. So you know, it's not like in the High Court where you just have a particular matter and you're applying your mind to it, or you're sitting in an appeal and you apply your mind to that and you can get it out within 3 to 4 months. I think it takes time in the Constitutional Court because of dissenting judgments, because of other concurring judgments, because of the workload that the judges are faced with. I mean, it's an incredibly large workload. I was completely shocked at the workload that the judges face in that court. But I do think, you know, going forward, I think they're also trying their best to get judgments out as quickly as possible. But circumstances, you know, given the circumstances that they face, judgments are sometimes delayed. But I find it, you know, I think simpler judgments, smaller judgments come out quickly, but it's the larger ones where there needs to be lots of discussion to bring everybody onto the same page. That takes longer, I suppose. Yes.
Just a quick follow-up, ACJ.
Yes.
So what you're saying, Honourable Judge, is what's good for the goose is not good for the gander. You've got a 3-month rule,
yes.
you know, generally, but with the Concord they can take as much time as they want.
No,
is
I
that
don't.
what you're saying?
I think it has to be a reasonable amount of time. I think within 6 months or so would be reasonable, I would say.
Okay, thank you. I've got an answer. Thank you.
Thank you. Commissioner Tsepe.
Thank you, Acting CJ. Good morning, Justice Kathryn Stilwan.
Good morning.
Welcome. I just wanted to ask you, do you think that the experience that you have, particularly acting in specialist courts like the Competition Appeal Court, would assist you were you to be appointed at the Constitutional Court, given the extended mandate or jurisdiction of the court? And if so, do you have examples where that have happened when you are acting there? Thank you.
Yes. When I acted in that court in 2017, I had not acted in the Competition Appeal Court, but I was given a complex competition appeal matter, the SOS support group matter, to deal with. And fortunately, I had some knowledge from when I was in practice, you know, to put into that judgment. But I did a lot of research as well. I did a lot of research on it. I do think, I think having the extra labor appeal specialist experience from being in that court and the competition appeal experience
will help tremendously in the competition appeal, in the Constitutional Court, because those two courts now are on the same level as the SCA, and those matters come directly to the Constitutional Court on appeal. They don't go via the Supreme Court of Appeal anymore. So they're going directly to the Constitutional Court. So I think any judge that's appointed in that court should have sat in the Labour Appeal Court and the Competition Appeal Court. Should have that specialist experience. Yeah.
Thank you.
Thank you.
Thank you. I think I'm going to just mention this for the benefit of everybody. I'll get my staff to double check. I think the reference to 3 months that Justice Catherine Setlwane is referring to in terms of judgments is what the judiciary has fixed as what they aspire to achieve, ideally. But it's not misconduct if you go beyond 3 months. You can still have more time. So I just want to I'll check when, and I'll come back to it when I can say something more accurate. But I think the 3 months is just what we aspire to achieve one day.
Actually, I think Chief Justice is 8 months.
Oh, it's 8 months.
3 months is a warning.
Yes.
That is, you have to, parties
Yes.
can ask,
Yes.
but the judgment must be delivered in 8
Yes.
months.
Thank you, Commissioner.
Yes, I know in the High
Commissioner,
Court.
I wanted to double check. I was thinking 7 or 8 months, but I wanted to double check. Yeah. Okay, all right. Thank you. Then Commissioner Madonsela.
Thank you, Acting Chief Justice, and good morning, Judge Catherine Setlwane.
Good morning, Mr. Matansela.
It seems clear to me that there is some consternation around the delays in judgments, especially from the Constitutional Court. And you and some other candidates have sort of tried to tread carefully in trying to give explanations for it. But hopefully we don't have to tread carefully, because we're not aspiring to go to that court.
Okay.
As matters currently stand.
Yes, understandable. Yes, yes.
Maybe the chairperson must get out of the room.
Now, if we were to confront the problem, and if you were to be appointed in the Constitutional Court, given your understanding of the workings of the court, having been a clerk in that court and having acted in that court, how would you seek to address the problems associated with quick delivery of Constitutional Court judgments? What do you think is wrong with the Constitutional Court just giving out quick judgments with no theses that are written by various judges who differ on particular topics? That's one aspect of it. The other aspect of it, you have mentioned the question of applications for leave to appeal, which are also occupying the court outside of the sittings of the court. How can one alleviate the burden of the justices of the court in dealing with applications for leave to appeal, which seem to be coming in numbers now that the jurisdiction of the court has been enlarged?
Yes. I mean, I think I think it's important to try and get consensus in these judgments to the Constitutional Court, but it's not always possible. And I think those judgments where there's consensus, those judgments are delivered, fairly soon, within 3 months, I think. From my experience, things just where there's dissension amongst your colleagues, that takes a little bit longer. But I do think that there's a whole register when you go to conferences on a Wednesday. So when you are allocated a judgment, you are then, from the date of the hearing, you're given, I think, 3 weeks, 15 days or 21 days or something to produce you're first given 7 days. You're first given 7 days to produce your memorandum, okay, setting out your views to your colleagues. And then once your memorandum is in and once your colleagues have responded, and the colleagues also have a period of about 4 to 5 days, or could be 7 days, to come back to you to tell you what their views are, whether they agree or whether they not agree. And you know basically from those responses from your colleagues, you know, which way, whether they're going to agree with you or not. Then, you know, from that date, you've got, I think, maybe 15, and Judge Zondo will, Acting Chief Justice Zondo will correct you. You probably have, I think, 3 weeks, Acting Chief Justice Zondo, to produce a draft, okay? You then produce the draft, and sometimes because of I found that sometimes because of the workload, your colleagues don't come back to you immediately on that draft, you know. Maybe if it's a high-profile matter and there's a need because the public are waiting for the judgment, that'll happen. But I think other matters can sometimes take longer. So that your colleagues sometimes only come back to you in a month's time or 2 months' time. Or some colleagues will come back to you within the 7-day period, you know, with their comments on your draft. Some other colleagues take longer. So I think you can actually try and bridge those periods, time periods, you know, and make sure that each of the judges keep to those time periods that are set up. Because they very carefully, one of the judges takes responsibility for this register. And I know it was between Judge Cameron and Judge Turan when I was there. They would, you know, every day, every Wednesday conference, they would basically insert that, you know, this judgment is due on that day. And when you've given the judgment in, and if you haven't, then they'll remind you at the conference. But sometimes the circumstances, you know, depending on, you know, the other thing with the court is, and we have to understand, given all of these matters that they asked to deal with by way of direct access or otherwise, matters on the basis of urgency, etc., those matters actually interfere with their workload in the regular caseload of that court. Because every term, the 11 judges get one judgment to write, you know. And maybe you'll get a smaller judgment to write that arises out of matters where there are no hearings, but you will produce you may still produce a judgment. Yes.
I understand the bureaucracy around the production of judgments, but my problem is, and I want to hear you on what the solution should be. Shouldn't court just simply write quick and short judgments?
Yes.
Or shouldn't the court employ people to assist in considering the applications for leave to appeal so that we have a quick turnaround time?
Yes.
That's what I want to hear. I don't
Yes,
want to hear
yes. Yes, I mean, I think with the applications for leave to appeal, the clerks are already there. The clerks draft the first memorandum and the application for leave to appeal, and then the judges then basically work on that memorandum before it's sent out to your 10 other colleagues. So there is already assistance from the clerks, you know. Clerks are also there, and they're also assisting the judges with research in the judgments. So I think that I think you can actually speed up the process. I think maybe there has to be a concerted effort to actually speed up the process and maybe hold judges to the deadlines that they're given. I think if you hold them to the deadlines that they're given, and unless there's a convincing reason for not meeting that draft, you know, a judge must be told, no, you need to produce this within that time limit because everybody gets the same time limit. So I think you can work quicker. I think maybe that's the culture. The culture needs to change.
I think you can hold them to their deadlines. I know that.
Yes, I think you can hold them to deadlines, and I think in some cases you don't have to go into a whole exposition of the law and repeat, you know, what the High Court stated 15 years ago. The Constitutional Court, you basically hone in and, you know, in developing the law, you develop the law. You don't have to do it in 45 pages. You can do it in 10, 12 pages. And I know that judges are being encouraged to write shorter judgments. I mean, we certainly were encouraged to write shorter judgments when we were there.
Thank you, Judge Catherine Setilwane. I have Commissioner Shabangu Mdawe, Commissioner Nojesi, Commissioner Malema, and Commissioner Schlema. I propose to stop with these. We are running behind time. Okay, Commissioner Shabangu Mdawe, and I'll always be happy if a commissioner says one question only.
Thank you, ACJ. I'm going to be very short. In fact, I want to make a follow-up on,
Yes.
on the question asked by the minister. Good morning, Judge Sitwan.
Good morning.
Let me first start by commending you by taking that matter of the LGBT community back then in 2005. It was not an easy task to represent that community. Then, looking back then and now, has anything changed with regards to the rights of the LGBT community? Are our courts protecting the rights of that community enough? Should you be considered? What is it that you will assist so that the rights of this community are protected?
No, I think in terms of the rights to marriage, and I think inheritance, in terms of succession, all of those things, adoption, surrogacy arrangements, in vitro fertilization, adoption. I mean, they've attained a number of rights through the years, you know, through the High Court right up to the Constitutional Court. And I think, for me, and the concern that was raised by the minister is the question of violence against members of this community. And the same goes for women, you know. How do we ensure that endemic violence that this community faces comes to an end, you know? And what can we do as a society? What can we do as government? What can we do as courts to basically ensure that there's full protection against violence for these communities?
Thank you.
Thank you, Commissioner Shabangomdawe. Commissioner Nojesi.
Thank you, Chair. I've been covered. At least let me oblige. I've been covered.
Thank you. Oh, you make me happy. Commissioner Malema.
I'm not about to make you happy
just
now.
go straight to the point.
You know, I want some sense of clarity. Here, people make an application for rescinding judgment in the Constitutional Court, and they are made to run during weekend, and the matter is heard quickly. An impression is created, correctly so. There is an uncertainty in the country. That's how urgent that matter is. There is uncertainty in the country. Things are burning, literally. And when we grew up, we were told that an urgent application means that someone is about to lose life. There must be an immediate intervention. When that impression is created, the matter is heard, the Constitutional Court takes forever to come back to us with so much uncertainty. How do we deal with that? Is that enhancing the good image of the judiciary? And if not, who is going to be held accountable? Are there mechanisms to hold Constitutional Court judges accountable? Because an impression must never be created that the Constitutional Court judges are above the Constitution. They too are subjected to the Constitution. How do we deal with that?
Yes, Mr. Malema, I understand the frustration that was attached to basically waiting for this rescission judgment to come out. It took quite a while. I do believe when the court deals with the matter on the basis of urgency, it then must apply the requisite urgency in producing that judgment. I mean, we do that in the High Court. You know, we have highly complex matters. And though sometimes these are the same matters that go to the Constitutional Court. And we produce judgments within a week or two, sometimes the very next day, you know. So I do think when the matter is urgent, then the court must then apply itself with the requisite urgency in producing the judgment.
Thank you.
Thank you, Commissioner Malema. Then it's Commissioner Schlemmer, and I think she would be the last one.
Thank you, Acting Chief Justice. Good morning, ma'am. It's almost afternoon.
Yes.
I'm sorry for keeping you so long. I just want to ask you one question, and that relates to the appointment of justices to the Constitutional Court. You mentioned during your interview a couple of times the fact that one needs additional type of knowledge, that you actually need to act in the Labour Appeals Court as well as in the Competition Appeals Court. Yet the Constitution has not been amended as yet to make provision for such requirements. How would you suggest that the Constitution be amended, and what would you require of Constitutional Court judges if you were to write the amendment to the Constitution?
Yes. I mean, I think, I don't know if you need an amendment to the Constitution in this respect, but I think it's advisable and it's appropriate to appoint judges that have had appellative, experience before. I think it's important. I mean, in the past, you had academics that came directly to the court. I mean, they did superbly. But things are changing now, and I think you need a lot of procedural knowledge, for a judge. And given that the Constitutional Court is now dealing with a larger subject matter than constitutional issues, you need to have the broader knowledge that a High Court judge would have, or a Supreme Court of Appeal judge, or a Labour Appeal Court judge. I'm not sure that it requires an amendment. I just think it's advisable when this commission appoints judges to ensure that the judges that are being appointed have experience across the field, and so commercial law, competition law, labor law, all areas of the law. In fact, you need to have broad experience, and I think that experience comes with serving a lot of time at the High Court, serving time at the appellate court. So I don't know if an amendment is required, but certainly I would say that when appointing members to the Constitutional Court, you need to have judges that have all-round experience, basically.
Thank you.
Thank you, Commissioner Schlemmer. Commissioner Mpofu has asked for a small indulgence. Commissioner Mpofu.
Thank you, DCJ. I'm so sorry to you, DCJ, as well. I meant to do a quick follow-up in the answer that you're giving me. You said that unlike in other courts, nobody comes to you or to your chambers to seek to influence which way you should go in the Constitutional Court. Can you tell us what you meant by that? Just briefly.
No, I don't think it wasn't meant in a malicious way. I just think that in the High Court we often talk amongst ourselves before we go into an appeal hearing. In the SCA, there was a practice that you shouldn't talk amongst yourselves before you go to an hearing, but I don't think that was strictly complied with. I think colleagues did walk into your chamber to try and elicit your view on a matter. I think that happened from time to time, which I was surprised. I was once in the lift and two colleagues were speaking about a matter that I was going to be in. They were talking about it and which way they're going to be, which way they think they should go. And I was standing there as an acting judge, completely silent, not even wanting to lend my ears to that conversation because I was told strictly you don't discuss this with other judges. That's all I said. No, there's no pressure on the Constitutional Court to go in a particular way or not to dissent or to dissent or anything of that sort. Really nothing at all.
Thank you, Teacher.
Thank you, Commissioner Mpofu. We are done. Thank you very much, Judge Catherine Sitlwane, for having made the time to come. We have come to the end of the interview. But before I release you, I would like you to be with us when we do what we are going to do now. I've been advised that it would be appropriate for us to have a minute's silence as a tribute to Commissioner Sigogo, who passed away. So if everybody agrees, may I ask that we all stand and have a minute's silence. You are now excused,
Thank you.
Judge
Thank
Catherine
you.
Sitlwane.
Thank you very much.
Thank you.
Acting Justice Zondo.
Colleagues, we We were supposed to have tea at 11. We're at 11:45. Maybe we should have tea now and restrict it to 15 minutes. I don't know whether that's the time you normally take, and be back at 12. Is that fine? Strictly 12. Okay, let's do that. Thank you. Good afternoon, Judge Golopen.
And good afternoon, Acting Chief Justice, and thank you.
Welcome, and thank you for availing yourself for this session of interviews. As you know, the session has come about as a result of an order of court that the Commission should do these interviews afresh. So we are grateful that you have availed yourself again. Thank you. Let us start. I see that you completed your BProc degree in 1978 and your LLB in 1980, both at Wits. Is that correct?
That's correct, Acting Chief Justice. I started my BProc at the University of Durban, Westville,
Yes.
and then was able to transition and complete it at Wits. Yes.
Yes, okay, all right. And then you went into private practice after doing your articles.
That's correct. I started practicing on my own in a small one-person firm, and then joined a partnership, and that was in the early 80s.
Yes.
And much of the work then was really involved the struggle of ordinary people against the might of the state, and one found oneself doing a lot of work in defense of people who were charged with all kinds of offenses, public violence, people in
Yes,
conflict.
just hang on one second, yes. Judge Golopen. Let's just... Okay, all right. Yes, you may complete your answer.
And that was largely the nature of the practice. I also was the correspondent in Pretoria for Mrs. Priscilla Jana and Associates. And Mrs. Jana, her practice was largely devoted to public interest work, and I would do much of the Pretoria work. So that just immersed one into that area of work. It was interesting that I also had my practice in Marabastad, and Marabastad is where I was born. It was where people were consigned to be forgotten about, and it was a resilient community. And despite the poverty and the oppression, there was a sense that people would overcome. And I came from a very working class family. My father was a waiter, my mother was a seamstress, but they instilled in one a sense of value. My mum was quite political. She was, I would say, fiercely political. She went to jail twice at the age of 19. She marched in 1956.
And the period of your practice was about 10, 11 years, is that right?
Yes, it was about 11 years until I joined the Lawyers for Human Rights in the early 90s.
Yes. And you were with the Lawyers for Human Rights for something like, what, 4 years?
About 4 years, until the end of 1996. I was appointed in late 1996 by President Mandela to serve on the South African Human Rights Commission. But I took up that post in January of 1997 on a full-time basis.
Commission for 13 years?
For 13 years, until September of 2009.
Yes.
And I served.
And 7 of those years you were the chairperson?
That's correct. Professor Bani Patiana was the original chairperson, and then Mrs. Shirley Mabusela took over from him for a short time when I was her deputy, and then in 2002 I was appointed as chair and served until the end of my term in 2009, September.
Yes. And from the Human Rights Commission, you started acting in the High Court, and ultimately you were appointed in the High Court as a judge in 2011.
That's correct, Acting Chief Justice. I started acting in January 2010, was appointed in mid-2011, and have been serving there since then, yes.
Yes. So would it be correct to say your entire practice was human rights law practice?
Not entirely. In a sense, when one lives in a community, substantial amount.
Predominantly.
Predominantly, but you would deal with the ordinary problems of the community: criminal work, matrimonial work, contracts. You know, it was a mixed bag when you're a one-person practice. Yes.
Yeah. And you have been a judge in the High Court from 2011 up to now. Would that be 10 years?
That's correct. I think I'm probably now in my 11th year.
You are now on your 11th year.
Yes.
And you have acted in the Land Claims Court?
Yes, I acted in the Land Claims Court for 2 terms and then in the Constitutional Court for 2 terms as well.
Yes. And how did you find acting in the Constitutional Court, and how did you find acting in the Land Claims Court?
I enjoyed both experiences thoroughly. In the Land Claims Court, one was exposed to, well, the legal dimensions of an issue that is cardinal and germane to the destiny of ordinary people. And it's the question of land and the question of people's entitlement to the land and their return to the land. And beyond the law and the limitations of the law, one was able to also imbibe, in a sense, the deep sense of attachment people feel to the land. It's just not as a commercial entity, but as a place that signifies their whole history, their legacy, their relationship with their ancestors. And it struck me when I walked on a farm just outside Heidelberg in the context of a land claim, when the son of the family, and him and I walked for a while. And you would walk for kilometers because you would do the markings and the photographs would be taken of the extent of the land. That was part of the preparation for the hearing, and how he articulated in the presence of the farmer the family sense of attachment. And that was perhaps one of the more important conversations that I was able to witness in the context of my work there. Because that conversation led to the resolution of that matter, in the sense that I think the farmer was able to understand this was not about a community wanting to grab my land. This was people who had a legitimate right to this land for a variety of reasons. And that understanding was able to resolve the matter. So I think that experience helped me considerably, acting Chief Justice, in both respects, both as a judge, but also as a South African, to understand the issue of land. And certainly in the Constitutional Court, I enjoyed myself there, because I imagine, even though I'm not a young boy anymore, the thought of any lawyer, the idea of serving in the highest court would be something totally unimaginable in our lifetime. When we started practicing, it would not have been possible you would not be allowed to imagine that something like that could happen in your lifetime. And so when it happened, I would almost pinch myself every day to say, this is happening. And at a personal level, you dress up in the morning to go to court, and you'd look into the mirror behind your door, and you would almost say, well, and you reflect and you think that you are enormously privileged to be able to serve your country in that capacity, given where our country had come from. But beyond that, I enjoyed the rigor of the work. I enjoyed the spirit of collegiality that existed there. And even as an acting judge, I think the willingness of other colleagues, of senior colleagues, to hear what you were saying. They may disagree with you, but they would be willing to hear what you said. And even if they disagreed with you, they would do so with due regard to your dignity. And they could be quite ruthless if they wished to, if you had produced something that was not of a quality that justified the status of that court. But I found that level of engagement to be quite affirming, and so it was a wonderful experience for the 2 terms that I served there.
And whether in the High Court or in the Constitutional Court, have you had a chance to deal with a number of matters where you have had to find legislation unconstitutional and provide an appropriate remedy?
Yes, I had to deal with a matter in the High Court. It was the matter of Rahobi and Rahobi. And it was an interesting matter, because I had to find sort of post-democratic legislation unconstitutional, and legislation that had a very good intention. It was the Upgrading of Land Act, and the idea was to upgrade forms of title that was less than ownership to full ownership, because of the past system that didn't accord full ownership. I'm not sure if you want me just to speak briefly about the case. I can do so.
Very briefly.
Okay, good. So Mrs. Rahobi lived in Winterveld, Mabopane area, and the certificate of occupation in respect of the home in which she lived was issued in the name of her brother. But she lived there all her life, and that was the only home she knew. He married and he acquired his own house. Later on, the then Bophuthatswana government upgraded the certificate of occupation to what was called a deed of grant. But the deed of grant was issued again in the name of the holder of the certificate of occupation, which was Mr. Rahobi. And then the democratic government decided to upgrade that to full ownership. But again, the full ownership would be upgraded in the name of the holder of the grant. So Mrs. Rahobi was excluded then from any claim to the property, and she would face possible eviction at the hands of a brother. And the fact that he'd acquired a property didn't matter. And it was challenged on the basis that it was firstly located historically, the original grant, which then carried a golden thread to the final ownership, was based really on a sexist, racist piece of legislation that excluded her from total consideration. And on that basis, I found it to be unconstitutional. I didn't say she had the right to the property, but at the very least, that when ownership of the property was being considered, she would have an entitlement to at least submit her claim. And Parliament should then fashion a process by which those competing claims could be considered and dealt with. And it was upheld by the Constitutional Court.
What sort of factors would you take into account if you were appointed to the Constitutional Court and the first case you had to deal with was a case where somebody wanted to have direct access to the Constitutional Court?
Acting Chief Justice, I would need to consider firstly that the design of our constitutional order is such that the Constitutional Court is the apex court, but you'd want to instill an idea of constitutionalism in all the courts. And therefore, the high courts and other courts play an important role in adjudicating constitutional matters. And therefore, the Constitutional Court should be careful it doesn't become the court of first and last instance. However, at the same time, there would be matters where the interests of justice and exceptional circumstances may exist that may warrant direct access. And there is a debate. I'm mindful that people suggest that there should be greater direct access, and some saying, no, one should ensure the jurisprudence that we seek to develop is one that's spread out evenly, and courts that sometimes have to deal with factual matters, for example, may be better placed to deal with those at the High Court level, where the Constitutional Court is not hearing evidence, they're not having to adjudicate factual disputes. And so those would be some of the factors one would take into account, mindful that it's a balance at the end of the day. Yes.
Yes, and did you get an opportunity when you were acting at the Constitutional Court to engage in reading in and reading down?
Not directly that I can recall, but then again, one is mindful in that process of the limitations that courts must accept that the constitutional framework imposes on us. That the role of Parliament is an important one. And in reading in, one does not do it to the extent that one usurps the legitimate role of Parliament. And it's a delicate balance to be struck. But sometimes the reading in of some words might mean that you deal with the mischief adequately, and there's no need for Parliament to deal with that. But I think in doing so, one must always be consciously aware of the demarcations of the roles of courts and of other organs of state. Certainly, the Constitutional Court is the apex court in our country. In the hierarchy of our Constitution, it's not the apex institution.
Thank you, Judge Colopin. Any Minister?
Yeah, thank you very much, Acting CJ, and good morning, Judge Colopin.
Morning, Minister.
Oh, afternoon, sorry.
Afternoon.
We have been sitting here since morning, so. My first question relates to the question you have given to the acting DCG. I did not hear you mention the exceptional circumstances with regards to direct access.
I think I mentioned both, interest of justice and exceptional circumstances.
Oh, okay.
Yes.
Then the second question relates to one of the judgments you have delivered, AfriForum versus the University of Pretoria, on the language policy. There seems to be some divergence of opinion from the Concord on this matter, although not at the substantive level, but in the eyes of the public. They have recently delivered a judgment on UNISA, which is, when you read it, it does look like it was more on procedural grounds and not really on substantive grounds. But in the reporting to the public, it does look like it's on the substance of the matter. What could be your view when such judgments are delivered and summary is given, that the public understand them to be what they are supposed to be, and that the progressive stance that the University of Pretoria, the University of Free State, and I think Stellenbosch took, and some of them have been affirmed by our courts, should not be abandoned?
Thank you, Minister. As you point out, I penned the judgment in the University of Pretoria matter, and I upheld the language policy of the university, both on substantive grounds, but also on the procedural basis that I was satisfied, that it satisfied the requirements in section 29.2, that it was not reasonably practicable to offer other languages. As I understand the Concord judgment, it says that the University of South Africa did not discharge that obligation in demonstrating that it was reasonably practicable to do so, and therefore on procedural grounds it almost deferred the matter back to them. But I take your point that it might, in the eyes of the public, suggest that there are different approaches to a coherent language policy in higher education. And the Constitutional Court judgment doesn't muddy the waters, as it were. It deals with it precisely on the basis that it dealt with it. But it's in how the public understand the judgment that therein lies the potential for misunderstanding and mischief. And I think the summary is helpful, but it's helpful to a limited extent as well. Because, again, even media reading the summary could get it wrong and say that this is a setback. So I think the challenge that you raise is how does, well, I think it's at two levels. Firstly, how does the court affirm the substance of transformation in our language policy at higher institutions at one level, and be clear and unequivocal about that? Secondly, it's to say, well, having done so, how do we ensure that that transformation takes place in a manner that's procedurally fair and consistent with the Constitution? And if you fail on the second leg, it doesn't constitute a failure on the first leg, and it's maybe that messaging that doesn't come out as effectively as it should. And so I think maybe there's some scope for the court in terms of its own summaries to look at that. I think how media and others report on that is important. I think how government agencies, GCIS, Justice and Constitutional Development, report on that and share information with stakeholders is also important, because the principles around which the judgment is based, the transformative nature of the project we're in, is left intact, and there should be no doubt about that. If there's doubts about that, then it shouldn't happen, and it's unfortunate that it does happen, and that's in the communication that the problem probably lies.
No, thank you. That was my first impression when I saw the media headline. It's only when I went through the judgment that I understood the procedural and the substantive aspect. But the general members of the public do not have the same kind of privilege that I might have, or some of them are not as, they might not be lawyers. They may not understand it even if they end up reading the judgment.
No, absolutely. And Minister, we must also take into account that how media report on it, some media might have a particular outcome and agenda they want to achieve. And they will put a particular spin on their reporting of the judgment to suggest that it's a substantive departure from other judgments, whereas it's not. Yeah.
Thank you, Acting CJ.
Thank you, Minister. The commissioners who are virtual, is there somebody who has a question there? there isn't on those who are virtual. Commissioner Nochesi.
Thank you. When you apply to be a judge of the Constitutional Court, there are some few things that we must understand. What is your judicial philosophy? What do you regard as your judicial philosophy?
Thank you, Commissioner. As a starting point, for me, the law must be an instrument that achieves and advances justice. I'm quite mindful that the law can quite easily be used as a basis to maintain imbalances in society, as a manner to shield people from scrutiny, and the law can be a tool of power in the hands of some. So I'm mindful and not naive that this idea that the law must advance justice cannot be distorted. Having said so, I also think that one's concept of justice is one that comes from one's understanding of a society, one's experience in that society, one's ability, perhaps, Commissioner, to understand the heartbeat and the fears and the uncertainties and the hopes and expectations of the people you live with. Those are all things that shape the content of justice. It's not purely technical. And then the challenge is, when you get into a court, you carry that with you, but you function within the constraints that the system imposes on you. But it doesn't prevent you from bringing your own philosophy into your interpretation of the law and in the work you do. But it's sometimes a challenging and daunting task, because ultimately the law is not about what you want it to be. You have an opportunity to shape it, and ultimately it's the ability to deliver justice that will determine the legitimacy of the Constitution. And for many millions of people, they continue to live outside of the Constitution. It's still something far remote in their lives. And that's the challenge we have as a society.
Now, look, taking from, say, 96 up to now, would you say, has our courts developed a South African jurisprudence, or simple, have they developed an African jurisprudence built from our Constitution? And if you say that is so, would you, rather than simply to refer to customary law cases, that's not African law, because even others are the customs of other people. I'm interested to see or to hear from you, have we managed to identify South Africa in terms of developing an African jurisprudence?
Well, I think we have paid some service to some of the values that reside deep in African society, but we haven't developed them to the extent that they form pillars of our legal system. And let me give you an example. So 1 year of this concept of Ubuntu. At the one level, it's come to mean anything and everything to everybody. Anything can be Ubuntu. And that's a distortion of Ubuntu. As I understand it, it's the recognition of our connectivity as human beings, of our personhood, and our collective identity. Now, to what extent has that become part of our law of persons, for example, of our family law? I'm not sure it has to the extent that we'd like it to, because I think there's much in that is rich and that needs to be expressed. In a judgment I wrote recently that dealt with the Interstate Succession Act, the father of a child who had died because of cerebral palsy had laid a claim to the estate of the child. And the grandmother of the child had also laid a claim to the estate together with the mother of the child. And in the judgment, I had the opportunity to reflect on the role of grandmothers in African society. And while I found in favor of the grandmother, I didn't do it purely on that basis. I did it on the basis that the Children's Act, in any case, properly read, would have excluded the father from being considered as a parent and therefore would be excluded from the Interstate Succession Act. But you might want to ask me a difficult question which I may not be able to answer now. You might want to say, Judge Colopin, if the Children's Act didn't help you, what would you have done? Would you have found a basis in African law to have come to the same conclusion you did? And maybe we don't see that boldness. Thank you.
And thank you, Commissioner. Then Commissioner Madonsela.
Thank you, Acting Chief Justice, and good afternoon, Judge Colopin.
Good afternoon, Commissioner.
Just remind me, from your own understanding, how much time have you still left to go as a judge in the country, given that your age is 64? And I'm not asking that on the basis that I have any objections to recommending people who are of a particular age. I just want to ascertain how much public service have you still got to give to the public by way of judicial service?
Okay, I think, as I understand it, I would probably have about 5.5 years to go. I would be 65 next year, May, and I would probably serve until 70. Is my understanding, yes.
Thank you.
Thank you, Commissioner Madonsela. Then Commissioner Dodovu.
Thank you very much, Deputy CJ. Good afternoon, Justice.
Good afternoon, Commissioner.
Lately in our country, there are two concepts that are used, and I want to test your understanding on those, as well as whether they do exist or not. The first one is judicial dictatorship, and the second one is judicial overreach. Contrast the two and share with us, in your own understanding, whether you see this in practical terms happening in our country.
Okay, I think in looking at the two concepts, one must frame it and locate it in at least a proper understanding as to what guides the approach to that question. And that's the principle of the separation of powers. The Constitution has clearly demarcated the role, authority, and scope of operation of the different arms of government. And the judiciary's role is not a law-making role, it's not a policy-making role. It's to adjudicate disputes. At the same time, it has the duty to declare law conduct that is inconsistent with the Constitution as such, and to fashion an effective remedy. And therein lies the challenge, because ultimately the judiciary, not because it has asked or it has taken it upon itself, but it has to exercise that role. And in exercising that role, it has to cast its eye over the conduct of the executive and the legislature. And sometimes it has to declare executive action to be unconstitutional. Sometimes it has to declare parliamentary conduct to be unconstitutional, but it does so because the Constitution requires it to do so. And so when it does so, it is not interfering in the arms but it's simply discharging its constitutional mandate. And there might be some arguments that in some cases maybe it goes too far. And if it does go so far, if it does go further than what it should, then that would be an example of judicial overreach. But I think by and large, our courts recognize and accept the limitations of the role that is entrusted to them by the Constitution. I don't certainly think that there's a case of judicial dictatorship. And if that is the perception, it's unfortunate because judges don't decide matters based on their individual idiosyncrasies. We take an oath of office, and while I have a judicial philosophy that's my own, I still function within a discipline that requires me to be loyal to the law, be loyal to the parameters of my power, and to be mindful of the role of other organs of state and to act accordingly. So I think those debates are useful, they're helpful, but I'd like to think, and I still believe, that the judiciary continues to discharge and play an important role in our society. And when there's suggestions of judicial overreach, then by all means, let's debate those.
I don't dispute the fact that the judiciary plays that indispensable role. But this question of judicial dictatorship is emerging quite strongly. Do you think that is just a fallacy, something that doesn't exist, that people are just manufacturing something out of nothing?
Well, Commissioner, I think it raises the critical question that this role that the judiciary is required to play, and this role that it is playing, has always been a role that it was required to play and has played in the last 27 years. The reality, though, is that the judiciary is now being called upon more and more to deal with issues that are highly contested, issues of a deeply political nature. And I was thinking about it, Commissioner and Acting Chief Justice, this weekend, where politicians resolve a political dispute. They do so on terms and conditions and context that is entirely different from when a court adjudicates it. So two political leaders in the same party or in different parties who are embroiled in a political dispute might look at interests like, what does this mean for the electorate? What does this mean for compromise? What does this mean for winning votes in the future? And those factors would guide how they resolve that dispute. When that same dispute comes to a court, the court looks at different factors. It looks at the facts and it looks at the law. And the expectation of the parties as to what a court may do may be quite different from when that same dispute is being dealt with by. And therein lies the inevitable problem, that when the court goes in a particular direction, there's going to be an inevitable suggestion that the courts are playing politics and getting involved in areas that they shouldn't get involved. I don't know how one avoids that charge, but that's not the case. When I sit as a judge, I don't go looking out for a case. It's a case that comes to me. And my judicial duty requires me to deal with that case.
Thank you very much. Thank you, Deputy CJ.
Thank you, Commissioner Dodovu. Then Commissioner Nyambi.
Thank you, DCJ. Afternoon, Judge Kolopen.
Good afternoon, Commissioner Nyambi.
If you can share with us what you think are the best attributes of a constitutional court judge, mainly 3 of those that you think you possess.
Thank you. I think the one, and probably the most important one, is to understand the Constitution, its location in our society, within its political, social, and economic context, and the expectations that that Constitution has created for the millions of our people. You need to understand that, because ultimately that's what the constitutional project is about. Secondly, I think as a judge, you need to be humble and patient enough to listen, to allow yourself to be open to persuasion, to be able to persuade others, to interrogate honestly and openly the arguments that are presented to you. And then finally, to be able to work in a spirit of collegiality with other colleagues, to work efficiently, to deliver your judgments timeously, and to write judgments that do 2 things. One, that deal with the dispute and deal with it properly and decisively. But secondly, and this might be somewhat contentious, to try in your judgments to articulate a proper understanding of the Constitution, and this goes to the question of the Minister, whether in writing judgments your constituency is only the parties, or whether you speak to the nation, and I think you do. You speak to academia, you speak to the profession, you speak to ordinary South Africans, and it's important for that to be part of the judgment writing process, because ultimately, if the Constitution must belong to everybody, then everybody must be able to understand what that court is saying. And with respect, you asked if I possess those qualities. I think I do, but I also subscribe to the philosophy that for me, life is an ongoing learning experience, and I've never stopped learning. So I learn all the time, and I continue to learn. But I don't think I need to still learn more to get there. But I'm saying that when I get there, it doesn't mean my learning stops, if you understand what I'm saying here.
No, I do. Thanks, Judge Kolapen. Thanks, DCJ.
Thank you. Commissioners who are virtual, is there anyone who has a question? No one has. Judge Kolapen, you said that your understanding is that you have 5 more years to go, is that correct?
About 5.5 acting Chief Justice, and this was an issue raised before on my earlier visits to this hallowed premises. Yeah.
Yes. And in 5.5 years you would be 70?
Yes.
Yes. If the correct interpretation of the Constitution is that as long as you have not reached 75 and you have not finished 12 years, you have to go on beyond 70. Would you be prepared to go on?
On that interpretation, certainly I would, Deputy Chief Justice. I'm not saying that simply to allay people's concerns. I've been very fortunate to, all my life, do work that I've really enjoyed. I really enjoy the work I currently do. It fulfills and enriches me in every way possible. I still have good health. I'm still quite energetic. And so I'm not sure what will happen in 5 years' time, but I don't think in 5 years' time I'm going to have any less energy and any less love and passion for my country. And that's been the story of my life. Yeah.
Okay, thank you. I think there are no further questions. Oh, there is just one, Commissioner Zep.
Thank you, Chief Justice, and good afternoon, Judge Kolapen.
Good afternoon, Commissioner.
You know, from the question that was raised by Commissioner Dodovu regarding the judicial dictatorship, and do you think, for instance, I mean, I know that what comes to mind is that the public still seems to misinterpret some of the judgments that come out of the court. Do you think something needs to be done by the Constitutional Court to strengthen the communication of the judgments to the public? And secondly, for me, I know that mediation can play a role, and you are one of the proponents of mediation. Do you think such matters can be actually be fast-tracked if we reintroduce mediation into the judgment?
Thank you. With regard to the first question, yes, I think, and in part I responded to Minister Lamola with regard to this question, that yes, communication can be better, and even sometimes the media summaries may speak to a limited audience. As the Minister indicated, if he read the media summary in the UNISA case, he would understand the procedural basis. But if a member of the public, if somebody living next to me read it, may well come to a different understanding of that. And so I think in that regard, it's communication at two levels, I think. The one is of the actual judgments, but the one is for people to understand the role of the courts in the constitutional architecture, because people might say, but hold on, 40 million people go to the polls to elect members of parliament. And so they carry a mandate from the people and they pass legislation based on that mandate. So isn't it unfair for 8 judges or 10 judges to set aside that legislation? That sounds undemocratic, but that needs to be explained, that it's part of the design, that Parliament must act in accordance with the Constitution, and if it doesn't, the court can set it aside. And it's not an instance of judicial dictatorship, but the courts exercising a role given to them by Parliament. So I think it's at the two levels, Commissioner, both conceptually, in terms of its framework and the architecture, and then in individual judgment. But even in the individual cases, I don't think the responsibility must be exclusively with the court. I think organs of state, and I spoke about GCIS and others, can play a role, and civil society can play a role in that regard. On the question of mediation, I think, and to some extent I should have mentioned this in relation to Commissioner Nyotesi's question, is that for a society that has prided itself in its ability to mediate almost an intractable political impasse, in 27 years we've become a litigious society engaged in adversarial litigation, where we are constantly in conflict with each other, and we don't use and embrace mediation enough. So sometimes as a judge you would push the parties into mediation, but that's not your role, because the parties can say to you, Judge, we've come here for you to adjudicate, and there must be a winner and there'll be a loser, and that's not your problem. So I agree with you, we need to find ways of embracing mediation in a much more substantive way. And the Law Commission, I think, may well be proposing that in family disputes, a matter should not come before a court for adjudication unless there's been an attempt to mediate, or unless the parties can provide a convincing explanation as to why mediation is not possible. I think we would be saving lots of judicial resources. I think we could even ask judges to be involved in mediation. So if I have to sit for 4 terms, I could be on the mediation role for 2 terms. Because aligned to your question is, where will the capacity come for mediation? So I think that there could be a resort to some judicial capacity. But aligned to that, Commissioner, you and I spoke 10 days ago at the launch of a mediation training program for lawyers and advocates in the country. And I think that's an important constituency to reach as well. Because with all due respect to them, and I'm not casting any accusation at them, Commissioner Mpofu, but lawyers may also contribute to this adversarial thing. You know, I know people who go to a lawyer in a family dispute, and the first thing they'll come back, they'll say, don't worry, we're going to sue him, and we're going to sue every cent that he has, and we'll take the clothes off his back. That's something a woman who's scorned loves to hear. And she said, that's my lawyer. But if you track the case, Acting Chief Justice, 12 months down the line, the case gets settled on a very different basis. Everybody's still intact. And I think getting the lawyers also to buy into mediation is important, because... Yes.
I'm sure you have made your point.
Thank you.
Thank you. Thank you very much, Judge Kolopen. We have come to the end of the interview. Once again, thank you for availing yourself. You are now excused.
Thank you, Acting Chief Justice and the commissioners, and thank you for the invitation and the opportunity, as well as the dignified manner in which the interview was conducted. I do appreciate that. Thank you. Thank you for your leadership here. Thank you.
Thank you. Thank you. While we are waiting for the next candidate, commissioners, may I mention that when we interview candidates for the Competition Appeal Court, we will be joined by a senior judge of the Competition Appeal Court. Arrangements have been made for a senior judge to join us, because at the moment there is no judge president in that court. The acting judge president passed on a few weeks ago, and he was going to be interviewed here for that position. But in terms of the Competitions Act, the senior or most senior judge is required to perform the functions of the judge president when the position of judge president is vacant. So I thought I would just mention that we will be joined by somebody else. Thank you. May I mention that we are at 9 minutes to 1, but it seems to me that we should do this candidate maybe before we go for lunch. Is that okay? Okay, all right. Thank you. Good afternoon, Judge Matopo.
Good afternoon, ACJ.
Thank you for availing yourself for this interview. Welcome. As you know, this interview takes place because there is an order of court that said we must do this interview afresh. And thank you for availing yourself once again. I see that you hold the degree of B.Proc, and you were admitted as an attorney in 1989, is that correct?
That's correct.
And you practiced as an attorney from 1989 until about 2006, is that correct?
That's correct.
Yes. Do you want to just refresh our memories about the nature of your practice when you were practicing?
I don't know where to start, but it's a long road.
The main features of what types of cases you did in your practice.
ACJ, I practice in Johannesburg, and my practice was 2 blocks away from the High Court. I was a correspondent of choice by virtue of my proximity to the High Court, and with the result that I was fortunate that I was instructed to do almost and virtually everything that went to the High Court, and it equipped me to be a lawyer that I am today, and it kept me busy, and yeah.
So you were in practice for about 15 or 16 years or thereabout before you got appointed as a judge?
Yeah, 16 years.
16 years. Yes. And you got appointed as a judge in 2006?
Yeah, 2006, having acted for just about under a year.
Yes. So you would have started acting maybe in
2004 and 5.
Yes, okay, all right. And then you were in the High Court up to June 2015?
I was in the High Court, in 2013, and I was invited to act at the SCA for the whole year in 2014, and I was appointed the following year in April in 2015, and I'm still there.
Yes. And during the time when you were judge in the High Court, you wrote quite a number of, or quite a few reportable judgments, is that correct?
That's correct.
Yes. Do you recall more or less about how many there were?
Oh, no, there were many.
Oh.
There were many, but
Yes. Okay. And then if you look at the reported judgments that you penned while you were at the High Court, did they cover a lot of different branches of law, including constitutional law?
Yeah, ACJ, I wrote virtually on everything, the law of contract, the law
Yes.
and as well as the constitutional law. And very early in my career on the bench, I wrote a judgment on censorship. It's the film publication matter, where I declare certain sections of that act unconstitutional, and it went to the Constitutional Court, and my judgment was confirmed through the pen of the late Justice Square. And thereafter, I had occasion to write a judgment which dealt with the arrests of a civil debtor, and that judgment gave birth to another judgment at the Cape Town High Court, and then all judgments went to the CC, and Chief Justice Mogoeng wrote a judgment which effectively did away with that section in the Act. So that section is no longer there. So then I would say I'm proud because I had foresight when I wrote that judgment. And when I was confirmed by the CC, it gave me pleasure.
I seem to remember that there were quite a few of your judgments that you wrote while you were in the High Court that were upheld in the Constitutional Court. Am I right?
Thank you. Thank you.
Yes. And then you went to the Supreme Court of Appeal, and you have been there since 2015.
Well, you would say 2014 because once I got the acting appointment, I never left that court.
Yes, okay, okay. So that makes it, what, 6 years, 7 years?
7 years.
7 years. And in the meantime, you have acted in the Constitutional Court.
Yeah, for just about 18 months.
You have acted for 18 months?
18 months.
Yes.
Yeah. When COVID struck, I was at the High Court, and I became a beneficiary of COVID and had to stay on.
You mean in the Constitutional Court? You said High Court?
Constitutional Court.
Yes. Okay. So you have stayed there for quite some time.
Yes.
How did you find the Supreme Court of Appeal when you arrived there, in terms of now doing a lot of, or doing exclusively appellate work as opposed to when you were in the High Court doing motion court, trial matters, as well as full bench appeals?
One would sit at the High Court in full bench appeals, full court appeals. So getting an invitation to go to the Supreme Court of Appeal was purely an extension of what we were doing at the High Court, except that the numbers were increased. Instead of 32, we are now 5. So the panel had to be 5. But basically, the experience at the High Court equipped me to have what I would call a smooth ride at the Supreme Court of Appeal.
Well, I take it that you have enjoyed yourself in the Constitutional Court, otherwise you would not have made yourself available.
I did.
Share with the commissioners some of your experiences in dealing with different matters in the Constitutional Court that you have dealt with, maybe 2 or 3 matters that you think are important, where you have written judgments.
Well, firstly, during my first year of acting, or first month, I had occasion to write a judgment, I think this was my first, on the doctrine of common purpose and its applicability to the crime of rape. You would remember, and for the benefit of the other members of the commissions who may not be lawyers, that principle applied arbitrarily in the sense that where there would be what you'd call gang rape, the perpetrator who penetrated would be the one who's charged with rape. So when the matter came to the Concord, when I was allocated scribe duties, I looked at it and I said, this cannot be right. Rape is a power offense. It's not only the person who penetrates who is guilty. Actually, there are people around you, around the rapist, who are violating the poor woman or the vulnerable woman there. And I said, they cannot be allowed to go scot-free. This judgment was written against the backdrop of various judgments in the High Court, judgments in the SCA. I had to distinguish them. And also, various authors of criminal law were of the view that rape would be relating to one or that person who penetrated. But when you look at it, I mean, I live in South Africa, and that cannot be. I mean, it's offensive. You could just pause for a moment and imagine that woman who's been raped, only to be told that only the person who penetrated her is the one who's going to be found guilty of rape. That can't be right. So I said, no. Fortunately, my colleagues agreed with me, and then I penned a judgment, and which now says it applies to them. And the law books would have to change and to reflect what I have said in the judgment.
Yes. And during your time in the Constitutional Court, have you had a chance to deal with matters where you invoke reading in or reading down?
Yes, I did, but not necessarily that I wrote those judgments.
Yes.
No.
But you were part of the panel.
I was part of the panel.
Yes. And I'm sure, having acted for so long, there are pieces of legislation where you've written a judgment and found the piece of legislation to be unconstitutional, and you invoked constitutional remedies.
Well, yes.
Yes, yes. Okay, commissioners. Commissioner Mwemang, have I got it right?
Acting Chief Justice.
Okay.
Good afternoon, Justice Otopo.
Good afternoon, Commissioner Mwemang.
I'm attracted to one judgment that you penned on the Minister of Justice versus South African Restructuring and Insolvency Practitioners Association. It dealt with the policy by the department, and I want to believe that it was probably prompted by the demand to transform the briefing pattern, and hence there was a need for the department to intervene. But I see that it was the policy was set aside based on rigidity and also taking away the power of the master to make an appointment, because among the issues raised in the policy was the issue of the quota. Given the fact that the outcry of briefing pattern remains, do you think that the matter could have been approached differently so that it does not contravene some of the values that you raised around rigidity, accountability? Thank you, Chief Justice.
Mr. Commissioner Mwemang, that judgment was written against the background that insolvency practitioners, okay, let me put it this way, just take a step backwards. The insolvency work used to be the exclusive domain of white insolvency practitioners. And the master when introducing those policy guidelines, sought to address the previous imbalances that obtained as at that time. But now the problem is we had to balance Section 9.2, the remedial actions that had to be taken into account to try and balance it. And they would say there's a quota system. And as you would appreciate, and it would also say that you would have a white or a black practitioner and sort of getting the work from that white practitioners. And then we felt it cannot be right. So we sent the judgment to the Constitutional Court for confirmation, and the Concord agreed with part of what we said. And last time when I was here, the minister asked me what measures can be taken to improve it. And I said, if the master can have a boss barad or a workshop with all the insolvency practitioners, and they tell him how they want to run the profession, that would address, among other things, the question that you're raising relating to briefing patterns. So we don't have to be apologetic about the fact that they must be briefed.
Thank you, Justice Matupa. Thank you, Acting Chief Justice.
Thank you, Commissioner. Commissioner Nyambi.
Thank you, Acting CJ. Afternoon, Judge Matopo.
Afternoon, Commissioner.
Let me commend you for being prompt and timeous in delivering, in dealing with urgent matters, especially the one that you touched the last time you were here. Remember the issue of COPE, Congress of the People versus Shilowa, heard on Friday afternoon. Then on a Sunday, the judgment was delivered. My question is, with your experience having acted in the Constitutional Court, what you have done with that case at the High Court, is it possible that you can take that spirit of dealing with an urgent matter and delivering judgment on an urgent matter as we have done with your experience after being part of Concord, and we have a better sense when you are dealing with an urgent matter?
Thank you, Commissioner Nyambi. I was part of the panel that dealt with an urgent matter at the Concord, which was heard on the 29th of December. And within 3 or 2 weeks, the judgment was out. So, yes, it can be done. And emphasis is it must be done. It should be done. If it's not done, then we would indirectly be failing the litigants and society. We should do it.
Thanks very much, Judge Matopo. Thanks, Acting CJ.
No, thank you very much, Acting Chief Justice. Good afternoon, Judge Matapo.
Good afternoon, Commissioner.
One of the issues that stand out from the BLA that they say about you is that you mentor young judges, and especially women judges. What does this mentoring entail? Thank you very much.
Commissioner Mangwaneshi, it means you go down to the level of a mentee and ascertain and what his or her limitations are, and try and assist and upskill, and also affirm. The most important thing is to affirm people that they can do it. mentoring women judges is because there is a stereotype amongst the legal fraternity who believe that law-making or lawfare belongs to men, and that stereotype has to be put away. So that is what I had identified as something that has to be confronted head-on, and to that extent, I have ran numerous courses, seminars, so that women can be equipped and be on the bench the same as I am, because I believe in one thing, that we cannot sit here and pretend and say women are inferior. They're not. They actually are. They help us and capacitate the bench much more, and they are much more heads-on and hands-on as far as determining other issues are concerned. So that's what I do. And over and above that, I've had the privilege of being, to use the word, exported to other countries to go and teach. I've been to West Africa and under the auspices of Sajay and with JP Mlambo having organized it. I've been to Lesotho, I've been to Botswana, teaching and explaining how South Africa operates. So this is what I do, and this is what I think I should continue to do.
Thank you very much, Judge Mutapa. Thank you very much, Acting Chief Justice.
Thank you, Commissioner. Judge President Mlambo.
Thank you, Acting Chief Justice. Good afternoon, Judge Mutapa.
Good afternoon, JP.
I'm going to be raising a question with you that's been raised with other candidates. And that relates to the delivery of judgments. I'm raising it with you because you are a member of the SCA. Can you compare the turnaround times in terms of delivery judgments of the SCA to the Constitutional Court?
Yes.
Please tell us.
We have an unwritten rule at the SCA that come end of term, to the extent practically possible, judgment must all be delivered. If there is one or two outstanding, it can be as many as 4 or 5. So colleagues know that judgment has to be delivered promptly. Now, you would want to ask me why at the CC you would have judgments being delayed for quite some time in ordinary period. It's a vexed question. The court tries, and colleagues try their best to ensure that judgments are delivered as promptly as possible. There's a lot going around in terms of when your first draft is circulated, colleagues would comment, colleagues would suggest a particular angle that you must follow. You would consider the comments of the colleague, and other colleagues would also give you their comments. It is in that exercise that you would see some of the judgments being delayed. And regrettably, I would say, yes, you would argue that we could do it differently, but the court tries. I would be remiss if I say they don't, the colleagues don't try. Sometimes, much to my what is the right word? To my displeasure when the judgment takes a long time. I've been somewhere there as well, so it works hardship when the judgment is not delivered promptly. Remember, we've got norms and standards. So one has to look at the norms and standards and say, we're not different from other courts. We should try and toe the line and deliver judgment as promptly as possible. At the SCA, we try, and we do our best to do it. And the Concord, it's understandable why, in some instances, judgments are not delivered as speedily as possible. But I think more should be done to ensure that they are.
My second question, Acting Chief Justice. I've heard your response, and you seem to think I was leading us to the reasons why it's like that. I just wanted you to tell us the facts that can you compare the two courts? But here's my question now. You say you believe that more can be done, but isn't it correct that that's the apex court and that's the last court where people go to? More often than not, judgments there don't come out before 6 months. They actually take longer. Am I correct?
Yeah, that's correct.
And do you agree that the way that court considers judgments after hearing argument needs a serious revamp about how to go about ensuring that judgments come out timelessly?
Well, anything is possible. If anything is humanly possible, if you put your shoulder to the wheel. But some judgments, and there are reasons why some judgments delay, it's through no fault of the colleagues. You would write a judgment, and a colleague would make his or her comments. You would be engaging the colleague with that comments, and lo and behold, the time would fly. But yes, I agree that more needs to be done. When I was there acting, this is one of the issues that I lamented, and this is one of the issues that I addressed with a senior judge to say, where I come from the SCA, judgments are delivered as promptly as possible. Why are we having this delay in this judgment? And the senior colleague that I spoke to also said, yes, it's not acceptable. We should make sure that we deliver as speedily as possible. I agree. We should do more.
Thank you. One more question, CJ, if you don't mind.
Yes, yes.
This has got nothing to do with you, Justice Matopo, but one of the judgments you have listed is the Premier Gauteng and others DA case. Were you the scribe in that matter, and has that judgment been handed down? It was heard on the 10th of September last year.
Yes, I'm the scribe in the matter. I'm told it was delivered this morning. It would have been delivered many, many months ago.
I see.
But it's attributed to the factors that I've raised. My judgment was out a couple of months ago. And if colleagues want to comment, colleagues want to make suggestions, you should engage and accommodate them.
Thank you, Acting Chief Justice.
Thank you, Judge President Mlambo. Deputy President Petse.
Thank you, Acting Chief Justice. Good afternoon, Justice Matopo.
Good afternoon, DP.
Earlier, you made a reference to the doctrine of common purpose insofar as it relates to crimes of rape. And you mentioned the case that you wrote. My question to you is, what would your response be to someone who says that far from you developing the law, you in fact turned it on its head?
That person would not be living in South Africa. That person would certainly not have seen or experienced what our women are experiencing. And that person's comment would be an affront to the women in our country.
Thank you. My second question to you, you mentioned earlier that you have been at the SCA for 7 years, and currently the complement of judges there is 25, headed by the president of that court. Justice Meyer as number 1. How high up the hierarchy in that number between 1 and 25 are you currently?
I'm now part of the Big Five.
I think he doesn't like top 6, he prefers Big 5.
And how do you find it now that this is where you are at the moment? Has that in any way had a bearing on the responsibilities that you have had to assume?
Oh yes, and now I now have occasion to preside in matters, and that has thrust upon me a huge or tremendous responsibility to ensure, i.e., that judgments are delivered on time. I run the court with the proper decorum befitting a court, and that the counsel who appear in the court are given the utmost respect and the time that they need to present their cases. Not necessarily that they were not given time.
And then lastly, through you, Acting Chief Justice, and I take it that that has somehow changed your perspective in relation to the top 6, or so-called.
I think the issue about the top 6 was taken out of context and misunderstood. I said in my previous interview that it is not through any fault of the colleagues who happen to be at the top that they found them there. It's through years of experience that you end up in there. That is why now I am in the Big 5. And the others have left through a process of natural attrition. So that's what happens.
Thank you, Justice Matopo, and thank you, Acting Chief Justice.
Thank you, Deputy President Petse. Before I go to Commissioner Madonsela, after whom I'll go to Commissioner Malema, let me check commissioners who are virtual, if anybody has any question.
Singh, Acting Chief Justice.
Yes,
Writing
Commissioner
Singh. Acting Chief Justice.
Okay, thank you. Commissioner Singh.
Thank you very much, Acting Chief Justice. I'm glad that at last, after serving many years on this commission, that we have a different understanding of the top 6 as we had right in the beginning, because the top 6 in the beginning didn't have a similar function as the top 5 that we have now. Thank you very much, Justice Matopo. Thank you. I'd just like to compliment you on your commitment to ensuring that we have a judiciary that is more representative on racial and gender lines. Now, I'm going to give to you a hypothetical scenario. You are conducting an interview, and you have a male and a female who've done both, who are both suitable for appointment. They've done well in their interviews. Who would you be considering or recommending for appointment in a hypothetical scenario? That's question 1.
Commissioner Singh, one has to look at the historical imbalances. And we have to ask ourselves and look at the composition of the bench. Where are we and where do we stand in terms of gender sensitivities and otherwise? If you have 2 candidates, both male and female, and then you look at the numbers and you realize we have not advanced the numbers, you would have the courage to say it is about time that the male candidate must stand down and the female candidate be promoted. Nothing wrong with that.
No, thank you very much. My second and last question, Acting Chief Justice, will be, Justice Matopo, you know, we who sit on the outside and we are not lawyers and, you know, like you are and others, sometimes get a bit confused, miffed, perhaps that's not the right word, about minority judgments, although it is a right at the CC level. What is your view on minority judgments and the message it sends to the public? Thank you.
Well, minority judgments, since time immemorial in the legal profession, have been there, and they should be there. Remember, I said a minority judgment today can be law tomorrow. And it is important that those minority judgments be written, and colleagues must express themselves as to how they differ or they concur with the other judgments. Society would be enriched to know that the Constitutional Court, not because they sit and bank, they just decide like sheep to the slaughter and say, no, we follow this and this is the conclusion. No, we should write minority judgments, and there will still be minority judgments. Not in the Court, in all the courts. In the SCA, we do have minority judgments. I would encourage it.
Thank you,
Thank you,
Commissioner
Chief
Singh.
Justice.
Thank you. Was it Commissioner Breitenbach who also indicated she had a question?
Yes, thank you, Acting Chief Justice.
Yes.
Good afternoon, Judge.
Good afternoon,
Matoko.
Commissioner.
How are you?
I'm good, and you?
Fine, thank you. What, in your view, is the single most important attribute of a constitutional court justice, and why do you hold that view?
There's one only. You've got to be independent, fiercely independent.
Thank you, sir.
Thank you, Commissioner Breitenbach. Commissioner Matonsela.
Thank you, Acting Chief Justice, and good afternoon, Justice Topo.
Afternoon, Commissioner.
What is the value, if any, of a judge acting in the Constitutional Court before making himself available or accepting nomination in that court?
I'll give you answer in two ways. The first is, having acted at that court, I had a fair understanding of the workings of that court, and coming from the SCA, where things are done slightly different from the Constitutional Court, I then realized that there was value in me being afforded the opportunity to act in that court and understanding how applications and judgments get written and delivered. Then there's this same side of the coin. We have Justice Matlanga there, who never acted at that court, as far as I can recall, unless I'm wrong.
Actually, he did.
He did? No. All right. No, then I withdraw.
In his previous life.
No. Okay, in his previous, then I withdraw.
Well, I may be wrong, but I think Justice van der Westhuizen, who has retired, was appointed without having acted.
Yeah, straight from the High Court.
Yeah, if I'm not mistaken. Okay, all right. Okay. I was hoping for one question only.
Okay, I can forfeit my. It's not.
No, I'm not putting pressure. Okay.
No, I'll leave to other commissioners.
Okay, no, that's fine.
In the interest of time.
Okay, Commissioner Malema.
No, thanks. I think you've dealt with this question, Judge, but I just want to satisfy myself. This thing of norms and standards, they only apply in High Court and to a particular extent SCA, or they also apply at the Constitutional Court, because my layman's understanding of those norms and standards is that in 3 months' time after hearing the matter, you should give judgment, and if it goes beyond 6 months, then the head of court must start now being alarmed, and there's a point where you even have to now start reporting to the JSC if there is no movement. But let's take a matter like the rescinding judgment of the Constitutional Court, where the judges are told, lawyers, within weekend, you must do the impossible, and then the matter must be heard. It's got to be heard, and then the Constitutional Court just take time. An impression has been created in the country that, you know, this matter, the way is so urgent. People are even called on Saturdays to do this and that. And then the Constitutional Court just goes quiet on us. The country is burning. There is uncertainty in the country. How do we deal with that? Where is these norms and standards? Because leadership yourselves at the Constitutional Court, you must lead by example. It can't be that certain people at the lower level must behave differently, and you ask people to do that which you can't do. So I just need some clarity there so that I can be comfortable knowing that all of you, these norms and standards are not just created for some high courts only, and then constitutional courts have got their own norms and standards, because all of you come here say to us, you know, it's very difficult, the colleagues must do this and they must do that, as if it is justifiable for constitutional court not to be within the norms and standards. And if the norms and standards don't apply to the constitutional courts because of those dynamics that you are trying to take us through, let us be told that no, these norms and standards can apply because dynamics are different. So we know we don't hold you according to the norms and standards.
Commissioner Malema, it's a fair and valid concern that you're raising. It would be remiss of the judiciary to have norms and standards which are applicable to other courts and not applicable to the Constitutional Court. I think the ACJ is here, and he's aware of the concerns raised by not only you, by other members of the commission. I think when he goes back, he will take it to the justices to say, this comment or this concern has been raised. Let's try and be as expeditious as possible. It's a fair comment.
Thank you. The last one, Acting CJ.
Yes.
This principle you applied on male and female, where they both perform well and in line with the empowerment and the historical background of where we come from. Does the same principle apply on white and black male? Because, you know, there is an impression created here that if you perform well and a white colleague as well performs well, and we appoint a black male on the basis that we want to address the historical imbalances, we are wrong to do that. So if there is a black male, a black male and a white male, they are both suitable and they've performed well in this interview. Will we be wrong to go now beyond the issue of performance to look at the historical background and how we seek to transform the judiciary and ensure that the previously disadvantaged, they too participate at that level?
I think, Commissioner Malema, the Commission mandates you to do that, to go a step further, and unapologetically so.
Thank you, Acting CJ.
Thank you, Commissioner Malema. Commissioner Pofu.
Thank you, DCJ. DCJ, my hand was up before Commissioner Malema, but I don't know which standards you are applying.
well, Commissioner Pofu, let me make a confession, but it's not a confession. Somehow I see your name was scratched here. When it was under 6 and Commissioner Malema was under 7, but yours was crashed. I don't know how it happened.
No, I think no, I'm complimenting you. But just to say, those other standards don't apply here. Thank you, Commissioner, Judge Matopo. Yes, I'll also ask you one question. I ask one question because my questions come with preamble. What Chief Justice Mogoeng called preambles. Now, mine goes to the question of transformation, which, thanks to the fees must fall generation, is now fashionably called decolonization, I think, and more properly so. You have spoken about debunking the myth that, for example, only men can be good lawyers or good judges, which is a belief that was held, and I'm sure some people even still hold it. But my view is that, you know, if we don't transform, we'll never know, because we don't get into the unknown. And I want to ask that question in relation to the time when you started acting. It was believed that judges, good judges, can only come from the ranks of advocates, and even not just advocates, senior counsel at that. And I say here, because we can demonstrate it here, that that myth was completely misplaced. Sitting here on my right, these luminaries, legal luminaries, would not be sitting here if that myth had not been debunked, because all of them, including the minister even, came from the ranks of attorneys. Now, the real question is this: do you think that in the spirit of decolonization, we should still have this divided bar of advocates, attorneys, and more particularly in relation to access to justice for the poor and black people? The idea that you must now have two lawyers, you must have your attorney, and then you must have an advocate. If you want, you want. That's a different matter. I'm talking about it being compulsory. What does it do to access to justice, and what can be done to debunk that particular remaining myth, or what we inherited from the colonial legal system?
The reality of the situation, Commissioner Mpofu, is with the advent of the Legal Practice Act, the resistance that the profession has is from members of the bar, the likes of, should I say, you and Madonsela and the others, who do not want to embrace the fact that attorneys are as equally capable as advocates. And I've said this before, and I'm going to say it now. It really doesn't make sense to me, because advocates get their work from attorneys. But then they want to push this unequal treatment. And what it does, correctly, it impacts on access to justice, because the poor client has to pay 2 lawyers to get his case or a case to a court. That is not right. I think the profession must take a journey into itself, interrogate the issues, and say, let's debunk the myth, let's discard and do away with this dichotomy, which is not helping at all.
Thank you, Chair.
Thank you, Commissioner Mpofu. Then Commissioner Nochesi.
Thank you, SJ. Commissioner Malema has stolen all my questions. So
happy
I have nothing left.
Hey, I'm so happy you stole all your questions. Well, Commissioner Malema, do it again. Commissioner Schlemmer.
Thank you, ACJ. Good afternoon, sir.
Hey, good afternoon, Prof.
Are you well?
Yes, as well as you can see.
I would just like to know from you, when the JP Lombo asked you questions, you said there were 25, or I think it was the Deputy President, there were 25, or there are 25 judges at the SCA, and we only have eventually 11 at the Constitutional Court. As part of the Constitutional Court being the apex court nowadays, don't you think there should be an increase in the number of people at the Constitutional Court? Or is there something else that we need to do to assist with, I think, the workload as well as the delays that is coming, that we experience?
I hold drastic and aggressive views to that question. I'm not sure if I can share it with you, but because you've asked me the question, I think it talks to access to justice. You may say, do we need 2 appellate courts? SCA as well as the Concord. I hold the view that I think the time has come. We should seriously look into the question of whether the 2 courts cannot be fused, and so that the people can access justice quite quickly and speedily. And let me perhaps share with you how I look at resolving the issue. You have judges retiring at both courts, right? If you hold that view, you don't replace them. You would have a model where you would say you want the Constitutional Court to comprise X number of judges. And if, say, for example, you say 15 judges for argument's sake, as and when judges retire at both courts, or say 20, you don't replace them. Then you would have a Constitutional Court that would run dealing with all cases that were exclusively belonging to the domain of the SCA and also at the Concord. And then you would look at whether you would have that panel comprising 11 or you reduce the number of panel. That's a huge, like I said, it's a drastic measure that would require the intervention of the minister and all the role players to decide whether you need that or not. So in short, that is my answer.
Thank you, I appreciate that.
Thank you, Commissioner Schlemmer. I think we have, there is one more question, Commissioner.
Thank you, ACJ. Good afternoon, Justice Matopo.
Good afternoon, Commissioner.
Justice Matopo, thank you so much for your commitment in training women acting judges and the practitioners. And I can attest that also Saula invited you not so long to train its members on trial advocacy, and the interest there was very high. That shows that women legal practitioners take training very, very serious. But the challenge that we are having, Justice, I hope you also know that one, it's the exposure of women legal practitioners in other field of the law. I know there are people who are watching these proceedings who might assist in this one. What advice can you give on what should be done to make sure that women legal practitioners are exposed enough in these other legal fields so that we can achieve the transformation that we all want? Thank you.
This question talks to briefing patterns. We have been agitated for quite some time that briefing patterns should change and previously disadvantaged practitioners should be given briefs. In the commercial world, we don't get those instructions. Banks, corporate South Africa has not fully embraced the competency of black practitioners. It's a sad indictment. That said, you have the state attorney's offices, right? And the Department of Justice is the largest or the biggest consumer of legal services. I remember when I was in Johannesburg, I took it upon with the state attorney to say, have a roster or a system wherein you could brief women lawyers, and not brief them in terms of the numbers, brief them in terms of the quality of the work, so that they can improve, they can be upskilled. I was given the assurance that it was done, and when I see the advocates appearing before us in courts, it's not happening.
Thank you, Justice. Thank you, SJ.
Thank you, Commissioner Mapisa-Nqakula.
Thank you very much.
Oh, I'm sorry. Yes.
I just have a follow-up on the last
Oh, okay, all right.
response.
Okay, because it referred to the department.
Yeah.
Okay.
But also because his answer also refers to the judgment that he delivered on the insolvency practitioners, where he declared in particular what is almost like a court assisting. And in his answer, he wants us to do exactly that he declared to be unconstitutional. so that's why I want this follow-up that.
Well, Judge Matopo, the minister is saying, in other words, if you thought because it's this time they are sleeping, they are not sleeping. They are listening very carefully.
It is noted.
I wanted to say the Minister Masenwar will do a rescission.
Okay, all right. Commissioner Mapisa-Nqakula.
Thank you very much, DCJ. Good afternoon, Judge Muto.
Good afternoon, Commissioner.
I thought that was very magnanimous of you to suggest that, yes, if you have a woman candidate and a male candidate, and even if they perform at the same level, that you would give to the woman candidate, so that we can address the imbalances.
You might wish to speak up.
So that we address the imbalances of the past. I really thought that was, if I don't say it, I won't feel good about it. But there's this, I'm following up now on a matter which you just raised before you answered the last question, which is fusing the two courts, the SCA and the Constitutional Court. Now, I'm talking from a layperson's point of view. I'm sitting here, and for some of us who've served in some of these areas, other than what you are doing, when a case goes to a constitutional court, I can assure you, I'm telling you now, once you hear your case has gone to a constitutional court, somebody has taken you there, you immediately, your reaction is that, oh my Lord, whatever decision they take, it is final, I cannot challenge it, it is the end of the road. Okay? Now, I may as well be speaking on behalf of those who are serving in the other arms of the state, which is your legislature and the executive, but maybe ordinary citizens as well. So my question then, if you're saying there must come a time where you fuse the two, what happens? What happens to the ordinary people who believe that, okay, in Judge Mlambo's court at the High Court in North Gauteng, I may have lost this one, then what does it mean? It then goes directly to the Constitutional Court if we are to fuse the two. And of course, when it comes out a ruling, there's nothing you can do, because we all say that's the apex court, there's nothing you can do, you have to abide by the decision of the court. I know you've given this a thought. It's something which has, I'm sure, preoccupied you over a long period of time, but I can assure you that in the same way, other people who are elsewhere, who may be affected by that, would be concerned. I'm just throwing it. Thank you. And I did say that this is from a layperson's point of view, so I need help.
Perhaps let me try and allay your concerns. And to do so would be to give you the hierarchy and the structure how court cases progresses until they get to the Concord. You would have a case litigated at the High Court. If it's a single judge, that decision would be taken to a full bench comprising 3 judges. And then if there's a further appeal, it goes to the SCA, 5 judges. And the last appeal goes to the Concord, 11 judges. So the problem that a litigant may face is, may not have the money to be litigating all the way from the Constitutional Court until from all the way to the Constitutional Court. And that may impact on that litigant's access to justice, because we say, I don't have the money to go with my case, and then becomes a problem. But if the litigant knows that the route to the top has been short-circuited by legislation, and the litigant would have comfort and confidence that my case will be heard as speedily as possible. But if it has to go via Bloemfontein and come back to Braamfontein and I'm in Joburg, that's another problem.
Actually, Joburg is too close to Braamfontein. Imagine Polokwane to Braamfontein.
I think we are done with this interview. Thank you very much, Judge Matopo, for availing yourself. We appreciate it. I will now excuse you. Thank you very much.
Thank you, ACJ.
Thank you. We are at 9 minutes to 2 on my watch. I guess we should take lunch now. Shall we agree what time we should be back? 2:30? Okay, 2:30, it seems there's agreement. Okay, we'll come back at 2:30. Thank you. Good afternoon, Judge Mulumela.
Is it on?
Okay, we can hear you.
Okay, thank you.
Yes.
Good afternoon, DCJ.
We'll just wait for a few more commissioners before we start.
That's fine, DCJ.
Okay.
Thank you.
Let us start. Once again, good afternoon, Judge Mulumela.
Good afternoon, Acting CJ.
Welcome to this session of interviews.
Thank you.
As you know, it's being held because the court said we must have a fresh interview. So thank you for making yourself available once again.
It's a pleasure, DCJ.
I see that you have quite a number of degrees here. You got your BA degree at the University of Fort Hare, is that right?
Correct, DCJ.
And as well as the BProp degree.
BProp, yes, that's right. That's right, yes.
Yes. And then you got your LLB
Yes,
at the Free State University.
That's right. DCJ.
And then you got your LLM
That's correct.
at the Free State University. And you were admitted as an attorney and practiced for about 10 or 12 years?
12, DCJ.
12, yes. And you were appointed as a judge in 2008 after you had acted for some time.
Yes, DCJ. I think if my calculation is correct, it's 15 years.
Of practice?
That's right.
Oh, yes.
Yes.
Okay, okay. You were appointed in 2008 as a judge of the High Court, is that correct?
Correct, DCJ.
And that means you have been on the bench for about how long? About 15 years?
If you
From 2008?
Yeah, from 2008 it would be 13, but if you include the acting appointment, it's 14.
Yes, okay, okay, okay. And you were subsequently appointed as Judge President of the Free State High Court.
That's right.
And how long did you serve as Judge President of the Free State High Court?
For 3 years.
Yes. And during that time, you also got an opportunity to act in the Constitutional Court, is that right?
That is correct, DCJ.
Was that 2015?
That was 2015, that's right.
Yes. And was it for 2 terms?
It was for 2 terms, yes.
Yes. And I see that you have also acted in the Labor Appeal Court and in the Competition Appeal Court.
That's right, and I ended up being appointed, I acted from 2011 at the Labor Appeal Court and got appointed there in 2014.
Yes. And then how long did you remain there before you were appointed to the Supreme Court of Appeal?
Remain there as...
In the LAC?
No, I was never at the LAC, and I think I need to explain because it seems sometimes people don't understand. So when you are appointed as an acting judge of the Competition Appeal Court or of the Labor Appeal Court, you don't really have to leave your division. Let me start with the Competition Appeal Court. The cases are accommodated within the court term of the High Court, meaning that you will be excused only for the days on which you will be sitting in the Competition Appeal Court. Say now, if your matter is going to be heard over 2 days, it means you will miss 2 days from the division.
Yes, but I thought you said you were appointed, because even though it might work like that, it's different when you are acting and when you have been appointed. Yes. As a judge of appeal in the Labor Appeal Court. Yes. Were you appointed as a judge of appeal in the Labor Appeal Court?
That's right, yes.
Yes. Yeah,
while I was still serving as a judge of the High Court, that's right, yes.
Yeah, you didn't physically leave the High Court, but
that's right.
you were not acting in the Labor Appeal Court. You were found to be fit to be appointed.
That's correct.
Yes. And but how long was the period that you were a judge of appeal in the Labor Appeal Court before you were appointed to the SCA?
4 years. Sorry, yes, 4 years.
Yes. So you would sit as and when you were required in the Labor Appeal Court?
That's correct, decision.
And in the Competition Appeal Court, were you appointed as a judge of that court, or you were only acting there?
I only acted. I acted there for 2 years, but like I explained, it would mean I would go to Cape Town only for the hearings and then come back to the division and continue with the work in the division.
Yes. So you have experience in the High Court, you have experience in the Labor Appeal Court, you have experience in the Competition Appeal Court, and you have experience in the Supreme Court of Appeal.
That is correct, DCJ.
Yes. And how did you find the work in the Supreme Court of Appeal after you had been appointed there?
I enjoyed the work very much, DCJ. Intellectually challenging, but I coped. I think I managed to cope quite easily with the workload because having been a judge president at the Free State High Court, I had to do both management of the court and the other courts, the lower courts, about, I think, 70 or 80 lower courts that fell within the jurisdiction of the High Court, and that I remotely had to manage in addition to running the division. And in addition to that, I also had to do the work itself in terms of going to court and so on. But then as a judge president, you have to lead from the front, which means that when complex cases were on our roll, I would make sure that I participate on them. Some of the cases, we would do them as a full bench, meaning it would be me and 2 other judges, and others I would be the sole judge. And in circumstances where I was not involved in that particular case, I would, in any event, make sure that I familiarize myself with the issues, because sometimes it happens that a matter has been set down and a colleague gets sick. And so I was always on standby to do the work. So I always did extra reading in addition to what was on my own plate. I would also read other matters just to be in a standby position. And so I found that when I got to the Supreme Court of Appeal, I was able to manage. The workload there is quite hectic, but I managed easily to do the work. Yeah, so I would say that the jurisprudential leadership that I brought from the High Court, having been the judge president, assisted me. And when I got to the SCA, I managed to flourish. I managed to write not only, judgments where we were unanimous. I also wrote dissenting judgments, and 4 of those dissenting judgments that I wrote at the SCA were confirmed by the Constitutional Court. And I would also add that, having acted at the Constitutional Court assisted me also in terms of the performance of my work at the Supreme Court of Appeal.
When you were judge president in the Free State High Court, what was the complement of judges in your division?
I think 16, if I'm not mistaken.
16.
It might be 16, I think.
Yes. And while you were in the High Court, were you able to write some reportable judgments as well?
Yes, as a matter of fact, there's a judgment that I wrote at the High Court, and the parties did not appeal against the judgment. I'm not sure whether they did not appeal or whether they tried going to the Constitutional Court and they were denied leave there. But the matter was concluded at the High Court. And years later, a matter similar to that one was heard by the Constitutional Court. And the Constitutional Court, in a judgment authored by Justice Petse, made several references to several paragraphs of my judgment. In other words, that judgment was also confirmed by the Constitutional Court, and in that way contributed to the jurisprudence.
Do you have a recollection of more or less how many reportable judgments you were able to write while you were in the High Court?
I'm not, no.
You are not able to?
No.
And in the Supreme Court of Appeal?
I'm sorry, I didn't count DCJ, but I think when I read, it doesn't matter. Okay, when I read the report from the General Counsel of the Bar, I think they talked about 12 matters, and they said I was involved in 84 other matters. It's actually more than that. Yes.
And how was your experience of acting in the Constitutional Court in 2015?
It was a very enriching experience, DCJ. I enjoyed that stint. I found the workload quite challenging at the time, but I managed to do everything that was on my plate. And in addition to doing the work, I also managed to do a prison visit and, even compiled the report in respect of that prison visit, and it was published before I left. Meaning, in addition to the workload that I was doing there, I also managed to accommodate something extra, because Justice Cameron was always at our conferences at the Constitutional Court, encouraging colleagues to do prison visits. So even though the work was challenging, I enjoyed it very much. I found it fulfilling, and I left that court a new person. And I have always maintained, and I think I've said this at this platform previously, that, when you act, it's not only a matter of yourself, the person who's acting, getting personal growth, but wherever you are coming from, be it the magistracy, be it the bar, be it the High Court in my instance, everybody benefits. Because when you go back, you are not the same person. You go back with a level of expertise, and colleagues, approach you to say, let's say for some guidance in respect of their matters. And so the whole division benefited from my acting appointment. So not only did I benefit, but the whole division benefited from that.
Yes, and I'm sure when you were acting in the Constitutional Court, you dealt with a lot of matters where applications for direct appeals were made. What sort of factors were taken into account in deciding whether to grant direct leave for direct appeals?
The interests of justice, and whether there are any exceptional circumstances that warrant hearing the matter, meaning that you would have to exercise a discretion. And as to whether you would grant it or not would depend on the contents of the application that's served before you.
And did you get a chance to write judgments where you declared legislation unconstitutional
That is
and
correct.
granted appropriate relief?
That is correct, DCJ, in the matter of Provincial Minister versus Oates Warren.
Yes.
Yes.
And in that case, did you have to deal with Section 36 justification exercise?
No, I didn't have to deal with that. In that matter, DCJ, the parties actually were agreed that there was a loophole in the section. The minister had initially opposed, the municipality had initially opposed the matter, but later on there was some sort of, let me call it in quotes, settlement, in the sense that the minister agreed that he was no longer going to ask for that order in terms of which all the actions that had been done in terms of the resolution that was, the flawed resolution that was taken would be set aside. And as soon as, there was an agreement in that regard, both parties were agreed that the legislation was flawed and that particular provision had to be supplemented. And it had to be supplemented by way of a reading in. But even though the parties had agreed, you'll see in the judgment that we still investigated that whether there was a need to do that, because we are always careful of treading into the sphere of another arm of state.
Well, you would have been involved, even if you didn't write the judgment, you would have been involved in judgments written by other colleagues where the Section 36 justification exercise would be done.
Yes.
So you were involved in such matters?
Yes, DCJ.
Yes. Okay, thank you. Commissioners? Commissioner Nyambi?
Thank you, Acting Chief Justice. Afternoon, Judge Molemela. I must say I'm impressed about the detailed CV. Somebody who has been a prosecutor, candidate attorney, director, Molemela and Partners, commissioner of the CCMA, judge in the in Free State, and a judge president, and now a judge in the CA. So with that experience, I will ask just one question. Judge Molemela, if you can share with us some of the stereotypes you have had to deal with as a woman judge, and how you have managed to stay focused, professional and competent, given the current, the historical and current challenges still experienced by women in our country.
Excuse, just for clarification, does that include before I was appointed as a judge?
Yes.
Oh, okay, yes. Yes, I did, like so many other women, experience those challenges, where as a candidate attorney, I had to do certain kind of work. And my principals specialized in criminal law. But in terms of the consultations with the clients, I would be the first port of call, and I would have to take the client's statement. And I remember that on many occasions, the clients would say, but you are a woman. Are you sure you can do what a man can do? And I said, yes, I'm qualified. But there were those stereotypes, and some actually would tell you point blank, I do not feel confident being represented by a woman. So, and I now, with the benefit of hindsight, I know that that is the one challenge that has been a hurdle in the careers of many women, where you found yourself channeled to a particular field of law, which is regarded as soft law. For example, maintenance matters, divorces and so forth. And as a result, many women were not able to get exposure in commercial law and so forth. And at the end of the day, that is also what is responsible for the situation that we have had over many years, where the judiciary was not representative in terms of gender, simply because the pool from which female judges could be appointed was very small because of lack of exposure. The situation is being addressed. At some quarters, it has been addressed. But I must say that once I was appointed as a judge, I can't really say, I would not be telling the truth if I would say that I was discriminated against purely because of my gender. That has never happened. Where there were disagreements, it was not purely because of my gender. It was just disagreements as you would disagree with your brother or your sister, your mother, or your spouse.
Thanks, Judge Molemele. Thanks, Acting Chief Justice.
Thank you, Commissioner. Then Commissioner Madonsela.
Thank you, Acting Chief Justice, and good afternoon, Judge Malumela.
Good afternoon, Commissioner.
You have had the experience of being a puisne judge as well as a leader of the division, and you have acted in specialist courts in the LAC and the CA Competition Appeals Court, as well as in the SCA. You've acted also in the Constitutional Court. Tick all the boxes. Ideally, one would think that in a country like ours, with the mind that we have in people like you charting the way in the legal field, we would not be having so many appeals in the court systems, in the hierarchy of courts, because the law is or should be known. Now, as a judge in the apex court, like the Constitutional Court, is a judge that lays down precedent and rules for the courts below it. Now, how can one be assured that the Constitutional Court retains its precedent-setting authority, with the result that there is no doubt and there is no litigation that goes up back to the Constitutional Court on almost the same issues, or even, if I may suggest, why are we not having a limitation of number of appeals when we have a court of authority like the Constitutional Court? Will you be able to give your views about that?
Yes. Sometimes people will do things because they are allowed to do those things. There was a stage when the jurisdiction of the Constitutional Court was limited only to constitutional matters. And I don't think the workload was hectic at that stage. And then there were several consultations were held, and then it was decided to open it up. And when its jurisdiction was opened up, it was opened up to include matters where arguable points of law were being raised and they were found to be in the public interest. And once that happened, then things changed because more and more people felt that they deserved to approach the highest court and for their matters to be finalized there. So even in instances where the jurisprudence is really clear-cut, you will find people applying for leave to appeal at the Constitutional Court, and the application in most instances will be dismissed, but they will try. So in answering you, I will say the fact that that court is being buffeted by application is not because the jurisprudence is not clear-cut. It's because we have many, many cases coming from all the courts, and sometimes litigants insist. And even if, I think, even if you as a representative say, you know, I don't think we are going to succeed there, then they terminate your mandate and go to the next one who will agree to go there.
Thank you, Commissioner. Then Commissioner Dodovu.
Thank you very much. Deputy Chief Justice, good afternoon, Justice.
Good afternoon, Commissioner.
Do you subscribe to the philosophy of judicial activism? Do you think that we need that in the context of the challenges that are facing us as a country?
Thank you, Commissioner. I would say there is sometimes scope for judicial activism, but generally one must shy away from it, you know, respecting the separation of powers, which is what the Constitutional Court has been doing in many, many cases. And, you know, given how liberal, I mean, our constitution, the South African Constitution is one of the most liberal constitutions that you can find anywhere in the world. And because of that, there's very little need to resort to judicial activism, because everything that needs to be done in terms of judicial activism is already contained in the Constitution. Let me make an example. The Constitution has several values, and one of them is social justice. Pre-Constitution, those who were resorting to judicial activism were doing so in order to achieve social justice, in order to achieve equity. Let me make this example with the judgment of Justice Schreiner in that matter, the Collins case, the 1957 case. At that stage, our country was a country in which the Parliament was the most supreme body. In other words, courts did not have the leeway to test the constitutionality of legislation. And in his dissenting judgment, Justice Schreiner found a way of deciding against the particular piece of legislation that was intended to exclude colored people from the voters' roll. In other words, despite parliamentary sovereignty, he found a scope to decide against that. And that you would call judicial activism. It was good because at that time, the system that we were under was the apartheid system. There was no justice, there was no equity, there were no human rights that were being observed. But in the context of the Constitution that we have today, that allows you to take social justice into account, to take into account substantive equality when you make your decisions, there's very, very little scope. But the one example that I want to make where I personally resorted to some form of judicial activism was in one of the cases that have been included, attached to the questionnaire, where a student had not relied on the Constitution in bringing her matter to the High Court and eventually to the Supreme Court. So you could put it this way, that no constitutional rights were implicated, and the student lost the litigation. And the matter came before the Supreme Court of Appeal, and there was really no merit in terms of, the substance of the application, and the matter had to be dismissed. But even after dismissing the matter, I found that despite the fact that no constitutional issues had been raised, because of the nature of the litigation that had issues that had to deal with access to education, the student did not have to be ordered to pay the cost of the litigation. That was my view at that time. But the majority view was that because the student in question had not relied on the Constitution, no constitutional issues had been raised, and therefore there was no need to apply the BioWatch principle.
If I may take this point further, sorry, excuse me, CJ.
Yes.
If you don't subscribe to judicial activism, the truth of the matter is that 27 years since the advent of our new democratic dispensation, the poor and the marginalized still don't have access to court in a way that is equitable, equality, and all of that. And all the issues that you raise, whether it's equity, whether it's social justice, there are still problems obtained. And the poor, in terms of their financial position, they cannot do anything. If you argue that this is judicial activism is not one of the panacea to resolve all those questions, what is it that in precision can be done to attend to this situation that I've painted?
Oh, okay. If maybe I may just go back, I did say that there are instances where it is justified. So there are instances where judicial activism is justified, and the example that I have just given is one particular matter. But there are instances where it is not justified because of the nature of the issues that have been raised. And in the case of Prince, Sachs J in that matter cautioned the courts to be very careful in relation to separation of powers, to say, if you are hard up, he didn't use those words. He said actually, judicial adventurism can be just as bad as judicial timidity, meaning that from my point of view, there's a balance. So it will depend on the nature of the issues that are raised in your case. Where there is scope to resort to judicial activism, you can do that. In many, many cases, you don't have to even do that because the Constitution itself permits you to do that. And an example would be, for example, affirmative action. The Constitution permits you to do it. So if you are going to find that the methods that have been resorted to in order to address the injustices of the past are sufficient and there's nothing wrong with them, you don't have to resort to judicial activism in order to come to that conclusion. You rely on the very Constitution for that conclusion.
No, thank you very much. Thank you, Deputy CJ.
Thank you, Commissioner. Commissioner Shabangu Mdawe.
Thank you, ACJ. Good afternoon, Justice.
Good afternoon, Commissioner.
How are you?
I'm fine, thanks. Trying.
Justice, in one of your, I think it's number 18, the question was asked to say, what would you regard as your most significant contribution to the law and the pursuit of justice in South Africa? There you mention your involvement with the members of the public, mainly in rural areas, who were advocating.
Sorry, Commissioner. I think Commissioner Mpofu is struggling to hear you. Maybe bring your mic closer and maybe raise your voice a bit.
Okay. Do you want me to start? Okay. Okay, for the benefit of Commissioner Mpofu, I will start. I think it's question number 18 on the questionnaire, where it says, what would you what would you regard as your most significant contribution to the law and the pursuit of the justice in South Africa? You mentioned your participation with members of the public, mainly in rural areas. These people were advocating for the development of rural communities. This item is one of the items which is very close to the heart of many people in South Africa, specifically those who are staying in the rural communities. According to your assessment, has there been any change in this matter? Or where are we with the development of rural communities?
Strides have been made, and yes, there are changes, but I would not be honest if I were to say to you, South Africa remains an unequal society. And that this is the case is evident from many, many judgments, not only of the Constitutional Court, but the judgments from other courts, Supreme Court of Appeal, the High Court, and so forth. I was in an appeal recently which had to do with accommodation of farm workers. And as I was reading the authorities that we were referred to, I came across a judgment of Justice Sachs of 2000 and I think it's a 2004 judgment, PE municipality. And there he laments how unequal a society South Africa is. And he in turn refers to a 2002 judgment where Ackerman J also, made the same lamentation. And as I was reading those judgments, I was saying to myself, how many years later? Almost 18 years later. And the situation it was evident from the very case that we were doing that the situation had not changed much. So yes, I acknowledge that strides have been made to turn the situation around. However, we are not where we should be. And that is something that anybody who's driving around in the townships, who's driving around in the rural areas can readily see.
Thank you, Justice. Thank you, CJ.
Thank you. I've got two more hands before I go and see whether commissioners who are virtual have something. Commissioner Sepe.
Thank you, Acting CJ. Good afternoon, Justice Molemela.
Good afternoon, Commissioner.
Welcome.
Thank you.
I just wanted to find out from you, do you think the experience you have had in the specialist courts like the Labour Appeal Court and the Competition Appeal Court, whether that would stand you in good stead were you to be appointed to the Constitutional Court, given its extended jurisdiction that you've referred to already? Thank you.
Yes, thank you, Commissioner. Yes, most definitely. The experience I gained from acting at the Competition Appeal Court and from being involved in the Labour Appeal Court will help me a great deal. But in addition to that, I have obtained further experience as a justice of the Supreme Court, insofar as I have participated in other specialized, other matters, in specialized fields, like maritime law and intellectual property. I have benefited from the courses that were offered by the South African Judicial Education Institute. They offered an array of courses on an array of topics. And I also benefited from the training that was given by some of the judges of the Supreme Court of Appeal who have expertise in those areas. In other words, in addition to the training done by Sajay, Justice Wallis gave us training on maritime law at the Supreme Court of Appeal. I was privileged to be attending. And Judge Harms also gave us training on intellectual property. So all of that experience all of that experience will stand me in good stead at the Constitutional Court. There's no doubt about it.
Thank you, Acting CJ. Thank you, Justice Molemel.
Thank you.
Thank you. Then I'll go to Commissioner Matolo Zepu and thereafter Commissioner Mpofu.
Thank you, Acting CJ. Good afternoon, gentlemen.
Good afternoon, Commissioner.
You know, I'm looking at your CV and your qualifications, and I ask myself that, where did you find the time? You have done so much to empower yourself, but having said that, I know through the struggles that we had whilst we were still in practice, that women were still underdogs. And they are still underdogs even now. As you say, we have a liberal constitution, everything is there. Having a bird's eye view of all your journeys in all these courts, what do you think can be done? Because we cannot be underdogs forever.
Yes, there was a stage when Nadel invited me to speak on a particular topic. And that topic had to do with the challenges faced by young practitioners in the profession. And so I said to myself, I can't go and speak on that topic, placing reliance only on my own experiences. I need to contact people to find out what's happening on the ground, because I'm no longer a practitioner, I'm a judge. And I contacted a number of people, and they too confirmed that is all the challenges that I faced are still extant. They are still facing the same challenges, despite some of the interventions that have been made. And I remember one of the things that they stated was that, look, we are being told that our senior colleagues will transfer skills to us, so we will also be involved in litigation that involves complex matters. However, we find that, yes, we are roped in, we are involved, but there's no transfer of skills at all. And what they said was that we think that perhaps these people are afraid that once they have transferred the skill, they will become redundant. And so they are deliberately blocking. So, and those ladies were saying, we don't want to participate in a twinning setup where somebody is supposedly transferring skills to you, but what is actually happening is that you are accompanying this person, but there's no transfer of skills. You are not really involved in the issues. So I think to overcome that problem, the profession needs to do more than what it has done, because what it has done in the past has not solved the problem. The profession, and I think the department as well, will need to do more, because when I was inquiring from the departments, why are, for example, female practitioners not receiving enough support in terms of work? Because there's actually a lady from the Free State Bar who closed shop and said, I'm not getting any support. And then she stopped being at the bar. I think she's now an independent advocate, if I'm not mistaken. And, you know, then she said, we are being told that sometimes when the instructions come to the state attorney's office, they go to the state attorney's office with a preference of which counsel to brief from the various departments. So it's not helping. Hence, I say, not only the profession must be involved, government must also be involved to see to it that there is indeed a transfer of skills. And you are not going to be able to pick it up to see that it is not happening unless you have a process where you are monitoring the situation, evaluating the situation, and then you have measures in place to say, if firm A or firm B does not comply, this is what we're going to do. We will no longer give them briefs from government. In addition to that, I think government will also have to assist in terms of the training of women. Be intentional about it to say, In addition to the twinning concept, women must actually be trained on those specific areas, like maritime law, like mining law, and so forth and so forth. Women who are in practice maybe spend 3-4 months focusing only on that. But of course, government will have to come in terms of financing the project, in the same way as government did when they were financing the project of fast tracking of women judges, which was a wonderful program in which I participated and I benefited immensely.
Thank you, Commissioner. Commissioner Mpofu.
Thank you very much. Good afternoon, Justice Malamana.
Good afternoon, Commissioner.
Yes, no, I just wanted to start by commending you on the issue of, let's call it independence. I had the experience of a matter where you found against us in an appeal, and then the same issue came before you, and you, in a dissenting judgment, stuck to the same principle that you had found before. I'm not mentioning the names of the parties because that matter is coming to the Concord very soon, yeah. But I think that's one of the best attributes in a judge. I wanted to ask you about there's been a lot of emphasis on commercial, so-called commercial experience in the Constitutional Court. Just follow up on Commissioner Tsepe's question. In your case, clearly, having been in all the courts you've been to, your commercial experience, I think, speaks for itself. But my criticism with that, because with that analysis, is because sometimes it's used to what is in modern language called subtweet. Is to subtweet black judges because they are assumed not to have this commercial, so-called commercial experience, whatever that means. In my view, law is law. Yeah. But do you find that the absence of that kind of obsession or maybe let's call it concern regarding criminal law experience, which is something that is closer to most people's experience with the law, and that criticism is sadly lacking. And my real question is then, what would be the importance, what criminal law experience do you have, and how do you think that stands you in good stead in the Constitutional Court, in as much as the commercial experience stands you in good stead?
Thank you. Yes. My career started as a prosecutor, so I gained a lot of experience from that. But then as a judge of the High Court, I had to do a lot of matters. It's a court where today you are in a criminal court, tomorrow you are in a road accident fund matter, the next day you are in a divorce matter, and so it goes. So I gained a lot of experience in that area of the law. I've done many appeals related to criminal matters at the Supreme Court of Appeal. And just in conclusion, I just want to give you the assurance that all areas of the law are equally important in my view. I mean, there's no way criminal law cannot be important when it is actually that area of the law that deprives the citizens of their freedom and sometimes for the rest of their lives.
Thank you very much. Thank you, Tisha.
Thank you, Commissioner. Can I ask commissioners who are virtual whether they have any questions? There are no questions.
I'm sorry. I have a question.
Is that Commissioner Breitenbach?
Yes, Acting Chief Justice.
Oh, you have a question?
Please.
Yes, good. Please go ahead.
Thank you. Good afternoon, Judge.
Good afternoon, Commissioner.
What, in your view, is the single most important attribute of a Constitutional Court justice, and why do you hold this view?
I think you said single most, so I'm thinking which one is okay. I think, without a doubt, judicial independence is the most important attribute. But I would add that you also need a thick skin.
Thank you very much. Thank you, Acting Chief Justice. I'm done.
Thank you, Commissioner.
Acting Chief Justice, it's Singh.
Yes, Commissioner Singh, please go ahead.
Yeah, thank you very much indeed, and good afternoon, Justice Molomela.
Good afternoon, Commissioner.
Just to quote what you said just now, you said all areas of the law are important to you, and that's very good to hear. Now, I also note from some documentation that you are working towards an LLD, the topic being the protection of the environment in terms of Section 24 of the Constitution. Are you still pursuing that? Just before I ask the question.
I'm not, okay, let me answer. I'm going to be maybe a bit long in my answer, but
Could I then ask my question then?
No, let me, okay, let me get to the point and say that I have changed the topic.
I must say, Acting Chief Justice and Justice, I am disappointed that you've changed the topic because, you know, and I just want to ask you your views on the question of climate change and its impacts, you know, internationally, nationally, and in African continent and South Africa. It's become a very, very, very serious problem. And I'd like to know, you know, your view. Are we doing enough in practice and in law to mitigate the risks of climate change? Because we may have interviews, we may have buildings, we may have everything else, but one of these days we may not have Earth to talk about. And there are big companies in our own country, and you know who those two are. State-owned enterprises, one of them, that are the biggest culprits when it comes to increasing carbon footprint. So what can the law do to help us in this? Thank you.
I think that is an area where there's going to be a need for as many non-governmental organizations as possible to be formed dealing with that area. In as far as my situation as a judge is concerned, there is not much that I can do because, as you know, Mr. Singh, the judiciary is reactive. In other words, the judiciary can only deal with the disputes that are brought to it. So in as much as when I sit and look around, I see many areas that need attention, they will have to be brought to the courts by the litigants. Hence, I say it's an area that will need the involvement of many people in the NGO sphere.
Yes, but it does not stop judges from expressing their views on the impact of climate change, and I hope that can be done because it's a very, very serious problem. That's right. You know, in our country and around the world.
Absolutely. When the right case comes, we'll definitely make the right judgment and give and be as elaborate as we can on the subject. But we have to wait for the right case.
Yeah, thank you very much, Chief Justice. I'm just suggesting that we don't have to wait. Even if there's no case, one can still publicly, as you talk to women, as you talk to everybody else and activists, you know, express a view on the dangers and the risks of climate change. Thank you very much.
Thank you.
Thank you. I think we have come to the end of this interview. Thank you very much, Justice Molomela.
Thank you, DCJ, and thank you, commissioners.
Thank you once again for availing yourself. You are now excused.
Thank you.
Thank you. Good afternoon, Judge Unterhalter.
Good afternoon.
You are most welcome. Thank you for availing yourself once again. We have this session because there is an order of court that said we must do these interviews afresh. And we thank you for coming back.
Not at all.
Thank you. I'll ask you some questions, and thereafter I will allow commissioners to ask questions. I see that in terms of your academic qualifications, you hold a BA, LLB, BCL, and MA. Is that right?
Yes, that's that's correct. Yes.
Yes. The BA you got it at Cambridge. The LLB you got at Wits, BCL at Oxford, and MA at Cambridge.
That's correct.
Yes. And for most of your working life, you have been also attached to universities as a lecturer and professor. Is that right?
Yes, that's correct. Ever since I started at the bar, I have held academic positions, and I took some time out from the bar to be the director of the Center for Applied Legal Studies and to found the Mandela Institute, which has played a role in human rights work in various forms. And then I returned to the bar, but continued to hold academic positions and held a chair at Wits and thereafter at the University of Cape Town.
Is the position that throughout the time that you were at university teaching, including applied, I think, legal studies or Center for Applied Legal Studies, you were practicing part-time and also teaching part-time, or how were you managing?
Well, the way it worked was this, that when I took up the directorship of CALS, I actually stepped away from the bar because I was the director of CALS, and that was a full-time job other than very incidental practice. And similarly, when I started the Mandela Institute, I did much the same thing. But once the Mandela Institute was on its feet and we'd raised considerable monies for it and got it going, I then went back to the bar and then did my academic work on a more part-time basis.
Yes. So when would it have been when you went back to the bar, in terms of which year, more or less?
I can tell you, if you give me one moment. So the Mandela Institute started in 2000, and around 2002 or 3, I went back to the bar full-time.
Yes. And is the position that mostly your practice consisted of human rights kind of cases, constitutional law, admin law, as well as competition law, and some commercial law?
Well, ACJ, if I would like to explain one thing which perhaps I didn't explain clearly enough when last I was here,
yes,
which is that before I accepted a position on the bench, I did spend some 11 years serving in a judicial capacity, and perhaps I didn't explain this carefully enough last time, but let me do so now, if I may just have a moment.
Yes.
I was nominated by South Africa to sit on the appellate body of the World Trade Organization. And let me explain that that body is effectively the world's trade court. So I represented effectively, since regional representation is fundamental to being on that court, I was the African representative regionally for the World Court on Trade. And I sat on that court for 8 years and was the head of that court for 2 years. The kinds of disputes that that court hears are disputes between members of the WTO concerning trade disputes that cover a very wide range of issues that deal with environmental, health, subsidies, a whole gamut of fundamental features of trade that affect members of the WTO. And before I was nominated and was selected as one of the 7 members of the appellate body, I served for some 4 years on the Court of First Instance of the WTO, which is the panel stage after which appeals go to the appellate body, for 4 years. So if we calculate my judicial service during the time, before I took up a position on the High Court, I had served some 11 years in a judicial capacity, including heading for 2 years the appellate body. And so when it was said of me in the deliberations that I had but 3.5 years judicial service, I have to say that that was simply not correct. I have in total served some nearly 15 years as a judge. And the WTO court, the appellate body, certainly at the time that I served in that court, was probably the busiest international court of the many international courts that exist in the world. So I do at least want to bring that to your attention, because it is the court that served the WTO, and it is a court in which its members, including critically developing countries, have got a significant way of litigating fundamental disputes that affect their economies and their trade relationships multilaterally with many trading nations in the world. And so those disputes were large and complex and involved many, many important issues for the member countries of the WTO. And I did want at least to make that plain to you all.
So from which year up to which year did you serve in that?
Yes, so I have the figures, the dates for you there. So from 2003 to 2006, I was on the panel, at the panel stage of the WTO, and then I was then appointed then for 8 years thereafter onto the appellate body. So cumulatively 11 years of service in a judicial capacity in the WTO. And that was during the period that after I finished at the Mandela Institute. And so although I was at the bar for some 27 years, and it was said of me that I had, or the suggestion was that I had somehow left it rather late to come to the High Court. In truth, during the 27 years that I practiced at the bar, I was involved in a number of different other capacities, including the academic ones that I've referenced for you, ACJ, as well as 11 years of judicial service, including in a leadership role of that court.
Well, I have no doubt that sitting on such a body is quite important and has to be given proper weight. But I just want to find out whether when you say you served in a judicial capacity, when you served in that body, you intend to say judicial or you mean adjudicative, simply because you could have a panel of people whose job is to adjudicate certain disputes, but they are not judges in the normal sense, but they perform an adjudicative job. So, I just want to understand whether you mean judicial in the true sense or you mean adjudicative.
No, I mean judicial in the true sense, because the appellate body is a permanent, established body of the World Trade Organization. So it's not simply ad hoc tribunals that are constituted from time to time. That is true at the panel stage, but the appellate body is an established institution, established after the Uruguay round, when, because of the huge expansion of the multilateral treaties that underpin the WTO, it was felt important that members who were in disputes with one another could go to a court to resolve those disputes and have those obligations enforced. So one of the features of the appellate body, which is unlike most international courts, is that it was the fundamental mechanism for the enforcement of the rights and obligations under those multilateral treaties with enforcement mechanisms. So I do mean to say that it was a judicial capacity, not an ad hoc adjudicative capacity.
And when you served in that appeal body, were you full-time or you had to go there as and when there was a need for you to deal with some cases?
Well, the way that it works effectively is that you have to be ready, as the relevant treaty indicates, at short notice to serve at any time that an appeal arises. And since there are very demanding time periods as to the periods within which an appeal must be disposed of, although one didn't, as it were, have to sit in Geneva waiting for the cases to come, as soon as a case was referred to the appellate body, you had to make yourself immediately available for those cases because, again, unlike many international institutions, the requirement was that judgment, that is to say the recommendations of the appellate body, had to be rendered in 90 days for the most part. There are very, very big cases, one of which, for example, concerned the subsidies of Airbus and Boeing, which ran for more than a year, but that was a very unusual appeal. Mostly the time periods were demanding and you had to be available at very short notice to go to Geneva and hear the cases.
And in the Competition Appeal Court, you have also acted there, is that correct?
Yes, that's correct.
Yes. How long did you act there?
I've been acting there since I was appointed to the High Court, but because the last year and a half I've been in the Supreme Court of Appeal, I haven't been acting in the Competition Appeal Court since I took up a position as an acting judge in the Supreme Court of Appeal.
And I saw that you have quite a long list of reported cases that you argued during your time in practice. I think I tried to count and there seem to be quite many. Do you have an idea about how many there are?
You know, I haven't actually counted precisely, but I have been, I probably have certainly more than 100, probably more like 150 reported decisions. And I should revert back to the question you posed right at the beginning, ACJ, which is to say, well, what did my practice consist of? And I suppose if I were to try and summarize it, I'd say this. I started appearing in the Constitutional Court from the very beginning. I appeared in the certification cases and have appeared many times, many of those times before you. And I maintained a very steady practice in constitutional law throughout my time at the bar and have seen the entire evolution of our constitutional law through the many cases that I've been involved in that court. But I also practiced extensively in the jurisdiction of competition law, which, as we know, has now flourished as a jurisdiction in South Africa through the institutions created by the Competition Act. And again, there too, I began practicing more or less from the beginning that jurisdiction began, and that became an important part of my practice. But so too did the other aspects of public and regulatory law, for example, involving broadcasting, companies regulation, environmental regulation and the like. So aspects of regulatory law pretty much across the board. And then obviously I've also maintained a fairly significant practice in commercial law. So I think if one looks through the cases, and the reported cases are a sort of indication of the range of my practice, it was quite wide-ranging in the different areas in which I gained some specialty.
I know that among the cases that you would have argued in the Constitutional Court and in the High Court would have been quite many, which involved declaring pieces of legislation unconstitutional and arguing what remedy should be provided by the court in that situation. But since you started performing duties as a judge after your appointment, have you had judgments which where you have declared pieces of legislation unconstitutional and decided on the appropriate remedy?
Yes, I have. One of the cases that I have referenced in my CV is the Parler case, where it went ultimately to the Constitutional Court, where our decision was affirmed. But there we did set aside the provisions of the legislation as to where the change to the parole regime when persons convicted of murder were eligible for parole, there was a cutoff point which gave rise to a constitutional challenge. And there we did indicate that the basis upon which that change had actually come into force gave rise to inequality. And so we did declare that to be unconstitutional with provisions as to how that was to be rectified.
Now, it is said that different countries have different models of separation of powers and that South Africa has got its own. Would you like to share your views with the commissioners on the South African model of the separation of powers?
Yes, certainly. Our doctrine of separation of powers is not contained in any single feature of the Constitution. One has to, as it were, piece it together in different places. But just to give some of the features of how I think the separation of powers is articulated through the Constitution is firstly, of course, the role that the courts are required to play. So the very significant powers of both constitutional and administrative review and the oversight role that is given to the courts to uphold the Constitution is not just about a simple separation of the courts from the executive and legislative wings, but obviously the very significant oversight role that the courts have in respect of requiring the executive and the legislature to adhere to the significant rights that are accorded under the Constitution. So that's the first feature, which is a very large jurisdiction and gives rise naturally to border issues as to whether, as some people think, courts sometimes go too far or do not, but that's one feature of the separation of powers. The second is issues around the oversight role that Parliament is intended to play over the executive. Some people believe that under the implementation of our Constitution, that has been a rather underdeveloped feature of the division of powers, but it's a hugely significant one, and one that the Constitutional Court has had to remind Parliament of from time to time. And then in respect of the executive, of course, it is tiered as to the different levels of government, but there's also a requirement of cooperative government. So we have developed a model which is not just about how powers are distributed, but also how they are to be used in a fashion that can resolve potential boundary disputes between different parts of government and not simply give rise to unnecessary disputes of this kind. Again, a feature of our Constitution that is unusual and not always articulated in comparable constitutions. So one has to look at the division of powers by reference to different parts of the Constitution, and it's still a doctrine that is being articulated through cases, but we definitely have a distinctive division of powers and separation doctrine under the Constitution.
And one of the judgments that many people, even who are not lawyers in South Africa, know about is what we refer to as the Nkandla judgment. Would you share your views with the commissioners as to what you think is the jurisprudential significance of that judgment in South Africa?
Well, I think the significance of that judgment is that it is perhaps one of the more challenging instances in which the court is confronted with the question of whether there has been a species of abuse that has arisen. And one of the lines that is always difficult to navigate is where decisions are of a political kind, where courts are not required and in fact shouldn't go, and circumstances where fidelity to the Constitution and upholding the Constitution is absolutely vital to institutional integrity and the maintenance of the values of the Constitution. And the Nkandla case is just such an instance of holding presidential office to the requirements, including the oath of office that is taken by presidents. So we give to the president of the country enormous powers because they are intended to be articulated and used to achieve constitutional and social and political purposes. But when there is a straying from the proper exercise of those powers, it is the courts that must hold presidential power to account, and that's essentially what was done.
Thank you, commissioners. Commissioner Madonsela.
Thank you, Chief Justice. And good afternoon, Justice Unterhalter.
Good afternoon.
I just want to ask two questions with the permission, Chief Justice. And I would like to be given.
Oh, I'm sorry. Okay, thank you.
And I would like to be given the latitude to ask these questions in light of what has happened in these interviews.
I'm sorry, did you say you would like to ask more than two?
I would like to ask to be given some latitude in asking these questions because of what has happened.
Yeah, okay.
In the context of these interviews.
Okay.
I would be guarded in asking the questions, obviously. Mr. Unterhalter, you know already that we have received objections to your candidature, principally from the BLA and some other body called the Boycott Coalition, if I can just paraphrase the name of that institution, BDS. Now, we have to raise the issues with you so that you would deal with them head on, and then we can address them in our deliberations. You have read, I'm not going to go at length, I'm sure you have read the objections, and they pertain to you the fact that you accepted nomination as a member of the Jewish Board of Deputies in South Africa. What I want to ask you about that is this. Seems to me that the fundamental premise of both objections is the assertion that the Jewish Board of Deputies is a body that is pro-Zionist and that is, in fact, bullying all other people and organizations who are objecting to the Israeli establishment in the Palestine region. Is that premise correct?
In my view, the premise completely correctly summarized by you with respect is incorrect. Members of the Jewish community in this country, as in many other countries, hold a very wide variety of views about Zionism and the State of Israel. That is why people who are Zionists subscribe to organizations that bear that name and seek to pursue that particular political agenda. The Jewish Board of Deputies is a body that existed long before the State of Israel was ever created and has its roots in the 19th century in this country, where it is simply founded and was founded to look after the interests of a particular community, in this instance, the Jewish community, and largely to take care of its welfare, as many community organizations representing many different parts of our society do. It was on that premise that during COVID, when there were peculiarly large demands placed on the welfare, not just of the Jewish community, but also in respect of its charitable work with other communities, that I accepted a position to on the Jewish Board of Deputies, thinking that it could be of some service to the community and the work that it did for the Jewish community. There was, when I was nominated and came before you before, the objections of the kind that you have indicated, saying that effectively that showed my commitment to Zionism, which, according to these bodies, is antithetical to the Constitution, and hence I should not be favorably considered for appointment to the Constitutional Court. That proceeds exactly from the premise that you have stated, and which is wrong. It was not the reason why I joined. I would not have joined on that basis. And as you will have noticed, I resigned from the Jewish Board of Deputies because I recognized a different error, which is that the Jewish Board of Deputies litigates cases dealing with anti-Semitism, and some of those cases have come to the Constitutional Court, and it seemed to me unwise for me to potentially seek appointment to a body where the Jewish Board of Deputies might be litigating cases. And consequently, it seemed to me better to stand down. And that's precisely what I did. I recognized that that was an error, probably of judgment that I'd made. And sometimes it's a feature of judges that they should recognize when they make mistakes, and that was one.
Yes. Now, it's a follow-up on the position of the Jewish Board of Deputies. I just want to understand, does the Jewish Board of Deputies in South Africa currently and last year, when you accepted nomination to it, did it hold a particular view about the Israeli establishment in the Palestine region?
Not certainly while I was there. The Constitution makes no commitment to Zionism of any kind, and none of the issues that I was concerned with had anything whatever to do with Zionism.
I'm asking whether the Jewish Board of Deputies propagated.
Not as far as I know.
I just want latitude on this one, thank you. On the second reason why you stood down in the face of the objection from the BLA was, as you stated and you repeated today, that it's because of the involvement of the Jewish Board of Deputies in litigation in matters relating to hate speech and anti-Semitism. Now, my recollection is that when you were interviewed initially for the position of the judge in the North Gauteng High Court, I think, or in South Gauteng, you were pressed on your views around your membership or even involvement with the Helen Suzman Foundation. And then you expressed at that time that when you assume the position of a judge, you immediately disengage with the bodies with which you're involved. Around that, then I got so surprised when you then took up position as a member of the Jewish Board when you know that it is a litigating body. I would have thought that you would try to disengage with it.
from that perspective? I understand the point you're making, and I think the answer to that is just simply the one that I've given to you, which is that I joined it on the basis that it was facing very considerable demands in a time of COVID, with all the problems of the pandemic that we all know about. And I saw it simply as a contribution that I could possibly make to this community and other communities that it serves in respect of welfare issues. That's how I saw it. I didn't really think carefully enough in retrospect that there is also litigation that it undertakes and so on. And I recognize entirely that had I had that at the front of my mind, it would have been a reason not to do so, and I shouldn't, in retrospect, have done so, given that that was so. But, you know, I have to simply say to you that at a time of considerable social need in many communities across this country, it just seemed an aspect of service that I could make that didn't contradict my judicial activity. But I can see that there is a potential problem, and that's why I've dealt with it.
Yes, Chief Justice, that was the component of my first question. Now I want to move to the second question. With your permission.
I think this is what Commissioner Malema was talking about. One question is it takes long. Okay.
The second question.
Okay.
I just want to. On the second question is, it has to do with the judicial functions currently. You have delivered between April and now a judgment in Capitec. I'm asking you this question in the context of that judgment. Do you think that the jurisprudence of our courts currently on contractual interpretation are adequate or is adequate to regulate commerce between contracting parties? I ask because it seems to me that in the Capitec judgment, which you penned recently, you revisited the judgment of the SCA in Endumeni, and of course the constitutional judgments in Auckland's Park and Kumwendo relating to admission of extraneous evidence in the parallel evidence rule. Do you think that the jurisprudence thus far requires refinement or revisitation or overruling?
Well, let
Will
me
you also touch also on the other judgment that I've not mentioned, the Badieka judgment?
Yes.
Insofar as it relates to public policy considerations in contractual interpretation.
Yes. So the Capitec judgment, which came out after I made my application, so it wouldn't necessarily have been before the JSE, but it really touched on three issues, I think all of some importance. The first was a yet further revisiting in respect of Endumeni and how we approach interpretation. And although that judgment has been repeated many, many times over in our courts, it did seem to me that there were at least a couple of things in addition to say about the interpretation of commercial contracts. One of them being that there is often a commercial logic that underpins those judgments, and trying to understand that logic can be extremely important, so that a coherent interpretation is one that seeks to grapple with the interrelated parts of the whole commercial scheme within which an agreement works. And I sought to develop and emphasize some of the relational aspects of interpretation, which, although are part of our interpretational scheme, I think sought to accentuate some features of interpretation. The second feature of Capitec, though, was to try to reconcile two important doctrines, which is the wide scheme of interpretation, which has reference to text, context, and purpose, which gives a wide remit to the kind of extrinsic evidence that might be utilized for the purposes of interpreting contracts, and the parallel evidence rule. And what I sought to illustrate in Capitec is that because of our wide scheme of interpretation and the use of extrinsic evidence, it was rendering parallel evidence as something of a residual feature of our jurisprudence. And I wanted to bring that out, not because it's necessarily wrong, but simply logically, that's where these matters lead to. And then finally, it was to try and understand and indeed re-emphasize what had been said by the Constitutional Court in respect of good faith, which is that it isn't an independent doctrine that one can simply have direct recourse to for the purposes of seeking to discipline contracts, but one has to see how it is articulated through contractual doctrine, and in particular through the articulation of public policy. And in this particular case, I did find that the court below had simply strayed into a rather diffuse understanding of good faith as a sort of general notion that you can use whenever you think the equities favor a particular outcome. And that is not my view either as to what the Constitutional Court has said, nor as I sought to interpret it for the purposes of applying the reasoning of the Constitutional Court in the Capitec judgment.
I wish I could engage more, but I think there are other questions.
Okay, thank you. Commissioner Nochesi.
Thank you, sir. I think in the past 27 years, the rescission application brought by the former president to the Constitutional Court was the sort of a big test to our constitutional democracy. And thanks that rescission comes shortly after you and your colleagues have delivered the De Beer judgment. And the approach you adopt in the De Beer judgment being that that let the matter be referred to the NPA to deal with the condemned part. Let it be referred to the NPA. Now, if you sit, if you are not comfortable with this question again, if you sit and reflect and say, this is a De Beer judgment which I gave, and shortly this is a Constitutional Court judgment on the rescission of former President Zuma, would you say your judgment was in accordance with the Constitution and international law, or as the Constitutional Court judgment was compliant with the Constitution and the SCA? I mean, just if you reflect on these two, because they just come and it's what every South African is interested to understand.
Yes, so let me explain that the panel of the Supreme Court of Appeal that decided the De Beer case was concerned with certain provisions of the regulations undertaken under the National Disaster Act, which had been set aside by the High Court. Our decision was that the basis upon which that review had taken place was not correct, and that the regulations withstood scrutiny. An entirely subsidiary part of the De Beer case was the conduct of the particular litigant, Mr. De Beer, who had, in a series of engagements both with the court that heard the case, as well as with the president of the court, acted in a fashion that we considered to be entirely contemptuous. And so we simply thought that in that circumstance, we would refer that matter to the NDPP for any prosecution that might be thought warranted. In the case of the Constitutional Court, there was a separate question as to whether there was, again, a direct contempt that had been shown to the Constitutional Court. And it is permissible, at least as I understand the matter, and certainly the majority judgment in the Constitutional Court, for the court to take the view that it will itself then deal with the contempt that has been shown. So it doesn't seem to me that these are inconsistent approaches. They're just different approaches that can be taken. And There is, of course, a minority view that's thought that the fair trial provisions required a different approach. But there is a very long line of decisions, and ultimately the majority found that it was perfectly competent for the Constitutional Court to have decided the matter as it did, and that's where our law now stands.
No, I understand that. But in this case, coincidentally, in the appeal judgment, you agree with the minority if I go through. But let's
I'm not certain, just to be clear, that it's so much a matter of agreement.
No,
it's simply that we
that's
took
fine.
we just took a different route.
Okay, that's fine. Let's go to my second question. The second question is, look, since, the past 27 years, and we talk about the jurisprudence that has been developed by the Constitutional Court, would you say have the court develop an African jurisprudence or a jurisprudence that advances the African jurisprudence? Rather, except to say we apply customary law, I don't talk about that. For instance, let's say in other areas of law, criminal law, law of contract, because African law do cut across onto that.
So I think I have two responses to your question. The first is I would say that we have developed, and the Constitutional Court has developed, very much a South African jurisprudence, which is to say that our Constitution is distinctive and its values are distinctive, and it reflects both our history and our present in a whole variety of ways. And the way in which the court has developed it has been about recognizing where we've come from and where we're going, and some of the critical values that underpin the Constitution is very much part of what has been developed within the courts and the Constitutional Court. I think you're correct, though, if this is the implication of your question, that the role certainly of customary law is an underdeveloped feature. Most especially, although the Constitution in a number of places recognizes the application of customary law and actually recognizes that customary law should be developed, it does seem, I think, a fair point to make that customary law as a dynamic part of law is not an area that has perhaps had as much attention as it could have and should have. And it's probably likely that it will have a much bigger role to play than it has in the past. So I think that that's a fair point that you make.
Look, if I may just follow up just to, look, for instance, if in the principles of punishment, for example, I'm making an example, we have infused the value of Ubuntu rather than limiting yourself to the triad, the Zin triad. You wouldn't send an 8-year-old to jail for not attending court. You would rather ask him to go to where he's supposed to go. If you build, but if you rigidly apply the revengeful common law approach, you'll take him to prison. You see, those things.
You know, I would like to believe, for example, in relation to punishment, that the common law principles don't just reflect retributive aspects of punishment, but recognize other aspects of punishment that are meant to be both about deterrence, certainly, but also about restoration and rehabilitation. Now, quite whether the balance is correctly struck, you may be right that we could learn a great deal more about other forms of customary law which infuse either additional values or overlapping values with different emphasis. And those arguments are arguments to be made before the courts, because punishment is a discretionary feature of our jurisprudence, where perhaps too often there is too mechanistic an approach that is taken. You know, part of the problem that we have is that we often have cases where there have been pretty terrible crimes committed, and perhaps courts need to carefully discipline themselves that the retributive instinct that is necessary isn't always overwhelming, but is tempered with other values, including the quality of mercy, which is an important attribute that we need to bring to justice.
the last question is just a follow-up to your debate with the DCJ. Somebody argues, correctly or incorrectly, I haven't followed it up, that you are correct to say in the Constitution you can't find a section which actually say there shall be separation of powers in the Republic. You have to add and find it. Where in the Constitution, or how would you locate the Chapter 9 institutions that support the Constitution, like public protector? Where would you locate within the spheres of government, I mean the spheres that we have, or the arms of government that we have? Where would you feature those institutions? Would you feature them in the executive or the legislature? And or how would you describe them within the context of the Constitution? I'm asking this because if the public protector, it has been agreed on many times that his bank powers are binding, you'll review, but certainly at a later stage, there is a shift of interpretation coming from the courts, which where you say, no, can't go to this level, can't go. Where would you locate this institution? I think it's the last.
Yes, well, I think actually the public protector and other allied institutions don't fall within a sort of formal concept of the separation of powers, because they're not formally about government. They're about how to support the constitutional project. So they fall into a slightly different category. But the issue then has always been, as we know, well, are these decisions binding, and in what way must they be respected? And we know what the jurisprudence has had to say about that. But of course, as with every power that is granted, significant as those powers have limits, just as the courts, although they have hugely important powers as independent institutions, their powers are limited and they must respect the boundaries of the powers that they've been given. So you have to both understand the constitutional function of the public protector, but the public protector has also to respect the limitations of the office that is occupied, just as judges do, just as every body that has powers must do. And so I would say it's less a question of separation of powers, but more factor that we recognize the binding nature of the public protector's determinations. But we also, as with every other body that has powers, apply doctrine as to what are the limits of those powers. Every constitutional order depends upon recognizing the limitation of power as well as the enforcement of power. And that's what the great debate around the public protector's office has been about.
Thank you, Commissioner. Then it will now be Commissioner Moimang.
Thank you, Acting Chief Justice. Good afternoon, Mr. Dalta. What is your understanding of negative judicial activism and positive judicial activism? Apply that within the context of the latest case of the Concord for the IEC, where the literal interpretation of the text of the Constitution on the term of local council was at play. I want you to draw a parallel with that, with something that was it's a proposition that was made in the State vs. Makwanyane case, where at the beginning the court said that the courts were not empowered to make any modification, alterations, or additions to the legal text, as this is the function of the legislature. But of course, they were able to apply that positively to move as a transitional route from apartheid laws to constitutional democracy. But also, what bothers me is paralleling that with what the former Chief Justice St. Lever said in the Collins matter in 1957, that if the provisions of the law are clear, we as a court are not concerned with the propriety of the legislation or policy of the legislature, our duty is to administer and interpret. You see. I got a sense that the Concord is descending into conservatism because they overlooked the pandemic through which we are going through and just restrict itself to say within 90 days after the 5-year term, you must go to election, irrespective as to whether, as we do door-to-door transmitting the virus from one place to the other happens. It was none of their issue. Thank you, Acting Chief Justice.
Well, let me begin, if I may, just with your first distinction between negative and positive judicial activism. I mean, it is often a label that is attached to whether parties believe that the right or the wrong answer was achieved by the court. So when the right answer is achieved, it's positive judicial activism. When the wrong answer is achieved, it's negative. And these labels are often just stand-ins for whether particular litigants and people in society think a court has got things right or has got things wrong. As far as the IEC case is concerned, I'm not certain, at least on my reading of it, and there were 2 sets of judgments, as you will know, that this was simply any form of literalism around the provisions concerning the term within which the elections had to be taken. Because I think that the court was very concerned to understand whether the prospect of a free and fair election was possible within the scheme of a society that was subject to the pandemic and its many restrictions. And it grappled with this problem as to whether it was still possible to have a free and fair election under these conditions. And the judgments took different views about what was to be said about that. But I'm not certain whether the ultimate answer was an answer that simply said, well, we're just going to adopt a totally literalist view of the legislation. I think the real anxiety that the court had to work with is that there was obviously a desire that the mandate from the people must be renewed, and that's what is required. And that itself is a particular constitutional value, as against the issue as to whether the electorate would have a free and fair election, have their say to exercise their fundamental rights. And that is always a kind of difficult balancing act to play. So I must say my own reading would not be to suggest that this is some assertion of a kind of very conservative literalism, but simply an exercise in a difficult case as to how to deal with a provision that requires that something be done by a particular period, and the issue as to how to balance up the kinds of rights that are in stake in respect of that time period. So it wasn't just an empty formalism to say we adhere to the period just for the sake of it, but because the mandate of the people in respect of an election is a very fundamental feature of a democracy, and that's itself an important constitutional value. But of course the people must be able to decide in a free and fair way, and that was what was being balanced up, as I read the judgments in that case.
Within the doctrine of the separation of powers between the IEC and the courts, which one will be much more better?
I'm sorry, can you just speak up so we can hear you?
Thank you, Acting Chief Justice. Within the doctrine of the separation of powers, and with the available expertise at the disposal of the IEC and the amount of efforts that the IEC draw as part and parcel of preparing yourself for the election, don't you think that in this instance, given the doctrine of the separation of powers, the IEC was better placed to understand the ramifications of whether it will be detrimental to the voters to go to the election or not?
Well, I'm not certain that I would see it as a straightforward separation of powers question. I mean, you're absolutely correct that in the first place, the constitutional responsibility for organizing and running free and fair elections is that of the IEC. And there are many decisions that they have to take that they are best placed to make, and courts are certainly not well positioned to make in respect of discharging that constitutional mandate. But of course, as with every other body or authority that has power, the question is how does the exercise of that power measure up against the constitutional norms? And that's where courts are not seeking to do the job of the IEC. They're seeing whether the job that has been done by the IEC does or does not measure up to the constitutional value. So, as you know, these kinds of problems repeat themselves over and over again, and I think courts are fairly careful to show deference to authorities in respect of the areas where they have special expertise and where it's certainly not for the courts to go. But on an issue such as whether the democratic mandate needs to be renewed and that particular constitutional value, ultimately courts are given these powers under the Constitution to decide whether there's been a constitutional infringement or not. And that has to be measured up against what the authority has done. But it is done within a scheme of recognizing that it is the IEC and its judgments in the first place that one must give very close attention to, because they are the people who discharge the mandate in the first place.
Thank you, Justice Unterhalter. Thank you, Acting Chief Justice.
Thank you. Then now it will be Commissioner Magwenisha.
No, thank you very much, Acting Chief Justice. Good afternoon, Judge.
Good afternoon.
No, I have only 2 questions. Yeah, it's only 2 questions. I'll strictly to 2. From 1989 to 1994, you were a member of the Democratic Party. And then you resigned in 1994. Can you share with us why did you resign from the Democratic Party in 1994?
I just found that I was pretty inept in any political realm altogether, and felt much better and more assured in pursuing a career at the bar and in law. And I think my judgment was correct in this instance.
The last one, I'll stick to the commitment I made, Acting Chief Justice.
Yes. And the good thing is there is no preamble.
No preambles,
Yeah.
no preambles.
Okay.
It's the question I asked last time. I hope you will be more direct this time. I asked how many black and women female juniors were you able to include in your high-profile cases, which are not only focusing on the international trade law, but the whole spectrum of your practice, spanning over the many years you have been in practice?
Yes.
Thank you very much.
Well, I have had occasion to look at all of that, and I can say that between black juniors and women juniors, I would have included, the list I have here probably runs to about 30 or 35 names. But let me just say that not only did I involve them in my practice in areas of, say, pro bono work, which I did on many human rights cases, but I involved them in my practice in every aspect of my practice. And so it is actually a matter of personal pride to me that many of the persons that I worked with closely are now leading figures in the bar. So obviously, Mr. Nkaitobe, Sisilana, I mean, I've got a list of them here that I can read to you. Mr. Makola, Mr. Shozi, Mr. Malindi, Mr. Misimang, Ms. Goodman, Ms. Hofmeyer, Ms. LaRue. I have a very long list of people here, but although the list is long, what I think I would want to emphasize for you is that I did it not to build some impressive list to one day tell you about in a hearing of this kind. But I did it because there are people of wonderful talent who come to the bar, and many of them take time to be recognized for the talents that they have. And there are many opportunities for me to seek to work with them and gain much insight from working with them, but also help in different ways to develop their practices and the kind of quality that they have as practitioners. And I am delighted that today many of those practitioners are now leading members of the profession, and they discharge leadership roles within the bar, and they are excellent practitioners. And if there's one thing ultimately to be gratified by, that I hope, involvement with these enormously talented people, any contribution one can make to giving their careers a push in the right direction, I think is a wonderful thing to do. So you're very welcome to the names. I can list them for you in detail, but I'm perfectly satisfied that I had very significant involvements with Black practitioners and women, very worthwhile, creative, and fruitful working relationships with them that were of great benefit to me, and I think of quite considerable benefit to them as well.
Thank you, Acting Chief Justice. Thank you, Judge.
Thank you, Commissioner. Now it will be the Minister.
Good afternoon, Judge Unterhout. Yeah, I just want to check, you know, sitting here, I'm debating with myself or not yet convinced about the WTO body being a judicial function. And I want to just ask, why in the international courts, there are the International Court of Justice, all those, I know that there could be courts that are not called courts, where you perform those judicial. Why didn't they just call it an international WTO court to make it so easy for us to understand? Because as sitting here, I think it will be a debate as we go to the closed session, whether is that a court or is not a real judicial function or tribunal or whatever.
Yes, Minister, let me try and explain why the appellate body is called the appellate body and not the appellate trade court, as it were. It has to do with particular way in which the dispute settlement agreement, which is the agreement under which the dispute resolution mechanisms of the WTO were constituted, the way in which it was negotiated. There's a very unusual structure within the WTO, which is that the appellate body, which is the final body to which you can go to litigate a dispute, makes what is called a recommendation at the end of the hearing. And the members of the WTO take that recommendation, but here is the important point about it. The recommendation has to be compulsorily adopted by the membership of the WTO unless what is called negative consensus applies, which means the winning party chooses to give up the benefit of the decision that has been made by the appellate body. And that was just a question of delicacies in the way in which the WTO agreements were negotiated. But the critical point, and this is why people who spend time in this area know full well what the position is. The reason that the appellate body is in all but name a court is because that is the body that makes the final decision in respect of trade disputes under the multilateral agreements of the WTO. Its decisions are final, they are binding, they have to be adopted, and there are sanctions and consequences that flow from a party that doesn't adhere to the determination that the appellate body has made. It's a permanently established body, it's not an ad hoc tribunal, and so unless one wishes to say that all international bodies of this kind aren't courts because they aren't national courts, I must say I would be, in terms of the actual functionality of what the appellate body does, the binding nature of its decisions, the responsibilities that it carries, and the kinds of disputes that it determines, I must say I cannot for a moment understand how it is different from the highest courts of most national institutions.
Okay. Yeah, my second question relates to the issue of the vaccine, which, as you will be aware, the criticism to the well-established countries about vaccine nationalism. Don't you think the WTO, or what has been your role to advance the interests of developing countries, third world countries? Because it seems so easy for these big or well-established or well-to-do countries to hog this vaccine. And it also does appear that they seem to be protected by the rules of the WTO and the various rules, so they can do this. And I want to believe they can also do it in any sector of the economy. So what has been your role to advance the interests of developing countries in that platform of the WTO, so that we don't find ourselves with this kind of situation of the vaccine we are finding ourselves today? Yes.
So let me firstly deal with my role, and then I'll briefly refer to the question of the vaccines and the TRIPS agreement. But as I indicated in some of my introductory remarks, there are 7 members who sit on the appellate body. They come from different parts of the world, but there is intended to be roughly regional representativity in the appellate body, and I was the African member in that sense of representativity on the appellate body. The others came from China, from the United States, from Europe, from Brazil, and the like, Mexico. So it was a selected body from across the world in which regional representativity mattered. Now, there was no, it's a court, so plainly it's an independent institution. It has to decide the cases on the basis of its understanding of the law and the proper application of the law. But the key feature of the dispute settlement system, which has very real resonance for developing countries, is that the WTO is an institution that is a rule-based order. So the treaties that have been concluded are rules, and they are enforceable rules, and members can go to the appellate body to have those rights and obligations enforced. And many developing countries have used the dispute settlement system to their great advantage because they have held developed countries to the rules of international trade. So just to give you an example, Brazil was enormously successful in eliminating unlawful cotton subsidies that were restricting its abilities to export products to the United States. And similarly, other developing countries have used the WTO and the dispute settlement system to advance their trade agendas, because if you can get favorable rulings and the enforcement of rules in your favor, it gives you access to markets, it promotes employment, it promotes economic development, and that can be fundamentally important to developing countries. And so I would say that the rule-based order has been of very great significance to developing countries, and because of the systemic consequences of that rule-based order and its interpretations by the appellate body, it has created an order in which export-led growth by developing countries has been fundamentally important. Let me give you the most salient example of all. China joined the WTO. It is generally considered to have been one of the most fundamental things that happened in terms of promoting its export-led growth, which has almost certainly changed the economic face of the world. And that's one, of course, extremely big and extremely important developing country, but the same principles can apply for others. So what did we do? We applied and considered the rules in a way that was an dispassionate rule-based order available to all members to use for the purposes of getting the benefit of the rules that had been agreed to and applied on a dispassionate basis. Very lastly and quickly on TRIPS, which is the agreement that is relevant to the vaccines. South Africa and India, as members of the WTO, have been very active in seeking to negotiate waivers in respect of some of that intellectual property. But the agreements themselves have let out provisions in respect of public health and the like. And one possibility is that cases will be brought to actually utilize some of the exception procedures, both under TRIPS and under the GATT itself, for the purposes of pursuing public health. So the way the system works is not as some club to protect pharmaceutical manufacturers. It's a very nuanced set of rules to balance out certain kinds of rights, but with very significant public interest exceptions, which countries can use, for example, in respect of dealing with public health emergencies. And just such litigation may very well come if there isn't a TRIPS exemption that is finally agreed by the membership.
Thank you. Thank you, Acting CJ.
Thank you, Minister. Commissioner Mpofu.
Thank you. Good afternoon.
Good afternoon.
Judge. Yes, I'm just going to ask you, firstly, just to go, well, it's one question, but it has two legs. It might, yes. It's really about some of the criteria and some of the issues and some of the criteria that we apply. And I just wanted to give an opportunity because I think it's unfair for people to raise things, which have not been put to you. I asked an earlier candidate about this, what I called in his case, 3 ostensible disadvantages. And I've seen some commentary which means people don't understand the word ostensible, which means it's what it appears, but I know you do. Those were the fact that that candidate was not a sitting judge, so that doesn't apply to you. The second one was that he had not acted in the Constitutional Court, which applies to you. And the third one was that he was a white male, and you know what that means. So I'm not going to ask you, in the interest of time, about the other 2, because in your case, maybe unfairly, because I know you, and more importantly, I know your parents. I think that the progressive pedigree of where you come from should make the third issue maybe not that important. But I do want to ask you about this question of not having acted, because that is an issue that I'm quite sure will arise when we do our deliberations. If it does arise, I want to give you the opportunity to deal with it now, here and now, to say that despite the fact that you have never acted in the Constitutional Court, you do feel that because of whatever reasons you're going to give us, that issue might not be overlooked, but at least should be weighed against other issues. In other words, it should really be an ostensible disadvantage rather than a real one.
So let me respond to the question asked. I mean, everyone's experience is obviously something that you will all take account of and weigh in the balance. And those who have been fortunate enough to act in the Constitutional Court, that's something that is relevant to what they can bring to bear, and you will take that into account. I haven't been asked to act in the Constitutional Court, and it's not possible for candidates to say, well, I can in some way or another pursue a line which requires that I can tick that box, because that's not how acting appointments work. So it's not within my power to do that. But I do think that there are two things that I would ask you to bear in mind. The first of them is that I have had, I think, reasonably significant appellate experience. And I would say that in respect of 1.5 years in the Supreme Court of Appeal, my time on the Competition Appeal Court, and my time, as we've been discussing at some length, at the appellate body in a very sustained period of office. So I have, I think, fairly significant experience as an appellate judge, understanding how appellate courts work. And the SCA has been a very good experience for me. And many of the kinds of issues that we get, though they're not, that they come a little bit more across the spectrum, perhaps, than all the issues in the Constitutional Court, nevertheless gives one a fairly good vantage point to be able to, I think, act as an appellate judge, even at the apex level. But the second point I would make is just this, that as I briefly sought to sketch at the beginning in some of my introductory remarks, I am relatively confident that I am the only candidate before this body that has actually appeared in the Constitutional Court for a period of some 27 years. Right from the beginning, I have seen every iteration of that court and been involved in some of its very key cases. And I would like you to consider that. I do think that I have a very full understanding and, more importantly, commitment to the court and the flourishing of that court. And I think I have I've been fortunate enough to be able to develop a practice in constitutional law that I think does suit me to the court. So I haven't acted. I would love to have done so. It hasn't come my way. And that, I should say, is certainly not a disqualification. It's simply how you weigh everything in the balance.
Thank you very much, DCJ. Just a quick one for my second question. It's just an idea that I thought only occurred in my head, but fortunately one of the candidates this morning mentioned it, about the need. Okay, let me put it just like as an idea and ask you to comment, that there might not be a need in a country like this, there might not be a need for a court like the SCA. Not because we don't need it, obviously, but maybe because we can't afford it. And most people cannot afford it. And it's something that I even thought I was going to write about. And the idea was that if we could strengthen the appellate capacity of the high courts, and that might involve a whole lot of things, it might well be that we could do away with the need for a litigant having to go to sometimes the magistrate court, the high court, the SCA, and then the constitutional court, because that just makes access to justice almost like not even a pipe dream for certain people. It's not a refined idea, as I said, it's something that was playing in my head, but one of the candidates actually put it boldly that we might have to do that. What do you think of that idea?
Well, I think that it has quite a bit to be said for it, in the sense that we have the present structure that we do because of the original bifurcation between the Constitutional Court as the ultimate decision maker on constitutional issues and the SCA as the final decision maker on all other issues. We now change that structure to make the Constitutional Court the apex court on all matters, and hence its need to be able to be the authoritative voice across the spectrum of legal issues that can come to it. But I do wonder, in a country such as ours, whether we therefore should, for all time, accept this tiered structure, which, you know, certainly works in the federal courts of the United States, but, you know, that is a large and very rich country. I could easily imagine that we might be able to, with certain fairly important rule changes, be able to collapse the Constitutional Court, or rather, let me not say collapse, amalgamate the Constitutional Court and the SCA, and reserve a full panel, as we now have in the Constitutional Court, for certain categories of very important case, but have others which are heard by panels of 5. And that might be a way of rationalizing appellate work with an institutional arrangement that is no less rigorous, but is possibly less costly to litigants and less time consuming. So I haven't, like you, perhaps thought through everything about it, but it's certainly an idea that's worth putting on the table and thinking carefully about.
Thank you, DCJ. Thank you, Justice.
Thank you, Commissioner Mpofu. Before I go to Commissioner Nyambi, can I check commissioners who are virtual, whether there is anyone who has a question or wishes to ask questions?
Yes, Acting Chief Justice Singh Yang.
Yes, Commissioner Singh.
Thank you very much indeed. Good afternoon, Judge Adalta. I'd just like to know, you've been acting on the SCA for some time now, and it's a different kettle of fish than acting and than being a judge at a high court. What can you say about your working with other colleagues there and your sense of team building, etc.? Is there any experience that stands out for you?
Well, I should begin everything by saying that since I've been acting in the Supreme Court of Appeal, we have only been working virtually. And so it's a somewhat unusual experience to meet your colleagues virtually rather than in the courtroom and in chambers. But notwithstanding the constraints of the virtual world as we've come to know it, I have found the SCA to be an enormously collegial place where the panels of judges that are constituted to hear cases work in a very efficient manner with very great helpfulness to each other, and the way in which decisions are made and rendered for the most part in very quick time periods, short time periods, I have found to be an impressive feature of the SCA. So it seems to me to be a court in which a considerable body of work takes place, where there is a very strong work ethic. There is very considerable collegiality as between members of the court in getting on with the work that has to be done. And decisions are rendered pretty quickly. So I have to say it's a court that I've greatly enjoyed serving and which has many, many strengths attached to it.
Thank you. My next question will be with what you said in the end, that decisions are taken very quickly. What do you think about the time frames that the Constitutional Court takes to mete out certain judgments? Now, there are norms and standards for everybody else, but not for them. Somebody suggested this morning, well, 6 months should be a good enough time, but yet we know that there are judgments and findings that are much longer than that. Do you think there should be a particular time frame attached to by when judgment should be delivered in the CC?
Well, I'm peculiarly sensitive to this issue because when I sat and indeed led the appellate body, there is a provision in the relevant treaty which requires 90 days for the rendering of a decision, and that was often not possible to do when matters were extremely large and complex. And so I do understand that one has to adopt a rule which says that judgments must be rendered within both a reasonable time and with an eye to the value that, that justice must be done with expedition. But I think there are two features of the Constitutional Court which do have to be borne in mind. The first is that it is our apex court, that it sometimes gets matters of very considerable gravity and complexity, and it is a large court where by constitutional design the court sits en banc, and that means that there are many opinions to assimilate, and there are institutional complexities as to how it goes about its work and gets its judgments out. But I think there has been criticism that has been offered that not every case that the Constitutional Court decides is of great complexity, and that it should certainly adhere to the general principle, as I'm sure it would recognize, that if not speedy justice, at least outcomes that come within fairly clear time periods is a value that is worth recognizing and respecting. And I have no doubt that we will get a new Chief Justice in the next few months, I'm sure, and that will be one of the things that the Chief Justice will want to think about as to, are there procedures that can be streamlined? Are there ways in which there can be much speedier ways of getting to an answer and then writing the judgments and getting them out in shorter time periods? Almost every institution needs to think through its practices and how it can be more efficient and how it can more effectively serve the public. And that includes the Constitutional Court, and I'm sure that is one of the things, in the light of some of the criticisms that have been offered, that those who are in charge of the court will give careful thought to.
Thank you.
Thank you, Commissioner Singh. I understand Commissioner Breitenbach would like to ask questions.
Thank you, Acting Chief Justice. I'm covered.
Oh, thank you. Then the next one is Commissioner Nyambi.
Thank you, Acting CJ. Afternoon, Judge.
Good afternoon.
My other questions were covered by Commissioner Madonsela and Commissioner Makwanish. I will ask just one question, so that I can be fair to you when doing the deliberations. I don't want to have wrong conclusions. As a judge that is aspiring to join the Constitutional Court, what is it that you consider your weakness?
My weakness?
Yes.
What is my weakness? Sorry, I don't mean to be vain. Everyone has weaknesses. I'm trying to capture something in a way that would be helpful to you while thinking about matters. You know, I think that I come to cases, as I think most judges do, with some sense of where the burden of the argument ultimately lies and where I think the answer lies. I spend time in the hearings that I sit in, testing how good those positions are, and engaging with counsel quite extensively to try to test my own thinking and whether I've missed something and whether I need to revise some of the thinking that I come into a case with. It may be sometimes that is more extensive than is absolutely necessary. But I think, on the other hand, that I remember well as counsel that even if you lost a case, at the end of the day, you do want to have the sense that your arguments have been heard and appreciated. And I have found that those engagements with counsel are often extremely helpful to me in testing myself and testing where the balance of the argument lies. But I would think I, need to make it as efficient as possible.
Do you consider that a weakness?
It could be, yes.
Thank you, Acting Chief Justice.
Thank you, Commissioner. And then I think the next one is Commissioner Motolo Sepu.
Thank you, Acting Chief Justice. Good afternoon, Judge.
Good afternoon.
I think the issue of the WTO took a considerable time, but what I wanted to find out, since we've been in that court or whatever we call it, is there any decisions that were beneficial to South Africa that you know of?
Well, yes, I think there were many. South Africa has not been a litigant in the WTO system. South Africa was very nearly taken to the WTO dispute settlement system in respect of the subsidies that it gives to the auto industry, and Australia engaged South Africa, but that matter ultimately, as far as I know, resolved itself. So South Africa hasn't itself litigated or been a respondent in litigation. It might count itself lucky to have escaped some of that. The reason that I say it's benefited is because the jurisprudence of the appellate body has explained rules that are extremely valuable to all countries, but in certain aspects of WTO law, to developing countries and their interests. So let me, if I may, and I'm sorry this may seem somewhat technical, but let me give you an example where that is true. There is a part of the trade regime which concerns itself with anti-dumping duties, which are ways in which countries protect themselves by placing duties on goods where they believe that they're being dumped in the country. The United States pursued a policy for many, many years of something called zeroing, which was a particular technique for calculating dumping margins. The fact that it did so was extensively used by the United States to keep out, or at least minimize, imports, particularly in respect of steel, and was a critical part of the policy of the steel industry in the United States to protect themselves. Litigation and it was serial litigation before the appellate body, found that zeroing as a technique for the calculation of dumping margins was unlawful under WTO law, and the United States had to stop zeroing. It tried to do it in a whole variety of different ways, and every time it was taken to the appellate body and they got the same answer over and over again. It proved so controversial in the United States that it remains to this day a bone of enormous contention that the United States has against the WTO system at large. But what did it do? Well, it helped, for example, South African steel makers export their goods without that disadvantage to the United States. So that's just one illustration of where the rules and the interpretation of the rules is critical to the way in which developing countries, our own included, where we have exports across a wide array of goods, can either be made or broken by the kinds of ways in which these rules are interpreted and applied.
Okay, thank you for that. I think you touched on the anti-dumping. That's where I was going, because the issue of chicken dumping into South Africa, you read it in the newspapers, and I just wonder, why can't we protect ourselves? Because, that's the second question that I wanted to raise. Is you have been an SC for quite some time.
Yes.
And you have a lot of experience, as they say. I just found now recently that SCs don't take pupils. Why is that? And do you think it's a good thing?
Well, it's an old convention, and whether it should be perpetuated, I'm not so certain. I can tell you what I think the rationale for it is, which is that that pupils coming in to be trained can often best get experience with practitioners, advocates who are not already running very advanced practices. So typically, when you come to the bar and you know very little about how to engage the courts and their procedures and so on, it doesn't always help to be thrown into an extremely complicated matter. So I think the idea was always that training is best done, because that's what pupillage is, by junior counsel whose practices are more varied and might have a greater connection to the entry level at which advocates come in. But I say this subject to one important caveat, which is that it is very important for seniors to open up their practices, not just to juniors, as I've tried to say I did when I was at the bar, but to be able to recognize that there are other ways outside formal pupillage of recognizing those who come to the bar and how mentorship and exposure to practice can help them along, not just in pupillage, but afterwards, because it's like getting a driver's license. Some people would say you only really learn to drive after you've got the license. And so it's a lifelong question. And that's partly why I've spent a great deal of time doing training and advocacy training, which is a great value that the bar brings to what it does and has been hugely helpful to many, many practitioners. So I agree with you that it may not be a hard and fast rule. There might be circumstances in which silks should take pupils, but I can see that by and large, as long as silk's doors are open and they do use their positions to encourage juniors and in turn the juniors' pupils, I think there is enough to go around in terms of sharing experience and engaging in mentorship. I'm not certain in all instances that a silk will always be able to give a pupil the best introduction. Aspects of their practice, yes, but to sit for a year with somebody when a silk is dealing with large and very complex matters may not always be the best way of training people.
Just a follow-up, just little. I think you are getting where I'm trying to get. Because if you're saying you are doing complex matters, this is what we lack training in as women practitioners and black practitioners. So if SILK decides, have a discussion of deciding whom to train and not to train, this is why we are in the state. Don't you think so?
Well, I would suggest this as a way in which this can work sequentially, which is that silks should be very open to appreciating the talent that exists among junior advocates and particularly among black and women advocates who traditionally have been excluded from very important areas of law. And you can see in terms of the flourishing, as I was describing earlier, of so many black and women practitioners at the bar that it's an opportunity issue. And given the opportunity, they can flourish. So that should be the vantage point and outlook that silks have to open their practices to the possibility of the great talent that exists at the bar. The juniors then in turn, if they have pupils, will involve their pupils in that work, and you will not find that people get stereotyped, that their practices end up, only in crime or family law or whatever it is, but that their talents can be recognized in wider areas. So I think we're in basic agreement, which is that openness to people making the determined availability of opportunity is absolutely critical. Training is essential, and simply recognizing that very often we have seen that people have just been systematically denied opportunities to shine, and everybody needs someone to back them and to say, I see your potential and I will give you that chance. And that's what it's all about at the end of the day.
Okay, thank you.
Minister wants to just do a follow-up question. Minister.
Yeah, just a follow-up on that point where you ended, and on the empowerment of black women practitioners. I heard you earlier on, you also mentioned the black advocates that you have empowered and so forth. And on that score, I did not hear you mention any female. Can you mention one female that you empowered, you have worked with and mentored and so forth?
Are these women as a category?
Yes, black women.
Oh, yes, absolutely. Advocate Beloy is one of them. I mean, I've got a long list of them here, but certainly she is one of them who I would put on that list.
CJ.
Thank you.
CJ, just on that one, I know I'm still coming.
Yeah, okay, all right.
No, I hear you saying you've got many of them and you mentioned one. Just mention two.
Let me just look on the list. Excuse me, I'm just trying to, yes, well, Ms. Raja Badlander is another. Yeah, she is black.
Yeah, okay. It is your turn, Commissioner Malema.
No, I just want to ask a quick one. What is the worth of this acting stint in the High Court or even worse in the Constitutional Court? Is it worth considering it when you want to appoint judges?
Well, I do think that experience matters, and how one gains that experience can go by different routes. But I do think that when one overall assesses somebody's experience, to have had experience of a court is one way in which one can reckon on someone's suitability, but it's not a requirement, because we know that some of the leading judges appointed to the Constitutional Court never acted in the Constitutional Court. Certain of them barely acted in the Supreme Court of Appeal.
No, I hear that, but I'm just saying, I know it's not a requirement, but is it worth considering, or is something that we must just overlook and consider any other person? Here's a person who acted in the Constitutional Court, and then here's a person who has not acted in the Constitutional Court, but they are of good quality, both of them. They are very good. The only difference is that this one acted, the other one did not act. Will I be unfair in considering the one who acted in the Constitutional Court over the one who did not act in the Constitutional Court, given the fact that their qualities are of the same? The only difference is that experience of acting in the Constitutional Court.
Yes, I think that would be an extraordinarily mechanistic way of assessing candidates, because it is under the guise of simply looking at experience, you're creating it as a requirement. So you will never find candidates who on every criterion are equal in every way, and the only difference between them is that one has acted and one has not. That's not how candidates ever present, because they have different life experience, different professional experience, and so they have strengths and weaknesses in different areas. But let me give you a concrete example, which may be of assistance practically for the decisions that you've got to take. The Constitutional Court is an apex court that now takes cases across the legal spectrum in every area of the law. You might find somebody who has acted in the Constitutional Court, but their experience is, for example, largely an expertise in public law. And you might say to yourself, well, that's an attribute and it's good and it's useful. But we might be looking, when we think about how to constitute the Constitutional Court, given its expansive jurisdiction, to people who have got experience in some of the areas that have figured and continue to figure increasingly in the Constitutional Court, because that matters. So there is commercial law, there is company law, there is contract law, there is intellectual property law, there is taxation. These are all the things that the Constitutional Court considers, apart from constitutional and administrative law. And so that's why I think, with respect, people you don't just get this sort of, they're equal, but the only difference is this. They have their own trajectory, their own experience, and you have to ultimately think, what does that court need? How are we going to make it the best, most authoritative court that it can be?
Judge, when we say you are equal, we don't talk about your experiences of life. We mean you are both good. Let me put a different question of good people. There it's you, a white male, very good. Here is Ngugai Tobi, an African male, very good. It's not because you've got the same life experiences. You are just good lawyers, and you interviewed so well. You are what we are looking for. But the only difference is that when it comes to the transformation agenda, you do not fit that purpose. Will I be wrong to consider a black male over you?
Well, again, I would, when I talk about experience, I'm not talking about life experience, and you now posit a situation where we're talking about experience and competence as lawyers, which is, I think, the focus of your question. And I would say to you this, that the Constitution clearly requires representativity, and I don't need to refer that. You have it firmly in your mind as to what is required. And that's a consideration that is relevant in thinking about how to constitute the Constitutional Court. It should roughly be representative. So that's one question. But the Constitution also has an idea, which I think is a powerful idea, that we are a diverse country, and we want to harness the strengths of our diversity to a shared end. That's actually our greatest strength. And so it's not ultimately a question of you're in, you're out, because ultimately you are black or you are white. It's a question of saying, given all the talents that we can muster to make this court authoritative and the best court, as I say, it can be, who has got ultimately the best qualities for that purpose? And that's something where we draw on diversity, but we recognize representativity. And that, I'm afraid, is the balancing act. That is your job, not mine. And so again, I would say, you know, those talents need to be harnessed and they need to be applied, and we need to think about this court in the light of that.
Thank you, TCJ. Thank you, Commissioner Malema.
Chair, can I do a quick follow-up?
Yes, Commissioner Klaba.
Just a quick follow-up on the question that Commissioner Malema raised. You have been shortlisted. There are two candidates. I just want to make an example of the two candidates that he's talking about. Shortlisted, and they both have the requisite experience and the qualities. The question is, do you consider the acting stint as an added advantage? I think that was the essence of the question.
Of course, it's an advantage to someone to have acted in the court, undoubtedly. But it's equally an advantage to have acted in the Supreme Court of Appeal. And if I must speak to my own brief, which is what I'm doing here, it is this body must decide, is it advantageous to appoint to the Constitutional Court a lawyer who has served on an international court and led that court, and it is one of the busiest courts in the world. Now, you can say, no, well, that's not an attribute, but acting in the Constitutional Court for 6 months is an attribute. You could come to that conclusion, but I would respectfully suggest to you it would be a very eccentric conclusion to come to.
Thank you. I don't remember that in your CV I picked up anything that tells us why you didn't make yourself available to come to the bench much earlier, maybe 10 years ago.
Yes.
And I asked that question partly because this might have nothing to do with you, but it's like there is pressure that you have to be appointed now. You have to be appointed now. Whereas maybe if you had come to you had made yourself available much earlier, there would not have been that pressure.
Yes.
You would have been before us with maybe 10 years of judicial experience in a South African court, you know, doing the types of cases that when you get to the Concord will be dealing with, you know. So I don't know if you want to say something about why you delayed and made yourself available only after 27 years of practice.
Yes, well, I'm grateful for the inquiry because it was one of the issues that arose last time, and I would very much like to explain. I'd given you some of the dates in respect of what I had done over my time at the bar, and the truth is that there are only so many things that you can do over a career that you have. So I explained that I went to head CALS and the Center for Applied Legal Studies, and then established the Mandela Institute. And that took up some 5 years of my professional life. So that was one thing that I did. I then worked in the WTO in a judicial capacity, and that took up a further 8 years in an appellate capacity. And if you put all of those together, it takes me quite far into the period in which I have been an advocate. So it's not as if I spent 27 years as an advocate at the bar, and then it occurred to me late in the day, well, now maybe is the time to become a judge. I had taken time to do things, be an academic, run CALS, start the Mandela Institute, take up an international position of some importance both for the country and the continent. And that then meant that when I came back, and the judge president of my division will confirm this to you, when I went to see him about the possibility of taking up judicial appointments, he said to me, you need to come and start acting, because it was a rule of the WTO that you couldn't occupy a position in your government, your home government, and judicial acting since were counted as acting for within your government. So I couldn't act. So when I finished at the WTO in 2013 or 14, I had to start getting experience as an acting judge. And as soon as I had clocked up enough experience as an acting judge, I felt confident enough to then come and offer myself in 2017 for a position on the High Court. So I do think that I have spent my time in practice, not only practicing as I did as a silk, but doing a number of things that are relevant to the Constitutional Court and Judicial Office. But I don't think I could practically have made myself available for the High Court any sooner than I did, given when I finished on the appellate body. So unless the JSE takes the view that I should not have sought to represent South Africa, not sought to be a lawyer from this continent who discharged a function in the WTO, I should rather have declined all of that so as to come sooner to a High Court position, well, then that will be your judgment. But I do think that I came to take up, I will make myself available for High Court office as soon as I could, given when I finished at the WTO.
One of the factors.
CJ, can I make a follow-up on that one?
Yes.
Because I'm not sure, and I'm trying to check here on the computer. It looks like when you came for the High Court interview, we asked you if you are not in transit, rushing to somewhere like the Constitutional Court, and you gave us an assurance that no, you are here, you are not in transit and all of that. And all of a sudden, speaking to what the Deputy Chief Justice is trying to speak to, it looks like there is some hurry to go into the Constitutional Court. And this reminds me of, if I'm wrong, then I will accept. But it looks like when you came, some of us had the same reservation that it looks like you are in transit to somewhere higher than where you are actually applying for. Did we have that conversation?
I don't recall being asked if I was in transit, but your memory may well be better than mine. But certainly I came to the High Court to do the job of a High Court judge, and my boss is here with you, so he will tell you if you ask him. Have I served as a High Court judge in every single capacity and requirement without any expectation of preferment in any way? And the answer is yes. I have done exactly what every High Court judge has done. I have been very fortunate that I have been asked to act in the Supreme Court of Appeal, and I've been there for 1.5 years, and I've gained greatly from the experience. The question as to whether, should I be asked to wait or whatever, is obviously something you can bear in mind, but it does rather suggest that this is a question of waiting your time before you can actually assume a position in any court. And I would just say to you that ultimately it's not a question of whether I should be required to wait or anyone else should. It's a question of what does the court need? What's going to be good for the court? What's going to be good for the legal system? What's going to be good for the country? That's the critical question ultimately that you need to ask yourself. And if there are others who can serve better than I, well, then you'll make that decision. But I don't think that the question of whether one is suitable for appointment is a question of wait in line and take your turn when you've given 10 or more years. The question is, what does the court need, and who comes before you that you think will serve that court best? And as we know, and I think it's been said to you on a number of occasions, some of the most distinguished members of the Constitutional Court have had very little experience in the High Court and indeed in the Supreme Court of Appeal. The former Deputy Chief Justice, Justice Moseneke, is one example, and he was one of our most distinguished judges.
One of the factors that we have to consider in making the types of decisions that we have to make is what possible message a certain appointment may send out. Now, in your case, it may well be that one message that could be sent out if you were to be included in the list that goes to the president and the president appoints you may be that it would be that there is a recognition of experience, even experience acquired outside of the shores of South Africa, WTO, and so on. So, in other words, where that experience and that expertise is recognized, an appointment will be made. That might be one message. But is it not possible that another message would be this, that there may be a judge, there may be judges who, let's say, who are in the High Court or who is in the High Court, let's say one, maybe who was in practice as an advocate or as an attorney alongside yourself, who says, 10 years ago, I made a sacrifice and made myself available to serve as a judge, to be appointed as a judge. I wanted to still continue working as an advocate for another 10 years and make 27 years and make money before going to the bench. But I sacrificed all of that in order to render service to the judiciary and to my country. So I've been serving Advocate Unterholter, Judge Unterholter, was making money all these years, and now he comes 2 years, 3 years ago, he comes to the bench, and then the next thing he's parachuted to the highest court. I'm still going through the ranks here. Isn't that another possible message that could be sent out? And then maybe when we try and encourage practitioners to come to the bench, they say, wait, let me finish 27 years, then I'll come. Because I will have made money and I can come and go to the top court within a few years. So I put this to you because, at least as far as I'm concerned, it's important that when we make any decision, we think about what message it could send out.
Yes.
Positive or negative.
Yes. ACJ, I completely understand that, that the notion that, you know, anyone should assume that they can come to the judiciary and sort of leapfrog into the highest court in the land is a message that you would want to think carefully about, but I don't think that that is my position. If I had spent 27 years at the bar simply wanting to pursue a high-flown practice, which was very lucrative, and then come to the bench and say, well, now I expect to be elevated in a very short period of time, I can understand that there would be criticism and there would be questions raised. But that is not my position. I don't see the work that I did on the appellate body as sacrifice. I considered it to be an enormous honor and an enormous privilege. But the fact of the matter is, it wasn't time that I spent taking lucrative briefs in commercial cases. It was service to the country, to the continent, and ultimately to the international community. And that's what I spent 11 years doing. So to the person who came to the bench 10 years ago, I would say, well, I went to the bench 11 years ago. So if you consider that to be sacrificial, which I don't, nevertheless, I'm in a comparably or probably a stronger position than you are. So that's the first thing I would say. And the second thing I would say is that beyond judicial office, when over my 27 years at the bar, as I've sought to illustrate perhaps too often before you, I took time out to do things that were also of public service. The CALS is an institution of very great importance in terms of the issues that it served, the public interest litigation it undertook. You will recall its distinguished role in respect of many human rights issues, and similarly, the establishment of the Mandela Institute. Again, I didn't see it as a sacrifice. I thought it as something enormously worthwhile to do, but that was another 5 years of my professional life. So I'm now at, I'm not doing the maths, but I'm now at 16 or 17 years. And the last thing I would say is that I was not a practitioner at the bar who spent 27 years simply going after the most lucrative commercial cases I could find to amass money. I've set out in my CV, but it's perhaps worth reminding, that I did a very considerable amount of pro bono work. I assisted on the formulation of the Water Act and the complete reformulation of our way of thinking of water as property. I was involved in the first asbestosis case in respect of the unbundling of GenCore, where we got hundreds of millions of rand, which at the time was an enormous sum for the compensation of asbestosis sufferers. I was involved in the negotiations in respect of the export of wine from our country when the negotiations took place with the European Union, all pro bono. I then did many, many cases in diverse areas on private members' bills, on environmental issues, on the nuclear transaction, on the fact that there is now a regime in place that requires the disclosure of monies in respect of political parties. These were all matters done. And I might even lastly remind Councillor Malema that I actually acted for the EFF pro bono in respect of litigation that they did against Ms. Nglakula of the IEC, where the only thing I asked in compensation was a memento of a red beret, and he still hasn't produced it for
Thank you, Judge Unteralter. Thank you very much.
Acting CJ, you forgot about me, but
I'm
I
sorry.
will forgive you, Acting CJ,
No,
because
actually, I didn't even write you down. I'm sorry. Please go ahead.
no, Acting CJ, I'm
Yes.
actually covered.
Oh, you're covered.
But I just wanted to ask, and it's in response to the question you asked.
Okay. Sorry.
It's
Yes.
in response to.
Okay, you can go ahead and ask.
Thank you, Acting CJ. Good afternoon, Justice Unterhalter. In your answer to the CJ about your stint in the appellate body and the panel, can I ask, were you still practicing at that time, or was it just purely in that position?
No, I certainly did manage to do some practice, but it was very residual in comparison to, as I've said, the work that I was doing on the WTO, because we had to be available at all times. And just illustratively, I think I'd mentioned earlier the litigation around the subsidies in respect of Airbus and Boeing, which has only recently been resolved. I mean, these were enormous cases that went on for years and years, and it was a very, very substantial involvement. So yes, I did manage to carry on practicing, but it was residual in comparison to what I was doing in Geneva.
Thank you, Acting CJ. Thank you, Justice Unterhalter.
Thank you. Can I regard Commissioner Schlema's hand as the last hand?
Thank you.
Thank you.
Thank
Yes.
you, ACJ. I think you didn't see me earlier on.
Yes,
but
I'm sorry, I didn't, yeah.
Most of the things that I wanted to ask was already asked, but I should perhaps just declare again for the new commissioners that I know Judge Unterhalter. He was a professor at Wits where I teach. And something that I think you didn't mention enough is the role that you still play in academia. The fact that you still teach and that you've been doing that for quite some time as well. Together with the work that you do in practice and the work that you did at the appellate body of the WTO.
Yes, well, thank you for reminding me. I mentioned it briefly, but perhaps I should just emphasize that ever since I went to the bar and after accepting appointment to the bench, I have taught at firstly Wits and thereafter at UCT, and continue to do so. And I continue to write articles and publish in books and journals to this day. One of my pieces is coming out in the Oxford Handbook on International Trade Law. So I've continued to pursue academic interests, and I have a great respect, as you know, for the academic community. And I do think that some of those interests and inclinations are matters of importance to the Constitutional Court, because the authority and respect with which the court is regarded, in a sense, is appraised very critically by the academic community. And it's a community I know, respect, and understand. And I would hope to do a job in the Constitutional Court which would provide them with good material, but also which would make my contribution to make the court one that academics, whatever their criticisms, are justly proud of, as indeed should all South Africans be.
Thank you.
Thank you. We have come to the end of this interview, Judge Mtorolta. Once again, thank you very much for availing yourself. I should have said when you started, and I should have said to those who, maybe two or so who were before you, I should have apologized that we were running late, and so everyone has had to wait for some time.
Not at all.
I apologize for that, but thank you very much.
Thank you very much.
You are now
indeed.
excused.
Thank you.
Thank you.
Could we perhaps have a 5-minute comfort break?
Yes, that's what I wanted to check. Should it be 5 minutes, or are we not being realistic? It should be 10 minutes. Yeah, let's make it 10 minutes. Okay, all right. Let's take a 10 minutes break. Good afternoon, Judge Valley. Welcome. We are about to start. I think there would be one or two commissioners who will be coming in just now. But let's start. Thank you for availing yourself once again, Judge Valley.
Thank you, CJ.
We have this session because the court has ordered that we should have this interview afresh.
Yes.
And thank you for coming back to make yourself available. I see that you have quite a few degrees behind your name. You have a BCom degree, is that right?
Yes, that's correct.
And a BA degree.
Yes, that's correct.
And an MA degree.
Yes, that's correct, CG.
And an LLM degree.
Correct.
And an LLB degree.
That's correct, CG.
I think some of these are from VETS, is that right?
Yes, all of them are from WITS except the MA.
Except?
The Masters in
Yes.
Sociology, that's from University of Warwick in the UK.
Yes, yes. No, thank you. And you were admitted as an advocate in 1996, is that right?
That's correct, CG.
And you started practicing as such immediately after
Immediately.
that? And you practiced as such up to 2012?
Correct, CG.
And before you were admitted as an advocate, you had worked for Kausa or Sakau,
Yes,
is that
it's
right?
now called Sakau. It was called Kausa in my time.
Yes, yes. How long did you work for the trade union?
I worked for them for a year, full time.
Yes.
And I worked with them after that on a part time, on an on and off basis with them.
Yes, yes. So you were in practice as an advocate for about what, 14, 15 years?
I think it's less than that, 1996
1996 to 2006 would be 10 years.
10 years, 12.
So it can't be less than 14 years.
No, it can't be less than 14.
Yeah.
6. My arithmetic seems to have failed me at this point.
Okay.
And another 6. About
Yeah, I
16
think it's
years, yeah.
Yeah. And then you were appointed as a judge in 2012.
In 2012.
A
I must
judge-
just say that in that period before, while I was still studying, I was a very active member in an organization called IMSA. For
Yes.
those who worked in labor law would know, I was also on the board of trustees of IMSA at one stage. And I did a lot of mediations and arbitrations in that period, but I was still studying to work for my LLB.
Oh, yes. And was that something you were doing part-time?
As soon as I left the sociology department and I started doing IMSA work much more extensively, and I was doing my LLB. More like the LLB was a part-time, I would think. I don't know, no, the LLB was a full-time course, but I'd done an LLM and an LLB at the same time.
Oh.
There was an overlap in the LLM and the LLB. So the LLM came before the LLB.
Yes.
I finished the LLM but did not have an LLB at that stage.
Yes. And then you did the LLB after.
LLB after that.
Yes. Now, would you like to share with the commissioners what the nature of your practice was when you were practicing as an advocate in terms of what types of cases you were involved in?
Well, to begin with, there was a natural flow into labor law. So I could easily do labor law. And I had a lot of people in labor, people I knew in labor law, who would come to me for assistance, particularly from that union and a few others. But of course, there was only so much they could give me because they were also having their own difficulties, but labor law was my initial start. I then moved quite quickly into constitutional law. So you will see from the very early stage, I was involved in pharmaceuticals, which is a major case, new clinics, affordable medicines. I did quite a lot of that sort of work, and some of that work took some time. I became quite involved in work around medicines regulations and medicine and work involving the healthcare. In fact, just to go one step back, I was also chairman of Essential Services Committee at some point. And then when I came to the bar, after a while, the Minister of Health appointed me to the Pricing Committee, which was a committee that was looking into pricings of medicines. So, and that came as a result of my work in the healthcare work, which is the affordable medicines case, the new clinics case, the pharmaceuticals case. They were all quite big cases, and I did many other cases for them that I can't think of offhand right now. So that was that also took a major part of my work. Then I did some work in defamation law at that time. So that was it. I didn't get too much commercial work to my disadvantage, but yes, that was largely a kind of work I was doing. It's been so long since I've been, it's more than 10 years ago. I did do some unlawful competition work, but that was in arbitrations. So I represented parties as part of a team in an arbitration on unlawful competition, not through the competition law, but unlawful competition as part of dealing. So,
would that be the
I think
common
that the
law
spectrum,
competition?
yes, common law competition,
Yeah.
unlawful competition in common law.
Yes. While you were practicing, there were some cases that you did that got reported, is that correct?
Many of them.
Yes. Do you have an idea about how many were reported cases that you
wouldn't
argued?
know it. That I would have, when I applied for Silk, I would have known, because that went into my Silk application about all the cases that, and there were very many in which I was involved. In labor law too, I was involved in some very serious and path-finding cases.
Yes. And then you were appointed to the bench.
Yes, I acted for a term and then I was appointed to the bench.
And you have been on the bench for, is it 9 years now?
Finishing my ninth. I'm 10, if you consider the acting stint, it will be 10 years,
Yes. And during your time as a judge of the High Court, you have also written some reportable judgments that have been reported.
Many.
Yeah.
I can give you a number, I think about 50 or
Yes.
45, I don't know, 40 something, many.
Yes. And you have acted in the Competition Appeal Court.
I did. Correct? That's correct.
And was that from 2016 to 2018?
I would think so. Whatever you're reading must be correct.
Was that at a stretch or different times during that period?
No, 1 year. I got called in only at that point. So it was a full year. Then I applied. I didn't get it. And I think I continued acting. And then I applied again and I got it.
Yes.
So if it's the competition, if I started in 2016 and acting, then I've been in that court since 2016.
Yes. Okay. You have not had a chance to act in the constitutional court, is that correct?
That is correct.
Yes. But have you had decisions that you have made as a judge of the High Court that relate to constitutional matters?
You know, it's hard to say specifically constitutional matters work. I've dealt with all the matters I dealt with, or most of the matters I dealt with, constitutional issues arose in them, and constitutional issues were then dealt with by me. Many of those judgments. There was a law, the Black Eagle was one of them. Silicosis would have possibly be another one because it dealt with a number of constitutional issues, right to health care. Quite a few of them, and I can't off the cuff remember which ones were constitutional directly, but many of them had constitutional angles to them.
Have you ever given a judgment where you have declared some piece of legislation unconstitutional?
No, never.
You have not?
Never.
Have you had a chance of giving a judgment where you have had to invoke reading in or reading down?
Or striking off? You mean one of the remedies, constitutional remedies that have...
Yeah. Have you had that chance?
No, not to read in or read out, but
yes.
I had occasion to interpret certain legislation that might have been, or certain sections that might invoke constitutional values.
Yes.
And so applying section 39(2), for example, if you want to know. Yes, I would have done that.
And if you were appointed as a judge of the Constitutional Court, and the first case you got was one where some litigant applied for direct access, what kind of factors would you take into account in deciding whether direct access should be granted?
It must be exceptional for it to come for direct access. I believe it's necessary for the matter to be sanitized at the earlier courts and at the lower courts, for the lower courts to identify what the real issues are. There must be something very special about it, and it must really be in the interest of justice. In other words, that court must say that whatever wisdom that's to come out of the courts below need not is not necessary at this stage. There must also be some level of urgency to it. I mean, why would you want to come directly if you can get the same justice at the lower court? And if that justice is suitable, then why would you want to even come to the Constitutional Court? No, it's not a court that just should be invoked willy-nilly. It's a court that you must come with matters that have been considered carefully by other judges, that has got some sort of controversy that is worth the attention of a constitutional court before it can come. Now, there's been numerous judgments where the Constitutional Court has said, we can't give you direct access, go to the other courts. There's nothing special about yours. It must be exceptional. If there's no exceptional circumstances, I would not be keen on granting leave to come to that court.
If somebody who had lost in the High Court wanted to come to the Constitutional Court for an appeal directly without going to the Supreme Court of Appeal,
by bypassing the SCA.
What kind of factors would you take?
Again, they must indicate why. What is so special about it that the SCA cannot deal with us appropriately? And we must wait. I mean, we don't know what the High Court or the SCA will say. And if they say something that gives a final answer, then that must be it. You don't have to bring every matter to the Court for determination. The Constitutional Court is a court that deals with only certain and special issues that require the attention, that it's going to probably assist in developing the jurisprudence in some way. I mean, there must be as I say, something exceptional. And there has been numerous cases, I can't think of them off the hand, where leave to appeal for direct access was never granted, and rightfully so. There's no reason why you should bypass these courts, and the Constitutional Court is entitled to benefit from the arguments, the wisdom that comes out of the High Court, High Court and the Supreme Court of Appeals. So I wouldn't grant leave to appeal or grant direct access, leave to appeal directly from the High Court, or just direct access even before you go to the High Court. I wouldn't grant that so easily. There must be something special. And sometimes something special would be it's in the national interest, it might be urgent. And I can understand those sorts of cases, but not just any case for that matter.
Thank you, Judge Valley. Commissioners? Commissioners?
Yes,
if anybody has a question. Commissioner Matonsela?
Yes, good afternoon. Thank you, Acting Chief Justice. And good afternoon, Justice Valley. I'm here somewhere.
His hand is also rising.
Forget about him. Eh?
He says, I must forget about you. But you exist, don't worry. I recognize your existence. Thank you. Commissioner Madonsela?
You have written a judgment in Capitec.
Yes, yes, yes.
And the SCA dealt with it recently.
Yes.
And
it was Justice Unterhalter who overturned it. Yes.
I was just about to say that.
Yes, yes, let's talk about it. Yes, yes, yes. Oh, well, let's go straight to it. Yes.
Yes, yeah, no.
No, there's...
how do you feel about that? And do you think that... I asked this question because I've asked him as well, same question, around the same topic. I know that case because I'm following it.
Sorry,
I know that case is now serving before the Constitutional Court, or is...
It's going to go to the Constitutional Court, yeah. It's been never applied for leave to appeal.
Leave has been sought and papers are still going to be filed. So between you and Judge Unterhalter, somebody's going to get a hiding in the Constitutional Court. But that is not the issue. The issue is, do you think that our current state of the law on contractual interpretation is adequate to cover and regulate commerce between individuals? I'm talking in particular about the Ndumeni principles and all the principles that...
The Ndumeni case.
Ndumeni and the Auckland Park case, which you had the occasion to consider, and the judgment in Baedieka regarding public policy.
Oh, the Bideka case, yes.
So,
and Pridwen is the other one. They came out on the same day.
They came on the same day, yeah. Saying this, more or less the same thing. But I'm saying, are those principles, in your view, sufficient enough to regulate commerce between individuals, or do we need some form of refinement of those principles and a more accurate guidance from the Constitutional Court on that jurisprudence? Or do you think it is quite settled?
Okay. I'm going to try not to give too long an answer, because I can give a very lengthy answer and we can have a seminar on this, and I wish we do.
Please go for the shorter answer.
Thank you. When it comes to the shorter answer, as far as I'm concerned, my judgment is firmly located in the transformational constitutionalism project. Whether theirs is, I leave it to the readers to decide. And it will come before the Constitutional Court, and that issue is going to be arising. It will be one of the most important issues there is. Has the law developed on this issue? It is developing. And one of the issues is there is this conflict, this tension that's taking place between the SCA and the Constitutional Court. And it's been referred to openly in the Bideka judgment and to an extent in Pridwen. In Bideka, Froneman J makes a very strong point. He says that the SCA, some of its comments, are pejorative when they refer to the CC judgments. He also says that the SCA did not interpret one of the CC's judgments, and it's a leading CC judgment called Parkeisen, correctly. And over the years, people followed the SCA's interpretation of Parkeisen, not Parkeisen's own words. And he said, let Parkeisen speak for itself, but not let. So in Bideka, he's quite strong about it. In Bideka, even the majority judgment, which kind of came to the same conclusion.
Which was written by Justice Leon.
The one by Justice Theron. Sorry. that even that judgment took note of some very disparaging comments that have come out from the SCA. So there has been this tension that's gone on for a long time. The problem really lies in the fact that the SCA itself has been grappling over the years with this difficulty. It's a difficulty I capture quite extensively in my Atlantis judgment. Now, I went and I did the research on my own in Atlantis. And I said, I personally adopt a specific view of of contractual law. I don't believe that our law of contract is as fixed as it was, say, 30, 40, 50 years ago. And I believe some of the inroads that were being made, or that was attempted in some of the early cases, you know, in I think it was Bank of something versus Ornelas, Bank of Lisbon.
Lisbon versus
Yeah, Bank of Lisbon versus Ornelas, where the one judge, Jansen J.A., argues for opening up the law of contract, and he's then shut down, and he said, no, you're the minority of one. And then it moves on. But eventually, the SCA then accepts that we're going to move away from this. That's a contract, that's what you sign, you're bound by it, tough luck for you whether it works in your favor or not. Or good luck for you, it works in your favor, and tough luck for you if it doesn't. But for the need for certainty in commerce, you must be bound by it. They didn't follow that principle when it came to Sesven versus Bucas. They said, no, public policy. Bucas signs a contract and he says, I'm an intelligent person, I'm an orthopedic surgeon, I'm handing over my salary every month. They say, ooh, that turns you into a slave. We can't allow this contract to stand. And then they started, and from then onwards, we started saying public policy is the rubric around which we will decide whether a contract is valid or not. And then we applied it later on in other commercial disputes, like, for example, restraints of trade. So contract law is undergoing change. But one of the things that happens is Parkhazen comes up and it says, we need to relook at the situation. We need to introduce concepts like reasonableness and fairness and others. And we need to see how we can bring justice between the parties. It's nothing new. By the time Parkhazen came out, there were cases in England already, and particularly cases in Canada. In Canada, I mean, the Basin versus Hernew judgment is an excellent judgment, but they use the concept good faith. So I apply all of those things. And one of the things that have come out against me in the Unterhalter judgment and the others are wrong. They say, firstly, they said I didn't apply Biedeke. Biedeke wasn't out because the Biedeke I had to apply was the one of Davis J. Secondly, they say I rely on good faith. And good faith is not a self-standing principle. Well, that may be so. I'm willing to listen on that and say we can move away from it. But what the Constitutional Court did say is that public policy will still remain the basis upon which we will determine whether the contract is to be abided by, applied, or whether a clause in that contract should be utilized, enforced, should be enforced. But they said that, and they said it up front. What they do in Biedeke is say, look, we're also waving a white flag to you, Supreme Court of Appeals. We don't need this. It's not in the interest of the judiciary, in the interest of law, that the two of us seem to have this open spat. They don't go down the road that they say.
I thought you said you'd give us a shorter answer.
Thank you so much. And they then tried to synthesize the two systems. But I still believe that my judgment in Capitec is correct. And if you look at the facts in Capitec and the way they interpret those facts, you'd sometimes think we're not talking of the same case. What happened in Capitec, for me, was a serious injustice, just like what happened in Afrox. When a person walks out of a hospital, going in there for a simple operation, coming out with one leg amputated and told, sorry, the indemnity clause covers the hospital, you can get no remedy. And that is that Afrox was decided after Parkhazen. I still feel it was an unfair judgment. I still feel it was an unjust judgment. That's my views. I'm a judge like they are. I put my views up front. They don't agree with me, that's fine.
Except that my recollection is that Afrox was decided in the SCA.
Yes, no, it was in the SCA. And they just said, That's it. And that's one of the judgments that refuse to follow Parkeisen.
I'm so scared to ask you another question. I have no
Yeah.
answers.
Yes, if you can
let's
withdraw it.
just say, look, we disagree about these points. I understand some groups at the bar have had a discussion of my Capitec judgment, but they didn't invite me to come and talk. I was going to give an Atlantis
Let's stop there. Was there a hand this side earlier on?
There was, and I've given up.
You are covered.
That
Oh,
I've covered.
okay, all right. Okay, thank you.
There was a hand
Thank
here.
you. Oh,
Maybe I
Commissioner.
can take yeah.
Okay, then it will be Commissioner Notjetsi after you. Okay.
Thank you, ACJ. Good afternoon, Justice.
Good afternoon, Commissioner.
I'm going to ask you a very
Ndawe.
common.
Yes.
I'm going to ask you a very common question, but unfortunately, this is one of the questions that is not going to go away anytime soon, until gender parity is realized in judiciary. In one of your answers on the questionnaire, you indicated that you constantly advocated for transformation within the advocate profession and participated in numerous activities. Can you share with the Commission as to what are those activities that you participated in? And while you are responding on that, can you also mention one or two of the women advocates that you mentored while you were still an advocate?
Okay, look, fortunately for me, there are some members in this forum who know what I did from the early period. But what I did is, I mean, something I just continued doing from 1976 onwards. I fought very hard in the advocate's profession for change. I was always I never stood behind. I was always in the forefront of the fights. I always put my name forward in those battles. On mentoring women, if you look at some of the judgments, some of the cases I appeared in, I only had women juniors. I can name them. I think Sina Yakub was one of them. Commissioner Pillay was another one of them. Leah Gabashi might have been one of them. I've had as many women juniors as I could. But I also want to say this. There are some excellent women advocates out there. And it's not a situation of, they say this about women and blacks, as if we're sitting there, we are lesser skilled, and we're waiting for somebody to mentor us. Really what the problem is, give them work. Brief them. They'll do it, honestly. They're not someone who's lesser able than than men, or black people are not lesser able than white people. It's a question of opportunity. And that's where we had our fights, and we haven't succeeded because we're still having those fights. So this thing will continue for so long. But let me tell you one other thing that I've never mentioned, and I was reminded of recently, on the gender issue. If you go back to 1983, we were the first union, Kawusa is the only union that managed to win the maternity battle. We won 4 months, 45% wage, and 55% came from unemployment. And 4 months without loss of service. We were the first and only union that managed to get that. And we were constantly fought for that in our union. Our union was led by a woman, and we were very sensitive of that. But that doesn't mean I'm going to bury everything under the carpet. There was a lot of patriarchal practices even within the union. Our men are not necessarily good people when it comes to this question. We must face that fact. So yes, it's a struggle. I've done as much as I could. I could maybe do more. Sometimes you get distracted. Sometimes the battles are around race. Sometimes the battles are around class. But it's an intersectionality between all of those three that one gets involved in. And yes, it's a long way for us to go still. I wish I could have done more.
Yeah, it is a long way indeed, Judge. Thank you so much for your answer. Thank you, ACJ.
Thank you. Then Commissioner Notjetsi.
Thank you, Chief Justice. My question is very short. It's just, I'll make a statement, I just wonder if you agree with it.
I concur.
If you, yeah, yes, if you concur. Factors such as unnecessary postponements of cases.
Can you just repeat that?
Factors such as
unnecessary
postponement of cases. Deciding matters on pure technicalities. Long delayed delivery of judgments. Temperament of a judge who presides in a case. Are issues that should first never be accepted in a constitutional court setup. 2, they constitute a threat to the independence of the judiciary. Because if you go to a judge, delays, does not deliver judgment, you start to panic, and that leads to a temptation to confront those judges, the judges. Do you agree with that statement?
I agree that undue delays, unnecessary postponements, and attempts to allow and or to take technical points in order to avoid having to deal with the real issues are seriously problematic. Most important of all, they undermine the rule of law. That's the more important point. People lose confidence in the rule of law, and that's not what we want. Our constitution makes it quite clear that the rule of law is supreme. So yes, I wouldn't. I believe that those factors are very important, and we must be absolutely conscious of them at all times. Yes. We must remember that there are litigants who need justice. And even if they don't get justice, they need an answer. Yes. Sometimes the answers are not just, like has happened in my view. This is my personal view in Afrox. Okay. They need an answer.
Okay. My last question. Have you ever been, at any stage, been either accused of or consider yourself guilty of being a judge that was not tolerant to those who appear before you? Your temper. I mean, have you ever been accused of those things, that you are a judge that easily lose it when conducting proceeding? Or are you aware of those things? And if you are, how have you sorted out if it did happen? That's my last question.
Okay. There was a comment, it was raised last time by one of the commissioners. There was a comment in the GCB comments. It was one that has been refuted by other advocates but was never put before this body. There was a comment that was rude to senior counsel, but I was never given details about it. And to date, I've never been given details about it. I've said that at times, I don't know if I come across rude, but particularly with certain types of senior counsel, I tell you, honestly, when you sit there, they sometimes talk down at you. They really don't respect you. I don't know why, but some of them do. You have to sometimes put a firm hand on your court. And if you don't, situations can get out of control, not only for you, but for the other side and for everybody else, you know. So you have to at times do so. So being firm is not necessarily being rude. I haven't got any complaints, but I can't say I was never firm.
Thank you, Judge Raleigh. Commissioner Mpofu.
Thank you very much, TCJ. Good evening.
Good evening, Commissioner Mpofu.
Yes, thank you. Yes, I think we are both tempted to call each other by first names. Yeah. So we'll resist that temptation. I just have one question, TCJ, and it is about, it's related to this issue about judges and counsel, but from a transformation point of view. You and I have been in that battle zone for such a long time.
Together, yes.
Yeah, you come from the days of Black Advocates Forum.
Yes.
Before it was even AFT.
Yes.
Now, and I know how passionate you are about this question of briefing patterns. What has been your experience sitting on the other side of the fence, as it were, with watching all the big commercial cases being run by particularly white advocates? And if the former CJ is to be believed, in the Constitutional Court, the situation is the same or worse of the kinds of counsel who appear before them. Do you think there's something that the judiciary can do using its muscle to complement the long fight that you know around briefing patterns?
You know, as a judge, I certainly can't do what I was doing as an advocate. And so I presume that's going to be applicable to all judges. I accept it's applicable to all judges. We can only nudge them and say, but why have you been doing this situation? A good example is competition law. I did not even do one competition law case in my life, not one. I'm now regarded as a very senior judge in that court. I am taken very seriously in that court. Ask anybody who appears in the competition appeal court, they'll tell you that.
I am that person and I agree.
And that is to show, I mean, there are so, in the competition field, with the exception of the Competition Commission, parties are not very amenable to bringing, you know, counsel from black, from counsel that are black or counsel that are women. Juniors, yes, they bring them in as juniors, but we've had that fight as advocates. You would second junior, third junior, we don't pay for the third junior. We've tried all those things out over the years. What we're talking since early 2000s, 96. So yes, there is a serious problem and it continues. And it continues in the big firms. And you also find this problem. Some of those firms have at the higher levels changed in color and even maybe in gender, but not necessarily the practices. Now, it's not nice to say those things, but those are some of the observations I have seen. How can a judge help in that? I don't know. What we can do, you know, and I hate this because it's always a case of can we train them? Can we bring them in? Can we give them advice? It's as if they just need training. They don't just need training, they need work. If you give someone work, that's training. He'll train on the job. You know how anxious I was when I first did labor law. I one stage read every single case there was on dismissals for operational requirements. When one of my seniors, whose name was Advocate Moirane, came to my chambers, we were doing new clicks. He said, what is all these files? And I said, no, it's for operational requirements, you know, he said. He says, what do you need them for? I said, no, just, you know, I had idle hands, so let me cover a specific area of law and see if I can have my skills ready in that area of law. You can't keep training somebody until you give them the work. Give them the work and let him apply that knowledge. Get him to work hard on it. He'll not necessarily, or she'll not necessarily be able to charge for all the hours they do, but get them the work and you will see. That's when the training takes place. That's when someone is being enhanced and advanced.
Thank you, Tisha.
Thank you, Commissioner Mpofu. Deputy President Betzer.
Thank you, Acting Chief Justice. Good evening, Justice.
Good evening.
I've got just one question to you. Of the judgments that were reviewed by the GCB
yes,
and taken on appeal to the SCA, about 45% of your judgments were overturned by the SCA. Would you wish to respond to that,
45.
or would you just be dismissive of
No,
what
I wouldn't
happened
be
at the
dismissive.
SA and say that
No,
you still
I
believe
would-
you were right and the SA was wrong?
No, I don't think that's right. No. If I were ever to take that attitude, then I need to be hit on the head. That's arrogance, that's lack of humility. And I think there are times when I was wrong, and in the heat of the moment when I made that decision, I missed the point. It does happen, it will happen in my court, it's an extremely busy court. But the more important point is this 45%. Look, I don't know how many of my judgments were taken. I don't know how many of my judgments where leave to appeal was applied for and not given. In other words, the SCA refused leave to appeal. So I don't know which judgments they're talking of. I don't know what that statistic is. I really don't, but I refuse to accept that that is a fair reflection of the quality of my work or even the level of disagreement between me and the SCA. I don't think that figure accurately captures the level of disagreement between myself and the SCA or the amount of error on my part that the SCA managed to find. Do you know Justice Nugent had a famous one? When he was in the Supreme Court of Appeals, he used to always assume that, oh, we have these cases, we're overturning these people, as if the Supreme Court of Appeals was always right. But when he was starting to be overturned at the CC, at the Constitutional Court, he then said once in a talk to us, he says, the appeal court is not more right, it's more binding. Let me tell you what Justice Haram says. I meet him in there was the House of Lords. All of them came here to this country, and I was lucky enough to visit that place. And I went up to him and I told him that I don't agree with Breed and Come. I was still an advocate, and I said, it's a problem with Breed and Come's analysis. And then he gave a talk, and you know what he said? He said, we've been overturned by the Constitutional Court, but the case they brought to before us was not the case they took to the Constitutional Court. So when you're on the other side, you see things are, and the SCA must also accept that some of the things said to them are not the things that were brought before us, and there was suddenly a change in their case. And so there's difficult, and I am very conscious of that when I sit in three-bench appeals, and when they start saying things about the judge that sat in the first court, and say, that judge missed this point or missed that point. I'm very conscious that you don't just go about disparaging that judge. I want to know, what did you do or say there? And it happens a lot in the competition appeal court, where they constantly make those comments about the tribunal.
I'm satisfied, Justice
Thank you.
Val. I think
Thank
in the
you.
interest of time, we must leave it at that.
Thank you.
Thank you.
Thank you.
Thank you, Acting Chief Justice.
Thank you. Judge Valley, you said, if I understood you correctly, there were many reported judgments that you wrote as a judge. I was trying to look at your questionnaire. Did I hear you correctly, or did I misunderstand?
I don't get the question.
I'm saying that I understood you to be saying earlier you have written many reported judgments as a judge.
Where's my
so
CV?
I'm just having a look at your questionnaire. Maybe there is something I don't understand.
Okay, there's a list of judgments, Judge.
If you go to page 13, as paginated page 13 of your...
don't have it. Is this it?
Of your... But I think it would have been page 8 of the questionnaire.
This is Judge Unterhalter's.
Oh, did he leave it there?
Put that aside.
Where's yours? Where's yours?
Okay.
Is it yours?
Sentence the wrong person, Acting Chief Justice.
Commissioner Singh.
List of judgments. Yes.
Commissioner
I would like to ask a question a little later.
Acting Chief Justice, I think it's page 21.
Okay, I'm sorry. Just hang on one sec, Judge Valley. Commissioner Singh, I'm sorry. You were saying something I didn't hear.
I would like to ask a question a little later, Acting Chief.
Yes. Okay. No. Thank you.
Thank
okay.
you.
All right. What page, Judge Valley?
There's a list of judgments.
Yeah, you see there, page 21, it says reportable judgments 55.
Yes.
Now, reportable is one thing.
And
It
reported
means you
is
have marked
another.
it reportable because you
Correct.
consider that it should be reported.
Correct.
But reported
Is
is
another
something
thing.
different.
That's correct. That's absolutely correct.
When you are saying many, when you talk about reportable,
Well,
as
if you
opposed
look
to
at that
reported.
same list, I don't know, I didn't do this. Firstly, this is outdated. It's now about 140 something, 150, 145 or 147. But if you look
You
at
mean-
that,
you
this
mean-
was prepared by my registrar, not me.
Yeah, but
And if you look at citation,
but would that be an excuse, Judge
No,
Vavi?
no, it's not an
Because would he not
excuse.
give it to you to approve first before you
No,
send
no,
it to
no,
us?
No, that wasn't an excuse and that was not an attempt to evade the question.
Yes,
The question is the difference between reportable and reported.
yes,
That's what the question really is.
yes.
And the question really goes to the heart as to whether I misrepresent to this body, whether negligently or deliberately.
We are not there
or the
yet.
number.
We are not there yet. I'm still trying to understand. So I'm saying when you said there are many, were you talking about those that are reportable, or were you talking about those that have been reported?
Many of my judgments were reported. How many exactly, I can't tell you, but numerous. And if you look under citation, they give you this where it's been reported. So if you look at each of the column, it says there, case, date, parties, reportable, and then it says citation. And it gives you some of the citations.
Yes.
And then how many of them now, I can't give it to you off the hand.
See,
I
what-
will obviously have to sit in.
What,
But I'll accept whatever you say about how few they are.
No, I only want to make sure what I understood is what you wanted us to understand. So that's the only thing I want.
Yes.
Because I was looking at page 13, paginated page 13, under question 16. It says, the questionnaire there says, list the cases where you have written the judgment, not more than 10, which you regard as being the most significant, and why. You are not there yet? Page 13, paginated
Yes.
13.
Is it
Can you see that
paragraph
question?
16?
Yes, yes.
Paragraph 16.
And then you have got
4.
You have got 4
Yes.
cases. Out of those 4, only 2 are reported in what I understand to be the official law reports. And then in question 16.2, the next question says, which of these cases has been reported? And then the answer is all of the above.
Okay.
So I would have thought that if there are many, those that you regard as significant wouldn't be 4, because most of the reported judgments one would think are important, but sometimes I know it's not like that.
Okay, I think
So I just want to make sure that I understood you correctly, and what you were telling me is what I understand.
I think ACJ, first point, this is only the one application. There's an application before this. There are 2 posts. There's one post that only some of us have applied for. And that application got 10 judgments that have been annexed to them. It's not here, I don't know why. This is the second application in which you only got four of the judgments. So that in total you would have had 14 judgments before you right now. Secondly, let's deal with the question of all of the above. And there your argument, there your concern, Acting Chief Justice, is that the only issue is, the only judgments that can really be regarded as reported are those which says 222 all SA or 224 all SA. That's correct. But those judgments, Hermione and Nell, is in the South African law reports as far as I know. And it's an important judgment about contracts and interpretation of contracts. And I also applied the role of good faith there. Then the Transnet IGS consulting was about corruption and about, if I recall, it was about setting aside a tender or something, I can't remember. And that too was reported. Where and when, I don't know. I leave that to my registrar to do all of those things. And she's excellent. I'll have to check out what there is, but I do have many reported judgments. That there is no doubt. I wouldn't be misrepresenting to this body. I have no reason to misrepresent to this body.
Okay, no. I just wanted to make sure I understood you correctly.
Thank you.
It looks like there are no further.
Now, as a follow-up,
yes,
DCJ, Judge
Yes,
Bali,
CJ.
when you come to an interview of this magnitude, one of the things you would expect is that you're going to be asked about reported judgment.
Yes.
And therefore, it can't be an acceptable excuse that we're now told about someone else who prepared, because in your preparation for this interview, you would have refreshed your memory about how many are reported judgments, because it's going to be a bone of contention when we go into deliberations that we were unable to give us how many factually, backed by whatever submission that is required from you to submit before this body, that these are reported judgments. So I'm worried that when you leave here, I don't have a clear answer as to what are the reported judgment, even if it's an estimate, and then we can go and deliberate about that.
Thank you, Commissioner Malema, for that, for giving me an opportunity to clarify this issue. I certainly don't know exactly how many were reported, and I'm sorry I didn't check that out before I came here. I do apologize to this body for not checking that fact out. I have written there reportable, and I've also written there the number of citations. I've given that. I did not count the numbers. I'm so sorry about that. But I can safely say, without fear of contradiction, that the number is well into the tens. It's way above 20, 30, 40. It's in that ranges. There's a lot of reported judgments that I have given. I've listed all of the judgments I've got there. And I have not, and I have no interest in exaggerating. I honestly don't have an interest in exaggerating the amount of reported judgments. There's no value for me to exaggerate something of that nature. And I do apologize to you if it is going to make your deliberations somewhat more difficult because you don't have that answer. I'm sorry for it. Thank you, Mr. Malema.
Just the last question. Did you say there was another application you made, though you made two applications and some of the reported cases are in another one?
No. Yeah, no. There's two applications that this body is considering two vacancies. There are two applications in those two vacancies. The one was done in October 1919 or something, 1919. 2019. I think it was done in 2019. The interviews were set down for March 2020. Then we all know COVID hit. It was extended to October 2020. Then that didn't take place. But then adverts went out in October 2020 for the second vacancy. And then that's this application. Then we know what happened after that interview process, and the court has told us to come back here, which we are. And there's been another advert for two vacancies. And so there's another application as well, a more recent one. What I'm saying to you now, to answer you directly, Acting Chief Justice, is today you should have had two applications before you. There were two. I don't know why you've only got one. Because you're considering two positions, and not all of the candidates have applied for both.
Okay, thank you.
Thank you.
Judge Wali. I think we have come to the end.
Acting Chief Justice.
I'm sorry. Commissioner Singh, I'm sorry. I'm terribly sorry. I forgot about you. Please
No,
go
thank you,
ahead.
sir.
Yes.
Thank you, sir. Good evening, Judge Valley.
Good evening, Commissioner Singh.
I've come across a news article, which I think it'll only be fair for you to respond to. And if I may read it, it's not very long. The heading is, Judge made a material error in inverted commas, relying on non-existent documented controversial 14 billion rand contract case. And it's a newspaper, City Press. It says at the center of the predicament is Judge Bashir Valley's reliance on a confirmatory affidavit, which he said was deposed by Eskom former group legal head Bartlett Hugh. The affidavit never submitted as part of the court roll because it allegedly never existed. This fact is confirmed in an admission made by Eskom attorney Aslam Musaji when he confronted a text message by Hugh regarding Valley's alleged inclusion of evidence he did not submit. I think it'll only be fair, because this is a public news report, Judge Valley, that you be given an opportunity to respond to these allegations.
Thank you, Commissioner Singh. Okay, that's a recent judgment I gave in which Eskom sets aside, asked to set aside what was a contract of 8 billion rand on the grounds that the contract was irregularly obtained. The issue that newspaper article, which I've not read but I know about because it was sent as a questionnaire to my registrar who brought it to my attention. The issue raises on this very minute point, and that is that Eskom board took a decision that they will not procure certain types of fuel oil from intermediaries, because that only adds to the cost. They would rather buy that fuel oil directly from the supplier. In other words, they would go directly to BP or to Cecil, but they would not want to give it to get an intermediary to go and buy it from Cecil, put up a markup and do this. So that's a resolution Eskom board is supposed to have taken. There's a controversy now in the case. Did Eskom board take this resolution or not? It's a very minute part of the case. The case is long. It's been included in my third bundle of cases. In that case, one of the employees, the most senior employee, that is a Mr. Who's the CEO of Eskom? De Ruyter. Mr. De Ruyter. Mr. De Ruyter puts in a main affidavit. And in that main affidavit, he says there has been this decision taken by the board. He's not able to put up the board resolution. I then criticized that in my judgment, saying that's non-compliance with the Companies Act. He then says why and how they took that resolution. One other gentleman, Mr. Shitangano, was at the board meeting. This particular gentleman, Mr. Hewu, was also supposed to have been at the board meeting. They gave me papers of about 2,000 pages that constituted 2,000 pages, and both those gentlemen gave confirmatory affidavits, except Mr. Chitangano went a bit further. He just didn't give a confirmatory affidavit. He went further. He said, and I did this. The other gentleman didn't say all those details, but as far as I know, and I tried to look for those documents, I don't have them anymore. They've been given away. He gave a confirmatory affidavit. But here's the thing, even if I was wrong that there was no confirmatory affidavit, it doesn't change the finding of fact, because that finding of fact was based on numerous other issues. It was based on numerous other evidence. And then lastly, that finding of fact was also one small aspect of the entire case. The case is about how that contract was given to this organization, I think it's called Econ Oil, how it was given to it, contra the principles set out in the Procurement Act and the regulations in the Procurement Act, contra the policies of Eskom. Then came a third aspect of that case. Was there really a contract or not? And there came the question of whether the formalities of whether a contract was entered into were actually complied with, whether they did meet those formalities. So this issue is a really, really minor issue, and I think it's blown way out of proportion. But I accept your point. It's in a newspaper. It cannot be taken seriously. They have applied for leave to appeal to the SCA. If they get leave to appeal, it will be dealt with there. I'm confident that the judgment won't be overturned, but I could be wrong. And it's important to be confident. It doesn't necessarily mean confidence is the same as being right. I'm confident, but I'll accept that there is a chance that the SCA will find against me and reinstate that contract. I set aside the contract. I said, firstly, there's no contract, but I set aside the whole process that they went about in this, giving this 8 billion rand contract to this company, which it shouldn't have been done in the circumstances it does. That company may deserve that contract, I don't deny that. But the circumstances in which they did it was, I said, wrong. So Commissioner Singh, I can't see you.
No, but he hears you. I'm sure he hears you.
I don't know if that answers your question.
I can hear you, ACJ, if I may just follow up. You see, the thing is...
Chief Justice, may I just caution against what is taking place at the moment? If the article was not really put to the candidate beforehand, I think it may very well be unfair to press on this line of questioning. I want directions and counseling from you.
Commissioner Singh, you hear the concern from Commissioner Madonsela that...
yes, ACJ, I hear the concern. It's an article I only came across today because it's a 15th of September article, but I'll leave it at that. I'll make up my own mind about how I interpret what Judge Valley has said. Thank you.
Please go and read the judgment as well, Commissioner Singh. It's unfair for you to make a decision on a newspaper article, Commissioner Singh.
Okay.
I mean, read the judgment.
We are done. Thank you very much, Judge Valley. We have come to the end of the interview.
Thank you so much.
We are sorry that we made you wait.
Thank you, Chief Justice.
We are running late, but you are now excused. Thank you very much.
Thank you, Acting Chief Justice, and I wish you all the best in the rest of your endeavors.
Thank you. I understand that the practice is that when we finish with one court, then there would be deliberations. But I know we are left with 2 candidates. Do you prefer that we deliberate now, or do you prefer that we do the other candidates and deliberate for everything? We deliberate now. Okay. All right. Okay. Let's deliberate. Who must? Oh yes, please. Yeah, the media and who else needs to?
All of them.
Everyone who's not in the commission.
Oh, okay. well, for 5 minutes. Okay. But it's better if we don't get out of here if possible.
Yes.
When we're done with deliberations, then my task is
and the voting.
Yeah, and the voting.
Yeah. Then we'll join for the. Okay, no, that's fine.